An ex parte order granted to the baby daddy. They go to serve Kelsey Fitzsimmons, the new mother. She ends up shot in the chest. Now she's on trial. Day two. Let's go. Good morning, beautiful humans. Happy Tuesday and welcome to Defense Diaries. I am your host, Bob Mata, and this is day two of the Kelsey Fitzsimmons bench trial. As you guys can see, if this is a new experience for you, bench trials go quicker, right? They're much faster than jury trials. There's less things that have to be done mechanically speaking, so they can kind of speed it along. Fascinating day yesterday. Fascinating day. I had a long drive back from Southern Illinois, and boy, I had great company listening to Judge Erskine and my beautiful and brilliant co-host, who will be joining imminently. Just great insight. I loved having Judge Erskine on. It was incredible to have a judge, especially from Massachusetts, who just is incredibly bright, knows the law. Just to get that judicial insight is invaluable, especially during a bench trial. I mean, couldn't ask for anything better than that. And I just thought it was excellent. I was listening more than watching, so I didn't see a lot of the video that they were showing, but I thought it was a really interesting day. I thought that I agree with both Allie and the judge that on direct, Noonan was relatively credible. I didn't find anything not to be overtly incredulous about what he was saying, but you got to wait for cross. I mean, if a witness doesn't sound credible on direct, you've got problems, right? So you would expect that it was a tight story coming in. We'll see how he stands up on cross today. It's going to be interesting. The other interesting thing is I thought Allie's insight into whether or not bench was the right choice here was something that was really interesting to think about. Because she's right that concept. I mean, remember, judges are in this country, they're either appointed or they're elected. I've come to learn over all the coverage of Massachusetts cases that y'all out there, they're appointed for life, which is stunning and terrifying. But y- you know, eh, much like a prosecutor, you have to kind of look at the politics of judging, right? You hope that never plays a part in a judge's decision, but the threat of a massive lawsuit by Kelsey when this thing is done, if she's acquitted, is a very, very real possibility. So, in terms of that thing where Allie was talking about, is the judge going to try to find a happy medium wherein he's not flat out calling Noonan a liar and he's not flat out calling Kelsey a liar, but he's just leaning strictly into reasonable doubt? How does that look for a lawsuit? So I don't know. It's all fascinating. I've been trying to think of what I'd like to see from the defense in terms of witnesses. Frankly, I would like to see some type of gun expert come on and give some insight as to whether or not there's any way to know whether a round was chambered, whether or not the trigger was actually pulled. Like, those are all just things that I think would be really helpful in terms of evidence that may help all of us, but most importantly, the judge figure out what really happened in that room. So I'm here for it. I don't know about y'all. Let me pull it up. They're not going to be starting right at 9. I don't assume. Probably. What did it come on? Like 9:15 yesterday? 9:30. Woo! You were on Boston 10, you said? Yeah. All right. I'll pull it up. Oh, you guys crushed it. Crushed it on the grift yesterday. I was really proud of you. I was really proud of Allie. I never go the 50, and she just, she always, stretches it. All right, there's some movement. But you guys did great. Who won that thing anyway? Who won the wheel? I wasn't watching. I was dropping somebody off the airport at that point. All right, let's see here. Get this guy up. Some weirdness on the screen right now. Looks like caution tape. I don't know what the hell is going on. You guys, maybe you can figure out what's happening here. Because I don't know. I don't know what it is. So I don't know. What is that? I mean, I don't know what it is. Is it the center line of a road? Is it caution tape and we just can't read the wording? Is it? I don't know. I have no idea. I don't know. I just don't know. So what do you guys think? What do you guys think? Yeah, maybe the parking lot in the court. I don't know. DB says the first down line. First down. Polly says that, Bob, is a yellow line. Indeed it is. Indeed it is. Astute. I always tell people. Whoa. You see him coming in firing? Come on, man. Come on. Don't you know? Haven't you heard the good news? We got us a quarterback. Look, see, now there's a man in his legs walking around. I don't know. But this is the court or something relating to the court. See, I feel like I see wording when it's not blurred. It's blurred. It seems, I don't know. I think it might be caution tape, which is weird. So let's see, Montana. I'd like to know the angle of entry of Kelsey's wound. Yes, that would be helpful to know. That would tell if she was full on facing him like he said, or at an oblique like she said. True. I would like to see that as well. I mean, every bit of evidence and give us some context and context clues, I think, is helpful. I mean, I don't know who or what they'll call or introduce on the defense. I mean, Kelsey's going to testify. There's no question about that, right? I mean, Bradl said as much during his opening. So she's got to testify, just like we knew that Noonan was going to have to. It's he said, she said, So it's we'll get to hear both stories, and we'll get to hear them both crossed. That's where we really test it on cross-examination. So hopefully Bradl's got. Well, let me ask, what did you guys think of some of the crosses yesterday? I thought there was more that could have been asked of Justin specifically. I mean, even though what he knows of that, moment in time is little to nothing other than roughly when the shots were fired. Beyond, oh, wow. What a delight. A wonderful, wonderful gal. Look at that. Wow. Delicious. Let's see. Did you have the boost? Were you using the boost yesterday?
Yes.
Now, in the car, I heard the witness fine. I struggled a little bit to hear the lawyers, depending. But I heard the witnesses fine. So let's see here. Dog, and thank you very much, Montana. We appreciate your generosity. And Dog Grooming Danny says, got to listen to Garcia on the way to my first appointment this morning. Enthralling as always, drove right past my exit. Hey, yeah, that was yeah, I thought it was a pretty good episode. It's episode 71. If you've never listened to my podcast, not YouTube, I consider this to be video podcasting. I consider podcasting to be audio only. And that's just straight up storytelling. It's like an audio book. And my podcasts, unlike 99% of them out there, are very, 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 very deep dives. Gacy is 33 plus 3 episodes. And Garcia, as it sits right now, with trial having just started in that case and on that pod, is in episode 71. So it's a deep dive. It's a really deep dive. I'm really trying to give people a real behind the scenes, behind the curtain look of what it's like to defend a death penalty case in this country. And that case was insane. So I do what we do. I get into all of it and try to teach a bit in terms of educating you guys to enhance your court watching and true crime obsession, because I think if you understand how the process works, I think it adds a lot. So 70, 71. Yeah, I'd love to get new, like Runkle. I got to get him on, talk about the guns. Dude knows guns. He's coming to my neck of the woods. I think he said in June. He might have to come into Chicago twice. I've told him, of course, he has a place to stay with Allie and I. So we might have a little Runklecation over here. So, which I'm looking forward to, because he hit me up. He's like, he was asking about the end of May. He's like, man, what is going on in Chicago at the end of May? I looked it up, like some kind of weird hot dog festival, but there was nothing like big, like no Formula One thing, no huge like Lala's later, Lollapalooza. The marathon is later, like all the kind of like big events where people travel in. Chicago's just a great town. And when it gets nice out, people come because it's a beautiful, beautiful city. I mean, architecturally speaking, with the river winding its way through downtown, it's a gorgeous city and it's immaculate. It's really immaculately kept. So yeah, but I told Ronks, I'm like, we got you, man. Come stay with the Matas and we'll play board games. I too love board games. I mean, Runkle's a gamer. Don't have any doubts about that. My man loves the game. I love the game. Gaming's awesome. This coffee's awesome. I needed it. So yeah, I was gone. I spent the weekend down in Marion, Illinois, working on season 2 of Murder on Songbird Road. Lauren flew in. I picked her up at the airport. We made the drive, did a prison visit on Friday with Julie Beverly, and then got down to Marion, interviewed a bunch of people. Was running around. It was interesting. It was interesting. I couldn't get the guy that I'm dying to interview. Like he's very slippery, and his sister's a real gatekeeper. I don't know why this guy won't talk. I'm just trying to ask a few questions, man. It's always weird to me if somebody possibly has information about a case that could potentially save somebody's life and they elect not to talk about it. It's sus. It's just how I look at it. It's sus. So I'm not going to name any names. I have a feeling these folks may not even have internet, so I don't know. I don't know. I don't know. I don't know. That was a frustrating part of it. That was a frustrating like that part. There were two parts of it that were very frustrating. So, you know, what are you gonna do? Oh yeah. What's up, baby? There
Morning.
she is, my beautiful and brilliant co-host. What's up, girl?
Hey, babe. Hey, all.
I missed you so much when I was gone.
I know I missed you too. I'm
I
so
don't think you
glad.
did. You got to have that like glorious Saturday of granddaughter and the magic of the zoo.
I know.
Like you
But I
did a
did
good
miss you. I
job
really
kind of
missed you
explaining
there
that.
because I know that how much you would have loved it.
Oh
Not
God.
the trapped animals, but your
No, I
granddaughter at
know.
the
I
zoo.
know. I know what you're saying. Like the joy and wonder
Yes.
that you see on her face is like
Oh my God, it was too
I
much.
watched all the little videos you guys sent me. She's just the cutest, most adorable kid. She's such a doll. She's just so, and her little voice, the whole thing, the little walk, all of it. And, it was, it looked like I missed out big time.
Blessed
Absolutely.
Texas Lolly. Did Runkle have some insight that made Noonan's story make even less sense? Is what I'm assuming. I'll have to go back and
I
and
saw Runkle's Runkle tweeted, I don't know if it was, I think it was yesterday, probably during the trial. Yeah, he's got insights. Anything that involves weapons, guns, Runkle's got insights. He's just very, very knowledgeable about the way that guns work
and of course the law.
and the
I mean,
law.
he doesn't have any trouble applying, you know, US law. Canada law must not be that different. Plus, he's been doing this long enough to know the
Oh
differences.
yeah, yeah.
But
I mean, there
Canadian,
are some distinct
yeah,
differences in
no, for
Canadian
sure.
law.
Yeah, I've had a combo with him.
I mean, they essentially don't have, you know, Fourth
A
Amendment
fourth, I
issues
was just
up
gonna say
there.
a Fourth Amendment.
Yeah, I mean, but like they don't like is a general proposition. He said that they do not suppress evidence. You know, they
Wow.
do some things that I think affect the weight of the evidence, but they don't really suppress evidence up there. It's different. It's a different system. Because like last time we had Runkle on, that like I always want to dig into that. I always want to know the differences in the legal systems because it's fascinating to me.
Yeah.
It's fascinating.
Bob also had some points when we were talking yesterday. You were taking notice of Noonan's words that he claims he spoke
Mhm.
immediately after, runs up to Kelsey and says, "Breathe. You have a baby to live for." And Bob's like, so is that what he says to someone because she just tried to unalive herself? So the first statement is you had a baby to live for? I was like, yeah, that's a good point.
Well, yeah, I mean, it doesn't make sense in the context that he shot her. You know what I mean? I know I just shot you,
But
but
live.
live because you have a baby to live for. That doesn't make any sense.
Yeah. Yeah.
So, but like, and we had an interesting conversation, and you're like, I was kind of afraid to say it on the live, but I don't think you need to, because it was interesting to have Lauren Bright Pachenko, who's my co-host on Murder on Songbird Road. She knew nothing about the case at all. So we're watching you guys. I was listening, she was watching and listening, and she like
Wait, you're driving?
I was driving. I was
And
just
you're watching and listening, and she's just listening.
no, she was watching and listening.
Oh,
I was just
okay.
no, I like
I thought you spilled secrets there. I know Lauren does not like you messing with your phone while
no,
you're driving.
no. So out of respect, I have no problem. I'll just watch full TV shows, movies while driving. You know, when I
No.
have a guest in the car, I try to be
Prank
a little
caller,
more
prank caller.
considerate. Um, but at any rate, so she knew nothing about it. She's diving into Reddit. Like, so she found all the text messages between Kelsey and Justin. So she was digging in, and
Yes, doggy.
her thought on the statement of what was said, whether it was,
Don't do it.
yeah, Kelsey, don't do it, Or what was the other?
No, Kelsey, no, I thought. I don't
Yeah,
know.
there were a couple of variations. See, to me,
In opening, he claimed no one else said these words, but in opening,
Bradl did, right?
right. No. The state claimed, Kelsey, don't do it. Kelsey, don't do it. Put the gun down. But I don't think oh God, the dog. He's all right. I'll be back.
What was he doing? So to me, when you hear somebody saying, Kelsey, don't do it, to me, that seems more like somebody telling somebody not to do something to themselves in the heat of the moment. And Lauren agreed. Like she thought that when that came out, that's what was heard. That she thought that was indicative of somebody threatening to kill themselves more than him saying, "Don't point the weapon at me." Because I think if you're pointing, drop your weapon would typically be what a cop would say, right? Drop your weapon. Drop your weapon. So I mean, that's just where I'm at with it. But I'm really anxious to see the cross. I want to see what Bradl can do with it. But I mean, the reality is if anybody's expecting Noonan to crumble on the stand and change his story, that's not happening. So it's got to be more artful than that. There's got to be questions that expose inconsistencies, because that's the best you're going to do with a witness that has a story that's going to stick to their story. Is you have to expose those cracks, those fissures. And yeah, I cannot figure out what the hell we're looking at on that screen. It's getting worse. No, there's a cord, maybe. I don't know what it is. Some weird body part or a bun. Like a hot cross bun, or maybe it was somebody's finger, their elbow. I don't know what we're looking at. So I have sent another invite to Judge Erskine, and she's just brilliant. She's just brilliant. I mean, truly, I thought that her insight was just amazing. And she echoed a lot of the things that I had kind of been saying leading into it, especially with respect to how this whole thing played out, with respect to Justin going in and getting the restraining order, ex parte, not giving her notice. It has all the earmarks of a strategic custody move more than genuine concern, especially because there is nothing in the affidavit or in the statement of facts in that petition that would indicate any abuse, any harm that had ever befallen the baby at the hands of Kelsey. So, I mean, that part of it just doesn't add up, So for me, I just thought that, like, to me, this is a helicopter grandma who they took advantage of the Jack and Jill bachelor party situation. Oh, this is the banister. Well done. Well done. That's exactly what it is. So that's either the bar of the court or the banister for the jury box, right? Yeah. Camera's obviously facing down. All right. I thought it was hilarious. Well, I have to say, I thought my wife was hilarious when he was running and falling. I mean, you guys are all hip to the limpies. Now you know. Like, Allison's been on the limpy movement for 7-8 years. And her logic behind it is rock solid. Absolutely rock solid. Everything she said, it makes way more sense than the P word. Because really, what is more useless than a limpy? I mean, our family has adopted it completely, and that's what we employ over at this house. You know, if somebody's being a real wimp, scaredy cat, you know, not stepping up, they're a limpy over here. That's the way we do it. So, you know, I'm all about it. I often promote that out publicly. You know, if it comes up in conversation for some reason, I'm big on it. I think that it's you know, it's another way to chip away at the patriarchy. You know, it really is, and you got to just keep chipping away at the old patriarchy, and that's a real low key, under the radar way to do it, that people don't even realize it's getting. Yeah, I thought Allie was phenomenal yesterday. I did. You know, I'm biased. Obviously, I'm biased, but in terms of knowledge of the law, and entertainment value, she's my favorite. But you know, of course, she is. She's great, but like she's so critical of herself, you know, and I'm like, you're ridiculous. You were awesome. You were awesome. So I just, you know, because she's just really, really knowledgeable about the law. Like her and Andrea on the same screen are a lot to handle in your brain in terms of like their legal knowledge. And it's
You're so
always
sweet, babe.
Oh, I didn't know you were there.
I am now.
I was trying to talk about you when you weren't here.
I was listening with my phone while I was dealing with the dog. I think I asked yesterday, but I forgot to look at the comments. Does anyone have any sort of like dog TV thing that they think works? Because what he's watching right now, no, it's
That
like
dude needs a walk.
I
You think
took him
that
for
guy
a walk
wants to sit there and
yesterday.
watch dogs wandering around out in the outdoors? Like he's like, my God, are they trying to torture me? Is that what they're doing? Is this some kind of weird torture thing that they're putting on this? There's dogs out in the woods, just frolicking, having the time of their lives, and I'm stuck here in this house.
You
I
sure
hate
your
it.
shit's live, right?
Huh?
Your
Oh yeah,
TV. Yeah, okay.
yeah, it's live. It is live.
Oh my God, he's back. What is going on there?
I just told you this is not a mystery. There is no mystery involved with yeah, but cats are different. We've got a very, very active dog. Like we do not have a dog that likes to lounge about and just a lazy guy. This dude is like, he looks like a part horse, part greyhound, part deer. He's a very, very active guy, and he needs exercise. Otherwise, he falls into a deep, deep depression. Ugh.
All right, I think somebody said, "Can we recap?" Yeah, my lord, recap yesterday. I think what we should do is, wow.
Wow,
Okay,
this guy.
is ask people. What, ah, damn it! I'll be.
The guy. Wow, the guy. He ain't having it. He ain't having it. He's not. He's not for the no walk. I really need to get him out for a walk. I mean, that's facts. I mean, he's like, when I leave town, I have to get my people to like swear on lives that they're going to walk the dog because I am the walk the dog guy. And I'm not talking about a letter that gives up my entire game. I'm talking about like physically walking my dog because he needs it, because it makes him happy. You know, he like, see, our problem is we don't have the invisible fence, and you're not allowed to have fencing where we live unless you have a pool. So, you know, it's really, I've got to bring him out. So I either bring him to the dog park I try to bring them places where I can have them off leash. All right, enough of that. So, yeah, I mean, yesterday, in terms of, I don't have the witness list in front of me, but I think they had Daly was the first witness who was a cop witness. He was the guy who was at the police station. They got the RO that they had to serve, and I believe that there was some kind of in-person conversation there briefly with Justin and his sister. And at some point, he heads over to the house, to Kelsey's house, and he's got a couple of cops with him. And the thing that I could not agree with the ladies more about is the concept of having Justin at that house when they're coming to take her baby, and he's the reason it's happening, is insane. Insane. And worse than that, they let her know he was there. Talk about a recipe for disaster. That was it. You know, I mean, that's I was not surprised at all when Judge Erskine said in her 20 plus years on the bench that she had never, and having dealt with ROs a whole bunch and their service, and just talking about the potential nightmare scenario of that becoming a lethal situation when you're talking about removal of a child from a parent. It is unthinkable that these cops would have thought that that was a good idea.
Yeah.
And I don't care who it is. I don't care if it's a social, anybody but that dude and his sister being in that house when they're coming to take the baby is better. Anybody, even if it was just a cop taking the car seat, bringing the baby to the police station, say, hey, we've got the baby, come get the baby, whatever.
Right.
That thing, the way that went down, and she knew, like, she was aware that he was in the house.
Yeah. I think there's a couple things too. One was they tried to sneak in through Daly, that Noonan right afterwards said he said what happened, and he said she tried to shoot me. And they tried to get it in because that's hearsay. It said outside of court to be offered for the truth of the matter asserted. And so they tried to get it in under an excited utterance, which requires, like, you're still under the stress. Usually it's like you're seeing some sort of physical manifestation. Somebody's still crying. Somebody's still visibly shaken, something like that. And the underlying point being, in these circumstances, the way that this person was and what they endured, they had no time to make something up. No
Right.
time to make something up. And this judge, I thought, did a really good analysis. He's like, look, some of these factors lean very heavily into what the rule says, to let it in as an excited utterance.
Yeah.
But at the end of the day, I cannot find that he did not have time for reflective thought to make up a lie. And, and that's a huge a huge win. But I thought, now I see this judge's logic, the way he thinks, the way he applies the law.
Yeah.
And that's gonna that I'm sure is the type of thing that Bradl's aware that this judge is like, the way he thinks, the way he applies the law, to lean towards saying, all right, we're gonna do a bench trial.
Yeah, no, I thought you were spot on with that. I thought that, because it gives you a mind's eye view of what's going on in that judge's head, how he operates. I felt that way having watched 2 hearings with him. You know what I mean? Like, it was after the hearings where I felt way more secure, because I just felt like he was an even-handed broker, like an honest broker. Like, I thought that he applied the law as it was supposed to be applied, which is all you can ask. All we ever ask for from a judge on the bench is just be fair, apply
Right.
the law, no matter which way. And you know, and I thought what I would have liked to hear you say with the excited utterance kind of objection in that debate that went on, that legal argument, was that we had a perfect example of an excited utterance when he's claiming that Kelsey said, or when he says, Kelsey, no, don't do it. That's an excited utterance. There's no time
Right.
for that person to lie in that moment, because that is the epitome of what an excited utterance was. But nobody brought it up. Not you guys, but nobody in the court. I'm like, here's what an excited utterance is in terms of what he's saying that Kelsey said, or what he said to Kelsey. And, you know, this other thing where he's got time and he realizes, oh my God, I just put her down. I don't know
Right.
if she's going to live or die. I
Right.
got to cover my ass. There's plenty of time there. You know, I mean,
Right.
especially cops, they know. Maybe and I think that you have to factor that in. You know, you're dealing with a trained officer who's been on the force for a long time. I don't know if he's ever had to deal with, like, you know, showing whether or not it was a good shooting or not, but they know the routine. So that is not something wherein they're not going to realize immediately, okay, I gotta, like, I may have screwed up here. Like,
Right.
I gotta make this thing right. I gotta change a fact or two in order to swing this thing in my favor. So he's going to be thinking that immediately,
Right.
you
The
know.
other thing telling about what he did testify to is Kelsey's statement of, "Sorry, I want to unalive. I want." I mean, that's her basically saying sorry she tried to unalive herself.
Yeah.
Give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts and this most honorable court. Court is now open. Please be seated.
Good morning, Your Honor.
Good morning.
March 24th, 2026. Courtroom 2, Lawrence Superior Court. The Honorable Justice Jeff Karp presiding. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, docket 2025, 77 CR 311, scheduled today for continued jury waive trial. Could counsel please identify themselves for the record?
Good morning, James.
Good morning. Good morning.
What's happening? All right. I don't know what happened to Bob, but here we go. Here we go.
Do some last minute research on the motion for a view. And wanted to talk to you folks about
Oopsies.
paper 88 is the defendant's motion for view. And I guess at this point, is the defense still seeking a view?
Judge, we haven't had any progress on the other end of it. Excuse me. At this point, I am satisfied with your discretion. If you would like a view, we'll do it. I did file a motion. If you feel that at the close of the evidence you would like a view, we'll make it happen.
Okay, well, let me just tell you my present thinking. So, and I think some of this you're implying, so I don't think I'm patronizing you by any means. But so I was told at Sidebar yesterday that Ms. Fitzsimmons no longer owns the home, and it belongs to a it is now owned by a third party. So has the defense been in communication with the current owner?
Not the owners themselves, some representatives, Your Honor, and just honestly kind of getting a little bit of passive resistance about it.
Okay. All right. So just to point out, and this is why I was running late, I was trying to remember, there was a case from a couple decades ago, I think, Commonwealth versus Mattis, which goes through the procedure under circumstances where none of the parties have, a party seeks access to someone's home for purposes of a view, and essentially my memory is, but just a quick look this morning, is that it's kind of a Rule 17 circumstance where the homeowner would need to be summoned, given an opportunity to be heard about whether we could go in there. This issue a lot of times doesn't come up because a lot of times the Commonwealth has either the scene is a public place or the Commonwealth has had the ability to I guess to reach out to the owners and make that work. But the Commonwealth is not seeking a view. They have the burden of proof. And I guess my position at this point is neutral. I would, if the defense wants a view and you're able to set it up in a timely manner, Commonwealth, if the defense was able to set up the view, in other words, reach out and do the legwork that the Commonwealth usually does, is the Commonwealth opposed to it? Okay. Will the Commonwealth and your resources help us? Okay. Thank you. So we have, so I'm just going to leave it to you, Mr. Bradl. I just don't want a last minute decision because we need to, Mr. Ruane especially needs to make plans for transportation, et cetera. So I just don't, it seems to me that as for whether I need it or not, I think it's not my place to say. I know I did, in fairness to both sides, I did say that yesterday. And after thinking about it, I don't think it's my place to say. The Commonwealth has the burden. The defense has due process rights, as well as many other constitutional rights. And I'm open to accommodating a view. Okay, just let Mr. Ruane know sooner than later.
Very good.
Okay.
And we wouldn't, I can just tell you now that we don't want to, force these people to do it. We don't want to get into a thing with it, but.
I can tell you this from my perspective. Here I am talking again out of both sides of my mouth, which from my perspective, it arguably is less helpful where the items in the bedroom or the layout and even like the bed and all that aren't the same. And I can get a sense that this is a pretty narrow stairwell, et cetera. But in any event, I'll leave it to you folks. That's you folks are better at doing your jobs than I am.
So we'll take one more. We'll reach out one more time, see where it goes, and we'll advise the court by the end of the day.
Okay, no problem at all. And other than that, I think we left off with Officer Noonan. I'm sorry, were you going to say something? For him. Okay, all right, that's fine. So we left off near the end of direct examination of Officer Noonan. He can be recalled.
Near the end, I thought they finished.
Yeah, I didn't catch the last like 10 minutes of Corr yesterday, so I
told you to listen, naughty.
I mean, I fell asleep.
So, yeah.
Wow, this guy. I have to admit, in my mind, Noonan was like a 30-year-old cop. So when I saw him get on, I'm like, holy shit, it's
Good morning.
All set, Mr. Gubitosi?
Thank you. Sir, I just had a couple more questions for you.
Of course.
The firearm that you used on the 30th, what happened to it after you left the residence?
So I secured the scene, and then once more officers showed up, they relieved me, and the chief had me walk with him to his car, and he took my firearm and he gave me his.
You talked about Kelsey Fitzsimmons. Do you see her in the courtroom today?
I do.
Can you point to her and describe an article of clothing that she's wearing?
She's wearing a sweater.
May the record reflect she has identified the defendant.
He.
Yes, it may.
Thank you. I have nothing else.
Okay. Cross-examination.
Thanks for that wall, cameraman.
Only wall.
This guy.
Only judges panels.
Wow. Just trying to make us
May I
all
inquire?
dizzy.
Yes, please. Thank you. Good
Do
morning.
you have it
sir.
boosted?
Morning.
Before we get into the case,
Sounds good for me.
I'm looking at your glasses.
Mhm.
Are those glasses AI recording type glasses?
No,
Okay, so you're not recording anything right now?
absolutely not.
Where'd Bradl come up
Let's
with
go
that?
to,
I don't know.
June 30th.
Somebody put that
at
shit in his
Kelsey
head.
Fitzsimmons' house. What time did you get there?
Some goofball emailed him.
I think
Hey, I think those are
right
recording
around
glasses.
6.
Those are meta glasses.
6 o'clock.
The upshot of that visit was that when you got there, you didn't secure the firearm.
I mean, look right there. I
All
guess
right, let's move on. He's
all
not
right, I could see
recording
why
this.
he thought it maybe. You know, they're kind of thick on the
I
side there.
guarantee you somebody
Convinced him.
like,
Yeah.
hey man, I think those might be like, come on. Let's,
All right.
Did you?
what
No,
benefit
we didn't.
is that to him?
And you
None.
collectively, meaning the three of you, you brought the guy getting the restraining order to the person he claims he's in fear of, correct?
I wasn't aware that Justin was en route. That was Lieutenant Daly when he made arrangements with Justin.
So you're
I-
saying that was, sorry, finish your answer.
Justin Ayala.
That was your, that was not your part of this incident?
No, it wasn't.
Okay, and you're saying that, oh, sorry.
Excuse me one moment.
What's happening?
The judge wants him to take the glasses off so he can.
He's like,
Now that you mentioned it, those do look like meta glasses. Would you pass those up, sir? What you were pointing at, you're just seeing the temple through his lens. It's.
I'm just
I mean,
saying.
now
they're-
it would be interesting if he was wearing them during the shooting and they were meta glasses. All right, pass those over, sir.
I want the.
They look
jury box
exactly
again.
like meta glasses.
So I just want to have the gentleman move. Sorry about that, sir.
They're shifting.
We'll
people.
make room for you.
I mean, they look exactly like meta glasses. It's
What do you know
bizarre.
about meta glasses?
I just pulled them up. It's that thick thing on the side,
Oh,
on
yeah.
both sides.
It's like those Bose sunglasses with the speakers that you got me.
So
All right. See,
when did you become aware that Justin Elaine was coming to the house?
I wasn't aware.
Did you see him at all when you were there?
No.
You were aware that he came in and was walking around the house?
No.
You were not?
No.
You go upstairs with Kelsey and with Officer Houston, correct?
Yep.
Officer Houston leaves to see who's coming in downstairs?
There was an older woman that was causing a scene with Lieutenant Daly, and
The question was, did Houston go downstairs?
he did, to mitigate what was going on downstairs, is what my belief was.
And you were with Kelsey when she was, she had gone into her bedroom, correct?
Yes.
Then you went down the stairs to see what was going on.
No,
You took some steps down the stairs, didn't you?
I did not.
Your testimony is that you stayed on that landing?
Yes.
Okay. Isn't it true you left Kelsey alone in that room for a period of time?
No.
you had to have. How'd she get the
You're
gun?
serving an order on someone who's your colleague, correct?
Correct.
It's fair to say that this restraining order service isn't exactly going by the book, is it?
And from my past experience, it is.
Well, the guns are floating around out there.
Actually, Kelsey had stated the guns were downstairs in the basement in the safe.
I didn't ask you what she stated, did I?
Right.
Continue.
Thank you.
Continue.
So The guns are still floating around. You're serving a colleague. The guy comes to the house who's got the order. It's fair to say this isn't exactly a garden variety service of a restraining order, is it?
That's inaccurate.
That's
It's
enough.
inaccurate?
Yes.
Okay. And this is just another day for you?
No, it's not.
So in fact, you were working, right?
Yes.
You get a call from Houston.
Yes.
Tells you
Houston,
what
we
the
have a
plan is,
problem.
correct?
Yes, he said that,
I didn't ask you what he said.
okay.
He told you what the plan is, correct?
No. He asked me to meet up with him.
He told you that Kelsey's ex-fiancé got a restraining order and that you had to serve it, get her firearms, and get the baby, didn't he?
Not on the phone, no.
And you said to Houston on the phone, whatever he said to you, your answer was, sounds good. Right.
No,
That's not what you said.
I don't remember what I said to him.
Okay. Well, that's what you told the grand jury, isn't it?
Objection.
Why?
Overall,
Right.
Misstating what he told the grand jury.
Okay, then that'll
you
get
can restate during redirect.
exactly.
We'll get to, okay, we'll circle back
And
on
I
all
prefer
this.
that both sides show a witness what they're referring to when they're trying to.
I will,
impeach
Your
it. Thank you.
I want to ask you some questions about your relationship with Kelsey.
Sure.
You said that you didn't know her well,
That's correct.
and you said that she was on maternity leave most of the time. Is that right?
Yeah, that's correct.
Most of what time?
And you also said that you got along well with her, right?
For the time, I think we went to 1 or 2 calls together. Other than that, I worked a completely different shift. So
So is
we
it
got
yes or
along
no?
when we went to calls. Yes.
Did you get along well with her or not?
Yeah.
And did you think well of her?
I really didn't have an opinion. I didn't have a chance to really get to know her.
Well, do you know Maureen Teresi, your neighbor?
Maureen Teresi.
You gave her your opinion of Kelsey, didn't you?
Mm.
I don't remember.
You called her a whack job, didn't you?
I don't recall.
I'm sorry, Mr. Bradl, I missed the question. Can you state
Sure.
it again?
So I asked him if he knew Miss Maureen Teresi, his neighbor,
Okay.
and I said that he gave his opinion of Kelsey to his neighbor, and that he called her a whack job. And then you can answer again, sir. What was your answer?
I don't recall.
You don't recall?
I don't.
Is it possible you called her a whack job to your neighbor?
It's possible.
So that's what you really think about Kelsey, isn't it? That she's a whack job.
After she tried to kill me.
And at the time, you went in there loaded for bear, didn't you?
No.
Well, let's see. You told the state police that the job was to section her, didn't you?
It was spoken about that if she reacts badly during the restraining order, she may have to get sectioned.
Well, that's what you said, that you had pre-planned that you were going to section her.
It wasn't
The job was to
pre-planned.
section her, isn't that what you said?
No, that's inaccurate.
So-
Hold on one second. Let me just go through some ground rules. You need to wait until the question is complete, because we can't have two folks talking over one another.
Yes, sir.
All right, thanks very much. Go ahead, Mr. Bradl.
And also you raised quite a lot of concern.
All right, I'm just gonna say, here's my issue. Like,
All right, be quick because this is getting good.
all right, it's just that, all of this information about how they were overreacting and they're planning on sectioning her and is undercut, in my opinion, by the fact that she tried to unalive herself, which shows that people's concerns maybe still overstated, but there was some basis for them because she was so far gone, she tried to unalive herself. So,
Yeah, we'll dig into that because it's interesting. Yeah,
all right, I'm blooping back. Don't worry, people.
people get worried. I get
Not-
worried. I'm very worried.
That's inaccurate.
So-
Hold on one second. Let me just go through some ground rules. You need to wait until the question is complete, because we can't have two folks talking over one another.
Yes, sir.
All right, thanks very much. Go ahead, Mr. Bradl.
And also you raised quite a lot of concerns about where Kelsey parked her car, correct?
Yes.
And you suggested at one point that you could box her in and take her into custody with respect to the car, right?
Yes.
So you were thinking that she was going to need to be sectioned, that she was a whack job, and that she needed to be boxed in and placed into custody, right? I'm asking about a state of mind, remember?
So the form, it's compound.
Overruled.
Those are all things that were in your mindset, weren't they?
No.
Well, you said them, right?
No, that's inaccurate.
Sectioning her,
It was brought up by my lieutenant that she may have to be sectioned
and you told the state police that part of the job was to section her.
if she were to be sectioned.
You didn't say that part to the state police, did you?
I don't recall.
Okay, well, we'll go over all this, don't worry.
Okay.
And so, with respect to
Hi,
the
Bradl.
car, you testified in such a manner that you're suggesting that there was some suspicion attached to that, right?
Can you rephrase?
Yeah, you're suspicious of the fact that she parked the car 150 yards away, you said.
Yes.
Why?
So your mindset is that she's evading something or she's up to something?
Yeah, what?
Well, my training and experience,
Mhm.
the distance of where she parked her car from her house and having a baby, and also her behavior in the past where her car was always parked in the driveway, was,
So you didn't know her very well.
Yeah.
I knew where she lived.
And you
I
pay the,
patrol the town, so I have to drive by her house.
So she parks in the school next to her house.
Yes.
What are you thinking she's
dude, I'm sorry, people. Who in the hell pays attention to someone who they barely know where they park? I knew where she lived. You knew where she lived. You barely know her. And not only that, you often drove by and paid attention to where she parked. I find this extremely bizarre testimony. And I do think that it's worthwhile. It shows his mental state that he finds where she parked her car highly suspicious. Bump, bump. If you know, you know.
going to do?
I don't know. I don't know what her mindset was.
Oh, you think you did though?
So you're speculating about any suspicion that's attached to that parking job, right?
I was just suspicious about that.
So she's in the house. You
Yes.
know she's in the house.
No, I don't.
You go to the house. You knock on the door. Daly knocks on the door. She comes out like a regular mom,
Yes.
holding the baby, wearing sweats,
Just a regular
hair's
mom.
probably in a ponytail, opens the door,
Yes.
right?
What
So at that point, do you let go of your suspicions about where she parked the car?
I was still curious as to why she parked her car over 150 yards away.
Wow.
Well, you're looking at it through your own lens as an investigator. Isn't it possible that there's 100 other possibilities in her life that maybe she parked there for some other reason?
Could be. I don't know. Again, I don't know what her mindset was.
So you go in there and you are the only officer who has tactical gloves on when you go in there, correct?
They're neoprene gloves. Yes.
So you're ready for anything, right?
It's past practice with me after working in Lawrence for so long. I tend to glove up for sanitary reasons. I knew we were going to have to handle her firearms, so I didn't want to get any of my prints or anything on them.
Mm.
But you said you took them off fairly quickly when you got in there.
Yes.
So,
And
mhm.
at what point did you take them off?
Right before she handed me the baby.
So you hadn't yet touched the firearms and you took them off. So that plan about not getting your prints on the firearms
Exactly.
didn't pan out, did it?
I didn't want to hold the baby with those gloves. They're pretty dirty.
And
Kai
while we're
said it.
talking about holding the baby, it's fair to say that Kelsey Fitzsimmons, with 3 cops standing there, had her baby, and she's the one that chose to give it to you. Isn't
Yes.
that right? You didn't ask for it. Daly didn't order her to give it to you. She, with whatever her mindset was, chose you to take her baby. Isn't that right?
That's correct.
And she chose you to take a bottle and feed her baby, right?
That's correct.
That's because she knew you the best from all those times that you drove past her house.
And then this is 5 minutes before you say she tries to murder you, right?
That's correct.
Okay. Now, you said that you felt that the baby couldn't be comfortable because you had your vest on. So it wasn't comfortable and you wanted to give the baby off to someone else, right?
That's correct.
A fair statement?
Yes.
Okay. Well, that's not what you said prior, is it?
Well, I like to have my hands free as well. I don't like my hands tied up.
That's what you said the last time, right? That when you spoke with the state police, that you didn't like having anything in your hands, and it was really a tactical reason why you gave the baby up, right?
No, it wasn't a tactical. I just didn't want to be holding the baby.
Isn't it tactical that you want to have your hands free to deal with anything you have to deal with at this?
I want to have my hands free on every call.
What's wrong with the word tactical? Why isn't that tactical?
It is
Can you rephrase
tactical.
that?
What's wrong with the word tactical?
There's nothing wrong with that.
So why doesn't it apply? Because I said it?
I'm sure it could apply.
I'll strike that, Your Honor. Why doesn't it apply?
I'm sure it could apply. Sure.
So for tactical reasons, you gave up the baby, but that's not what you said here at this trial, is it?
I don't recall what you, can you rephrase that?
Well, here at the trial, you said that the baby couldn't have been comfortable and you wanted to give the baby off, right?
Yeah, that's correct.
And you didn't say anything about wanting to keep your hands free for tactical reasons, right?
It wasn't asked.
You were asked what happened
You said it.
repeatedly, and you had every opportunity to talk about it, didn't you?
He offered it.
And you left it out.
Not on purpose.
We'll see.
We'll see. Oh, Bradl. Oh, getting his digs in.
See, if that was in front of the jury,
Sorry, Your Honor, motion is struck.
See, the judge was like, come on, Bradl. Go ahead, babe. What were you going to say?
well, the judge did exactly. If that was in front of a jury, he probably would have read them the riot act with those kind of extraneous comments. That's the kind of shit you and I pull all the time. Little
Hey,
pigs.
hey, hey. Yeah, I'm not.
Like real quick, why is he concerned about wearing gloves and fingerprint? We're not processing a crime scene.
Right.
We're serving a restraining order. That's sus to me. It's
It
weird.
is sus. And I'm wondering what the real, like, because Bradl seems to have some suspicion around the gloves, and I'm missing what it is. And his answer, like you said, is bizarre. Like, I didn't want to get my
Weird.
fingerprints on her gun. You're taking a cop's gun into possession. I mean, look, for all I know, it very well could be standard operating procedure that if you're going to handle somebody's guns, you wear gloves. But again, he took them off before he handled the freaking guns. But Bradl seems to have something in his mind about it. And then
Well, was he the only cop out of the three wearing gloves? Because they're all theoretically any.
I
of them
don't
could have
remember.
collected
I don't
weapons.
remember. But yesterday he offered on his own. Nobody asked him. He offered on his own. She gave me the baby, but my shit's uncomfortable. I got this, I got that. I couldn't really cradle him. Now he's just like, I not want to hold that baby. And yeah, of course he wanted, you need to be, prepared to use your guns on this dangerous person who you think is going to pull a weapon on somebody at any given time, which is what his mindset was due to Justin. So,
Yeah. Right.
all right.
Mr. Bradl, comment like that isn't helpful, please.
Sorry, Your Honor, motion is struck.
Striking yourself.
You're moving to strike your own comment?
I am.
It's allowed. And that's very
Gentlemanly of you.
forthright of you.
Right.
Just a moment.
Yep, take your time.
I hope there's more, Bradl.
He better not be done.
Oh, no.
No way.
Oh, no.
Oh no.
Oh,
no. Oh no.
Oh, no.
Yeah, they haven't even gotten to the shooting yet.
Yeah, he's maybe thinking of something else. Maybe she wanted to tell him something. Okay. Phew. He's just gearing up for part two, round two.
I would have fallen off the ball if he was done.
It would have been like,
I asked you something about your grand jury testimony that we alluded to.
there we go.
So your testimony here was that you didn't get the whole plan from Officer Houston on the phone, right?
Yeah, that's correct.
And my suggestion that your answer about the thing in sort of a matter-of-fact way was, okay, sounds good. And you disagree that you said that, right?
I don't disagree. I just don't recall.
You don't recall?
Yeah, what I said.
So isn't it true that you were asked, page 36. Who did you get a call from? Officer Houston. And what was that call about? Was the next question. And your answer was, he had asked me if Lieutenant Daly reached out to me. I said no. Officer Houston said, hey, can you meet me at the CCC, which is a little grade school behind the Atkinson School. He said, we have to serve papers to Officer Kelsey. I said, okay, sounds good. And I drove over to that location and met up with him, right? And
Sure.
You knew those papers were a restraining order for Kelsey to give up the baby, give up her guns, lose her job, brought by her fiance, right?
I had no idea what was entailed in the restraining order at that time.
At what point did you learn the job here?
As far as the restraining order,
As far as this job you were going to do at Kelsey's house?
what job?
The restraining order service, taking the baby, finding the guns,
When I met up with
sectioning her,
Officer
boxing her in,
When I
putting
met
her
up
into
with Officer
custody.
Houston.
Don't talk when I'm talking, sir.
Woo-wee.
Box.
Hold
Sorry.
on. Let's not argue back and forth and just ask your questions. If you just wait to answer until he's done. If you can restate, thank you.
Sure. So you asked me what the job was. So my suggestion is that the job is serving the restraining order, going to get the baby, finding the guns. You thought about boxing her in and taking her into custody. You thought about sectioning her. That job.
When I met up with Officer Houston behind the CCC.
And at that point, you knew what you were getting into, right?
After he explained what was going on, and we were pretty shocked.
In all of the statements you've made prior to being here yesterday and today, you've never said that you were pretty shocked about anything, have you?
I don't recall.
You weren't shocked. You were treating this like a video game, weren't you?
No.
Well,
Not a
your
helpful
first
question.
answer is, sounds good, like it's any other day, right?
As to meeting up with him behind the CCC. Yep, sounds good. I'll see you there.
Sounds good to meet up, okay.
Sound good?
Let's talk
Yeah, that
about
one queued
the
up.
bedroom and the shots that you fired.
All right, here we go. Maybe he watched.
Here in
Uncle
court, you said
Demo.
that those shots were in rapid fire.
Rapid succession. Yes. Okay.
Where was
and-
her arm?
Like a boom, boom.
Yes.
No, that's not what you said to the state police, though, is it?
Ooh.
That was 8 months ago, right around there. I don't recall. I said I shot twice, possibly.
You told the state police that you pulled the trigger. This is 1232 in audio. You told the police that you pulled the trigger once. You said the word once. And then you said, I kept giving commands. And then you said, I pulled the trigger again. That's a completely different scenario than 2 shots in rapid succession, isn't it?
As far as the time frame, I was trying to be.
Mm-hmm.
I was trying to recall
Mm-hmm.
the event
What now?
as best as possible.
Mm.
But rapid succession, you pull a trigger, Pull it again. Yes, I pulled it twice.
You talking crazy now, boy. You making no damn sense.
So that was July 3rd, right after this incident, wasn't it?
Yes, sir.
So it's fair to say that talking then it's right after the incident. Now you're here in court.
We should have been ready.
Both of those propositions can't be true, can they?
I'm sorry, what?
The proposition, I'll rephrase it. The proposition that you said here in court, that you made 2 shots in rapid succession,
Yes.
and
What you told the
what you
fucking...
said on July 3rd, 1 shot, giving some commands, another shot, both of those things can't be true, can they?
They
Nope.
can be true.
Oh,
can be true.
please.
Yes.
So rapid succession, and then what? You talk really fast before the second shot?
Oh, I was given commands. Don't do it. Don't do it.
I'm asking you about this particular passage, this particular thing. Here you said you made 2 shots in rapid succession.
Yes.
You painted a different picture on July 3rd, didn't you?
No.
Oh,
You shot,
please.
you gave commands, and then you shot again.
That's the
How can
truth.
that be rapid succession?
Because that's how it went in rapid succession.
You disagreed with me that it was a boom, boom.
Yes.
So where's the time for the commands between the shots?
As I'm yelling them.
Well, that's not what you said. You said you pulled the trigger once. I kept giving commands. I pulled the trigger again.
Yes.
So
That's not rapid succession, sir. Bullshit.
they're 2 different assertions, aren't they?
No.
He's just going to keep saying no. I'm just going to say right here, those of you that remember from yesterday, he said, he's like, don't do it, while she was, what does he call that? Something racking, whatever it's called.
Tap and rack.
Tap and rack. And that then her arm started to come up. And so I shot. And then like what he and maybe we'll watch it on lunch from yesterday. And then he said, but then she was still, and he started to say tap and racking again, but then he corrected himself and said something else. But it's like, wait, you already said the arm was coming up. So the arm was coming up and then it did what? Like it was already fishy. So we're going to listen to that. Someone remind me, babe. Hopefully you can remind me too. We're going.
So here,
Go ahead.
I want you to mark that because what I don't want to get lost in all this is the fact of, to me, the most important thing he just said about a minute ago was that he was trying to recollect in his mind what happened that this all boils, and you were talking about it yesterday. People's perception of what happens in a moment like that changes. And to me, that statement that he just made is reasonable doubt. If 3 days after the fact, he's sitting there trying to recreate what happened in his mind, we can't trust it. We cannot trust it. And like, I want you to mark the time because I want to go back and hear exactly what he said about.
Well,
like,
remember the
exact
time
words here.
changes, Bay, so we can't really, but
Well, just come on, dude.
I'm
Like,
just saying the time changes as more time comes. That's the way these things count. You know what I mean?
can you just write down the number that you have for me and we'll figure it out? Because I want to go back to that.
All right.
No, this is like 1 minute ago.
I know, but I think the best way to do it is this way because as the time gets more, so I think
All right, play it. We'll worry about it
112.
after the fact.
112.
I don't have the time, Joni.
You gave a statement on July 3rd to the state police, right? A recorded statement?
Yes.
Thanks, Sharon.
You testified yesterday and today. What was your preparation like for this case? To come in here and testify.
I met up
right
with
or wrong answer.
Mr.
wife is
Gubitosi,
correct.
Gubitosi.
How many times?
Always.
I believe twice.
It's true.
And when when were those meetings?
One was recently, I think last Thursday, and the one before, I can't remember.
And when did you start prepping your testimony?
On this past Thursday.
Well, you probably started prepping your testimony about 5 minutes after the shooting, didn't you?
No.
Oh
Mhm.
yeah. Oh yeah.
Oh yeah.
When
Oh,
was
yeah.
the first time you were questioned about what happened?
I think July 3rd.
Really?
So everyone left you alone until July 3rd?
Bullshit.
Yes.
Come
No.
on.
Not a chance.
Not a chance. What?
The judge is not going to find that credible.
Do we have any police out there? I thought there's like a procedure about how many days after a shooting they have to be I'm confused.
They are talking about that immediately. after.
Immediately. Lies.
When you were upstairs with Kelsey, she kept giving you things and asking you to take them downstairs, didn't she?
That's correct.
And she did that with Houston as well, right?
Yes.
So it's fair to say that she was trying to get you away from her, right?
I don't know what her mindset was. I wasn't going to leave her
But you
alone.
did.
Sure,
She's
let me ask you a
nut
better
job.
question. The effect of that would have been, if you took things downstairs, that you would have left her.
Yes, that's correct.
Twice. By his own testimony, twice.
That's not consistent with her trying to kill you, is it? She's trying to get rid of you.
Can you ask that question again?
You don't get it?
The
Come on.
fact that she's trying to remove you from the area where her gun is
I hate
not
that
consistent with her trying to kill you, is it?
He's gonna ask him. He's gonna answer badly. Here. Yeah.
At
she wanted
that
a
point, no.
gun. Oh,
Right.
So let's get into the incident here. What you say happened. You say that Kelsey went into her bedroom after being in the baby's room, correct?
Yes.
She, you don't go in the room, right?
No, I stayed at the very top of the stairs, right before the door frame.
So it's fair to say you're on the landing, the top of the stairs, looking into the room.
That's correct.
And the room's got a lot of furniture and a lot of things everywhere, right?
Yes.
So you say that Kelsey has a change in her demeanor, right?
Yes.
She starts to shake and get upset, shaking uncontrollably, you said, right?
Yes.
Then she lunges.
Yes.
She's on her knees.
She was, I believe, on her right knee.
mhm. Thank you, Chris.
Said that she pushed off her left leg and lunged.
How'd you get the
Right,
tactical
yes.
advantage on her knees?
And at the time, you were 3 feet away from her,
Yes.
maybe less.
Maybe.
So can we agree that's arm's length?
She was a little further away than arm's length, I would say.
So arm's length if you
Lunge
reach over.
yourself.
How about that?
Yes.
And your testimony is that she lunges over and obtains a gun,
Yes.
right? And she assumes a certain stance.
Can you elaborate?
Well, you were there. What stance did she assume?
She pointed a gun at my face and pulled the trigger.
And yesterday, when you were being questioned, you assumed a two-handed stance to show that, didn't you?
That's correct.
What do
Tactical
you call that
advantage.
kind of a stance?
I don't know.
What?
Like a modified Weaver stance?
Yes.
So she assumes a modified Weaver stance. Can you stand up and show a modified Weaver stance? That's just what it's called.
Okay.
I was just going to say, we know from the questioning yesterday, this judge does not, nor do I, know what any of these fucking terms mean. So there's no, like, saying a modified Weaver stance, might as well say like they do the joke you say for like when you take the car to a mechanic. It's your,
Yeah, your flam shooter, you need a
Right.
new flam shooter, your Johnson rod needs to be replaced.
right. So don't waste your time with that kind of stuff. But good, he's going to get up, he's going to demonstrate it. And, you know, that's what this judge needs. You've got to do that here. Yes, Nexus, Lexus. And where's the
Can
tactical
you
advantage?
demonstrate to us what a modified Weaver stance looks like?
Do you want me to stand up and show
Yeah,
you?
we do.
Oh, yeah.
And then,
Are you asking him just in general?
Just to
or-
show the stance in general first, yes, Judge, thank you.
So she grabs it, comes up, pulls the trigger.
no, your
That-
stand.
That's not, I don't think that's what he was asking.
No.
So just what's the modified Weaver stance? What is it?
Here.
And what, can you describe it? What are you doing when you do a modified Weaver stance?
Strong side. All right. So if I'm righty, this is my strong side. That's gonna grab the pistol, and I use my support hand to support the weapon.
Are you righty?
I'm sorry.
Are you righty?
I am.
I'd hope so with that
Thanks.
demonstration.
And you're saying that Ms. Fitzsimmons had the gun in that kind of a stance?
Yes.
And how far was the gun away from your face?
It was right outside of arm's length.
So,
Now
so
we're
she's
getting
3
further
feet
away.
away. She assumes the modified Weaver stance, so she's probably another foot or two towards you, right?
She stepped to the left. I don't know if she stepped.
Are you sure?
Well, your testimony was that she immediately lifted the gun to you and
Yes.
pulled the trigger and tried to shoot you right in the face.
Yes.
So the gun didn't go off,
No.
and there she is with the gun there. The guns didn't go off, and you're within feet of her and the gun that didn't go off, right?
That's correct.
And you didn't just grab her, did you?
No, I was in complete shock.
Oh,
And then she started backpedaling immediately and trying to tap and rack that weapon.
Right. So your testimony is that Kelsey goes from a wounded bird shaking uncontrollably to a female movie action hero, doesn't she?
Those aren't my words.
oh,
That's your
description.
description of what happened, isn't it?
I didn't describe that either. in
So
those words.
she
Tapping
gets
and
the
racking.
gun. She
Side
tries
tapping.
to murder you in the face.
Yes.
5 minutes after she has her feed her baby,
Yes.
she pulls the trigger, nothing happens.
Yes. It went click.
She stands up, right?
She was already standing.
What?
So as she's standing, she shoots you, she tries to shoot you in the face.
Yes. And then she started to backpedal.
So first she backpedals, then she sidesteps, she tap racks again, right?
Yes.
So in all this time, this is like the longest tap rack in history, isn't it?
It's 4 seconds.
So she gets up, she sidestep first or backpedal first?
Backpedals.
So she backpedals first.
And
How
then
many
sidestep.
She's doing the Macarena?
I would say maybe 4 or 5.
Wow.
And then maybe another
Yes, Kai.
3, 4 or 5 to
From
her
her knees.
left, which is my right.
So she goes into action. She tapping the magazine and then racking the gun while she's moving around.
Yes. She's a well-trained police officer
Oh,
Who's a whack job.
who tried to kill me.
oh God.
So let's get the order straight.
Yeah, let's try.
You said that she backpedals first.
Yes, after she pulled the trigger.
And nothing happened.
Yes.
And then she taps the magazine
Yes.
and then racks the slide.
I believe her hand slipped off. That's when she went in, and I was giving her commands, don't do it. And she re-racked and started to bring her right arm up.
And then she does it again, right?
Yes.
And you actually have no idea whether she successfully racked it the first time or successfully racked it the second time, correct?
That's correct.
You don't know what happened.
No, I don't.
And so it takes a few seconds to take 4 or 5 or whatever steps back towards the air conditioner, right?
From beginning to end, once she pulled the gun on me and pulled the trigger, and by the time I shot her, it was right around 4 seconds total, if not
What?
3.5. It was
That
very
five is-
fast.
Come on now.
So she goes from shaking uncontrollably, sad about her situation, crying,
Please.
to being pretty nimble.
She wasn't crying.
She walks, she backpedals, you said, right?
That's correct.
Then she sidesteps
Yes.
to the air conditioner. And you had a look of panic on your face at that time, didn't you?
No.
You were flustered, weren't you?
No.
Then why'd you miss?
Well, you were in shock 5 minutes later, weren't you?
After the incident and my adrenaline dumped, yeah, I was in shock then.
So at the time, getting back to the incident, Kelsey's by the air conditioner. She's backpedaled, she sidestepped, she tapped, she racked, she tapped, she racked, and then you shoot her.
Yes.
And you shot 2 shots. Where are we on the rapid succession? Which one do you want to go with? Rapid succession, or you shot, gave commands, and shot again? Which is it?
I was given commands and shooting at the same time.
So it was rapid
Well-
succession.
Your prior testimony was that you shot, you pulled the trigger, gave commands, and you pulled the trigger again.
Yes.
So was it that, or was it boom, boom, rapid succession?
It all happened in 4 seconds or less.
So
I'm
you're a
confused.
very well-trained SWAT officer, yes?
Yes.
You're a firearms instructor.
No.
No.
You're a patrol instructor, where you instruct
What's
other
a patrol?
officers on the job, right?
Field training officer.
Field training officer.
Yes.
Thank you.
Mhm.
And you've been doing this for 25 years,
No.
20 years.
Right around there, yes.
Okay, so you've been doing this for 20 years. And one of your thought processes was that you wanted to give your training and experience back to the North Andover PD where you started, right?
Yes, and come back where I started.
And
Mhm.
here, your first shot, you missed her from about 7 feet away.
I did.
Oh.
It was longer than 7 feet. It was at that point about 15 feet,
What?
15 feet.
I would say.
She's
Do
on
you have any
her back
measurements
wall?
on this?
No, but if you
15
remove the
feet?
bed and you were to walk diagonal from where I shot, it was probably around 15.
So the first shot, you missed her and you hit the air conditioner. Is that right? Or do you know?
I didn't know where it
Well,
went.
do you know now?
And the fact is that we have only one spent projectile in this case, right?
I'm sorry?
We only have one spent projectile in this case, correct?
I don't know what state police collected.
You weren't curious as to any of the paperwork or anything that happened in the case?
I believe they told me that there was one on the bed and one on the floor, I think. But I don't know where that one projectile comes from.
Did you know that there was one in the curtain next to the air conditioner?
No.
Have you looked at any photos from this at all?
Some, yes.
Well, show him a
Did you know
picture.
that?
Nope.
Let's get it. Yes, thank you. So I am so confused because I wonder if when you do the tap and rack, I mean, is that you got to have the gun, I'm assuming, ahead of you. I mean, maybe she was already tapping and racking when he thinks she was pointing the gun at him. I mean, maybe that's what I'd be arguing. But on opening, they made it very clear. They're saying he shot at her while she had the gun here, not moving it, not nothing. Which
This is where I'm at with it. In those
Thank you, sir.
3 seconds, no one's going to have a clear memory of what happened. This is all what he cooked up in his brain after the fact. Like it's just in those types of moments, it's
Yes, that's the
well, sorry, I was letting you go.
entrance to her bedroom.
And is that a fair and accurate depiction of kind of the stuff that was there at the time?
I didn't see any of that at the time because I was facing forward. That's at a completely different angle.
So you weren't looking in the bedroom.
area where
She got the gun.
you say that she lunged to, right?
There, yes.
It's
to-
not
that
behind
would
a
have been
door,
my
is it?
left.
Now, at some point, there was a safe there, wasn't there? A green safe.
I have no idea what was there.
Didn't you speak with Officer Corr at the scene?
Yes, I did.
And Officer Corr, you said that you ordered him to do something. You remember that?
I did.
You ordered him to take the gun and get it out of there.
Secure it.
And what were you doing at the time you ordered him to do that?
Rendering aid to Kelsey Fitzsimmons.
That's
So
not
you're
what
over by the
Kelly
bed.
said.
He would have had to go in that area to get the firearm and secure it, right?
So I placed the firearm. You can't see the right side of the door frame. So if you were to walk into that bedroom and look right, there's some sort of I don't know, nightstand or something. I put the weapon right there.
Then how did it get on the bed by the other guy? I'm so confused. That sounds like nowhere
Show
near the
you,
bed.
Exhibit 75.
Yeah, let's look at these pictures because that doesn't make any
Is this
sense.
the,
Oh, it's the
Yeah.
white. Yes, that's it.
Oh,
that
it is
where you
next
put
to the bed.
firearm?
On
Okay,
top of that.
sorry.
Now, let's just go over
Exhibit, exhibit what?
75.
Thank you.
So
I thought the other guy
let's talk
did
about
that.
who touched the firearm.
He picked it up and put it on the
So
bed.
Daly picks up the firearm, right?
Yes.
And the firearm was under Kelsey's leg, correct?
I don't know where it was. I was covering down. I didn't. I know he flipped her over and found the weapon.
So-
I don't recall where it was.
Okay. You heard, strike that. So
It seemed to indicate it was underneath her. She flipped her over.
your testimony is that Kelsey's racking the gun, sidestepping, backpedaling, tap rack, and at some point she points the gun at you, right?
Her arm started to come up towards me.
Okay. So it's fair to say that she's back again, like we said earlier. She's starting to do this, right?
No weaver stance.
Okay. So one hand.
It was.
Is that the FBI crouch?
Don't what does it matter?
What do you call that? Is that
No one
one-handed.
it's not called the FBI crouch?
I've never heard that term.
Okay.
all right,
So,
KP. KPT.
She starts to
Jackson.
point the gun at you. So we agree then that the gun is out in front of her, right?
It was in the upward position. It was coming up towards me. When I fired my second round, I saw her kind of buckle and she lowered her weapon and I stopped shooting and then she went to the ground.
You hit her in the chest. She goes flying back and lands on her back, right?
She didn't go flying back.
She landed on her back, correct?
She went down to the ground. I don't know which way she went. I think she crouched over.
Well, you knew she was on her back, didn't you?
I don't remember. As far as that goes, that's kind of a blur.
Mhm.
So the idea that she's got the gun out in front of her, she falls on her back. If the gun's underneath her, is this some sort of a magic gun?
Yeah, the magic gun.
I don't know where you're getting at.
Doesn't it make sense that if the gun is out here and she's receives a force of a 9mm bullet pushing her back this way, how does the gun get all
I
the
hope
way
they have an
behind her
expert.
and under her leg?
I have no idea. It's
I
the way
hope
she
they have
fell.
an expert.
So back to the notion of who touches the gun. Daly picks up the gun, right?
Yes.
Daly puts it on the bed, correct?
Yes.
And when do you touch it?
And you don't like that.
I don't. It's too close to her.
Okay.
Well, she's sitting there with a gunshot wound to her chest with you there and Daly there. Isn't that fair to say?
Yes.
That's all right.
So then you touch the gun, right?
I do.
And then you move it to the white shelf, bookshelf.
Yes.
And then Corr arrives. And
Yes.
then you tell Corr to grab the gun and secure it,
I
right?
do.
And then Corr has it. Does he take it into the hallway?
Maybe. I remember just focusing my attention on Kelsey.
Sure, understand. So you're focusing on Kelsey and you're giving her first aid.
Yes. Well, Lieutenant Daly was starting to work on her.
Well, is it fair to say that at first you still had your gun on her, but then you helped with the first aid?
Yes. Afterwards.
So that was your primary focus, was that once you felt that she was not a threat to you on your testimony, you started to assist with the first aid, right?
Yes.
And you and Daly are rendering first aid, and then Corr comes, right?
Yes. Yes.
And you say, get that out of here, secure the gun.
Yep. Make it safe.
So it's fair to say that Corr does that, but your attention is not on what he's doing, it's on rendering first aid, right?
That's correct.
So you don't have any knowledge or observation of what Corr did with the firearm, right?
No.
Can we stay on the gun under the leg? I hope he's got an expert. That's all I'm saying. They should have an expert.
At some point, are you aware that Corr takes the green safe and the firearm out into the hallway?
I didn't see him do any of that.
I'm going to show you Exhibit 51.
Boy.
Do you recognize that?
Yes, I do.
So Exhibit 51 is the left side of the door frame where you say that Kelsey lunged, right?
That's correct.
Is that how it looked when she lunged over there?
I didn't see that when I was in the hallway.
Do you know anything about that shoebox with the orange lining?
I have no idea.
Yeah, when did that get there? The pictures look different. The
Do you
cord.
remember seeing that
Cord.
chest with the brown leather trim on it?
I thought it was an end table when I walked out of the room.
It's a shoebox. That's what that is. Okay. Oh yeah, I see it now.
Do you think that the gun came from any of those areas there?
With how quick she grabbed it, I think it came from that box, but I don't know.
Show you Exhibit 36.
Hmm.
That's a picture of the stairway, right?
Yes.
It's pretty narrow.
Yes.
And you went up to the top and you were at that landing, right?
That's correct.
You never entered Kelsey's room?
No.
Well, afterwards, I guess.
So you said that you were shocked that Kelsey was quickly grabbing a gun and putting it in your face,
Yeah, absolutely.
and you that she'd gotten a drop on you, right?
Yes.
And had the
And
tactical
at that
advantage.
point, you feared for your life, you say, right?
Absolutely.
And you panicked and you shot her.
No.
Mm-hmm.
Well, you missed her from just a few feet away.
It's hard to shoot a moving target or anything moving.
I mean, she is sidestepping. So you've got a lot of training, sir. You can't hit a moving target.
Are you aware
What
of the Post Commission?
Yes.
And you know that the Post Commission has issued regulations that are in the Code of Massachusetts Regulations.
Yes.
And you know that it's prohibited to use deadly force on a person who is exhibiting a danger only to themselves.
Absolutely.
Mhm.
And
You
you
know
knew
that.
that on June 30th, 2025, didn't you?
I've known that since I graduated the police academy in 2006 or
Wow.
even before.
Right.
He's known that.
And you went in there thinking that Kelsey was dangerous and had guns and you might
Need to section her.
get into it, right?
That's inaccurate.
And that's why you had your gloves on, isn't it?
No,
You were ready to get wet.
no.
Ooh, get wet.
I'm sorry, ready to get what?
See, you
Get
can't
wet,
use
Your Honor.
terms like that. The judge, like, what does that mean, though, Bradl?
And that's when you had to adjust the narrative, isn't that true?
No,
So you're
I don't even know
gonna
what that means.
maintain that you got into a gunfight
Yeah, thanks, Kai. True.
with somebody who was your colleague, right?
yes,
Who had just given you her baby to feed 5 minutes earlier
yes,
of her own volition.
yes.
I wish this was
She developed
rapid
some
fire.
sort of a homicidal animus towards you for what Justin Elaine just did to her, right?
I don't think it was unbeknownst to me. I didn't know Justin was in the house. I think I was standing in her way for her to get downstairs and kill Justin.
Oh, wow. Oh, my Lord. There it is. That's what he thinks. He would have had to get, she would have had to get past a lot more than just you. Oh, boy.
I assume this is in hindsight.
Hindsight, yeah.
Please, one moment, please, Your Honor.
Take your time.
I hope the judge has questions. I just saw another Runkle comment.
Kelsey's like, this guy's so full of shit. See what
Well-
I want to see? What I want a memory expert. Somebody who comes
We
on,
talked
Did
about
you have a
that.
taser?
somebody under
I
high
did.
stress situations, how your memory works.
Did you think maybe
Yep.
to use the taser when she pulled the trigger and the gun didn't go off?
No,
Runkle said that? Damn.
you meet deadly force with deadly force.
She's 3 feet away from you.
Yes,
Could have just grabbed her, couldn't you?
no.
I think he could have.
Y'all carry tasers?
And if there was
See, that's why how the judge, that's how you know the judge is paying attention. Because like as Matthew points out, a bunch of you have, I just clicked on this one. He didn't think Justin was in the house, so how did he think that he was preventing her from getting down to kill Justin? And the judge picked up on that like that and was like, I'm assuming you mean in retrospect. And I kind of wish that he didn't do that. If Bradl would have picked up on it and he would have said, so that's what you're thinking in that moment when she's got the gun, that she's trying to get down to kill Justin. But the judge is paying attention because he picks up on that inconsistency. Like, I'm assuming you mean afterwards.
Yeah, but Kelsey was aware that Justin was in the house. That came out. I mean,
Right, but
she knew he was there.
his statement,
how would she know and this guy not know?
that is a good that is a good question, because I think it's possible that Houston told her while he wasn't paying attention. I don't know, but either way, it was an inconsistency the judge is picking up on. Like nothing's getting past him at this point.
deadly force,
I'm gonna go back. Sorry.
and if there was deadly force, you wouldn't have stopped at 2 shots, would you? You would have emptied that magazine right into her.
I stopped when she stopped. And that's what I'm trying to do. Stop the threat, not empty a mag.
What were some of the things that she asked you to bring downstairs?
I think there was a basket of books,
Car seat.
and I believe some clothes. I think she put him in a car seat.
Got anything else for
What
her?
did you say to her when she asked you to bring him downstairs?
No.
I said we'll deal with that later, and I put him down.
How then did you send Houston down with the car seat? How'd Justin get it?
What was her reaction?
She just kept packing stuff.
And trying to get you to take it down. Well, maybe he'll take these books down.
Are you sure?
So you said that you were, you'd started your career in the North Andover
Just
Police
let that
Department,
car
correct?
seat thing
That's
go.
correct.
And you left for the Lawrence Police Department
Save it for
in
closing.
what year?
2011.
And then you were on the SWAT team from 2019 to 2024, correct?
That's correct.
And that you left North Andover to get a faster pace, right? What do you mean by a faster pace?
Busier. Are you talking about when I left North Andover to go to Lawrence, or?
Yes,
A busier atmosphere,
I kind of
more action.
more calls for service,
More what, I'm sorry?
calls for service.
Calls for service.
Sometimes it's a technique when you're asking questions on cross-examination to kind of bounce around so the person doesn't know what's coming. But I'm not getting the sense that that's what's happening because it's not hitting hard. But let's see. Let's see. Give him, whoops. Sorry. Play, not go back.
Wanted more experience.
And you were there for how long?
In Lawrence,
Yeah,
from 2011 to 2024.
2024, you go back to North Andover, correct?
Yes,
And you said that you wanted to bring your training and experience back to where it all started, right?
yes,
Meaning you wanted to offer officers at North Andover the benefit of your training and experience, correct?
correct.
You said that you only have 10 years left, getting older, a slower pace is what's needed, right?
Yes,
So is it fair to say that the stress of a busy urban department was getting to you?
no,
Mm-hmm.
Well, you did tell Kelsey that you had PTSD, didn't you?
absolutely not.
What?
Mm,
Mm-hmm.
mhm. Oh yeah.
So slower pace, and you just wanted to grace the department with your training and experience, correct?
Yes,
Is that right?
yes,
Judge, I told counsel that I would ask for a sidebar before the next topic. Sure.
Oh, I wonder what that topic is. One
I
that
don't know.
requires a sidebar. It's going to get juicy, maybe. Because I'm waiting for it to get a little bit, talk
See,
about rapid succession. That's how I'd like to see some of these questions.
Here's where I get worried, because it's always a telltale sign of who defense counsel might have hired in terms of experts by the types of questions they ask. And I haven't heard anything that I thought was either information that his
Oops,
gun,
sorry. Go ahead. Sorry.
either that his gun expert would have told him to ask of him, and I didn't hear anything with respect to any kind of memory issues that you might have in a high stress situation. So it doesn't
So-
mean it didn't happen. It's just
No,
I
Bob,
usually
you make
tell if somebody has hired an expert, because that's one of the reasons you hire them,
right.
So
Bob's making an amazing point. And what he's saying is as a defense team, when you hire an expert, part of the thing you use that expert for is to ask very technical questions of the witness to kind of lay a foundation later for when the expert comes on and to catch him in something inconsistent and da-da-da-da-da. And what Bob's noting is that we're not hearing those kind of questions here that seem like an expert gave them to you to ask. And with the memory issue, Bob, I don't know, like at opening, when Bradl explained what happened, I said, all right, so we can't really go with a memory expert because he's saying this guy is straight up. He didn't leave room for it, in my opinion, because I still think he should do it. But let's see where we're at, and we can talk about that more on lunch.
In case you weren't here, down outside, we should discuss in open court what was raised at sidebar, which we will do outside of Officer Noonan's presence. So we're going to take a break so that Officer Noonan can stand down.
stand down,
I
sir.
want to direct this to the folks, the audience members. In case you weren't here yesterday, you should know There should be no recording, audio, video, photograph.
AI glasses.
By anyone at all other than our couple of media representatives that have expressed permission, okay? If you are caught doing so,
You out.
you will be removed
Contempt of
from this
court?
courtroom and the courthouse and told not to come back.
Okay.
Okay? Do we understand each other? Thank you.
We are live. We are live. All right, this is getting interesting, people. If you're not paying attention, come pay attention because some shit's going down. Something's up. Bradl's got something up his sleeve.
Yeah. All right. I'm going to do a little test on you.
Me?
Yep.
Oh,
and
no.
chat and chat.
Okay, good.
It's a
Phew.
memory. It's a memory test. And,
Oh.
and we don't have
A stressor.
a high stressor event
Right.
going on. All right. So I'm going to put up a series of 4 different numbered fingers, and I'm going to ask you in 5 minutes the order and what
Don't ask
number.
me.
All right. But I'm
Not
just
do
trying
it.
to
I'm
make
just
a
saying,
point
don't
here.
ask me.
I am doing it. I'm just saying, I'm trying to make a point here.
I already
about
failed.
memories. All right. So you ready? And it's
Yeah.
going to be quick. It's going to be quick. Like,
Rapid succession. Got it.
yeah. Okay. So, okay. Did you see?
I saw it.
Okay. Okay. Got it?
Yeah.
Did you see it? All right. So in 5 minutes, I'm going to ask you.
I'm going to remember that shit. Gotcha.
All right. All right. We'll see.
Tayhaf can't put it down for people
Hey,
to
Huff's
see
writing
again.
it in the chat.
That
Wow.
destroys the whole, because now our memory, now we've
Hey,
seen
Huff
it and
just
seen it
destroyed
again.
The entire experiment.
All right.
All
Do
right,
it
so
one
we're
more
gonna
time.
do
Wipe
it
that one
again.
from my mind.
No one write it in the chat. I'm going to ask in 5 minutes. Okay.
All right. Here we
All
go.
right. Ready?
Yeah. Okay. Oh,
Mm.
that was 4 digits.
Oh, yes. I did say we're going
I
to
already
wait 5
forgot.
minutes.
I already forgot.
Wow. All right. All right. Well, we'll see what the chat can do in 5 minutes.
Nobody write it down.
And there's no stressor.
Right.
Because
But it's still a different kind of, I see your point with the memory, but this is like, we'd almost need to watch something kind of traumatizing
I
and then
know.
be asked to repeat it back.
But it serves the same purpose because it's quick. You don't have a stressor, and I want to see how many people get it. Now, insert high stress, life or death type stress, allegedly.
I'm
we'll
going
see.
to look for like a really like, and we'll have to give like a trigger warning or a whatever warning, like something awful to watch and see, you know, how we remember what we saw.
Yeah,
That-
I already forgot.
no, I think I
I'm the one who
remember.
did it. I'm the one. Who
No,
did
I
it.
remember.
I'm kidding. I remember.
I was
too.
going to say, you need to write it down though, so that you actually somewhere, so you actually remember it.
It was 4.
What
It was-
happened? He said he's doing it on. Let me make sure I'm playing. I thought they were going to do it in front of us. The flip is going on here. All right, so here's some things other things I want to talk about. So the testimony. All right, maybe something's going to happen here. But the testimony about her trying to take things down is obviously to get him to leave the area is very consistent with what she said as far as on opening, like I'm trying to get him away so she could do it to herself and not involve anybody. But I'm trying to figure out why, he says that she got the drop on him and says that's the tactical advantage, which would mean she's like higher. Even if she's standing up, she's not higher than him. She doesn't have a tactical advantage over him, and
See, here's where I'm at, and this is why I wish we had the judge on. Like getting lost in the technicalities of what these people think happened in that moment. This case to me lives in one's ability to be able to remember clearly what happened in a 3-second period. You know, when you're going back and everything else that you're filtering your thoughts through, like he's in preservation mode. He as a on duty cop has now just shot another cop. No one else is in the room. No body worn cam. His career's on the line. How is that affecting his memory? Just that alone, without even consciously thinking I need to lie. Like to me, this whole thing is if they don't have a memory expert, they shit the bed.
Right.
Because
And we've
that
talked
wins
about
the case for you for both. Because it's like the judge kept saying yesterday, and she's right. Both things can be true because perception is everything, and each
Right.
person's perception of what happened in those moments is their own.
Yes, and
And they're all clouded by different things.
I starred me myself's comment. Allie and Bob, I genuinely think two are true in the same time. Noonan was justified in shooting Kelsey as he saw her as a threat, and Kelsey is not guilty because she didn't have the intent to cause him harm, which was the judge's point yesterday, because she was making it clear, like, look, with the information he knew, right or wrong, he's got Justin's family saying she is so far gone, she will unalive that child and cause a threat to you. So that puts him on heightened alert. Whether
100%.
right, and when she goes to raise the gun, whether it's going to her or not, she believes that it came out rightfully that would be a justified shooting.
In
However,
addition to all that, he's on record with a neighbor calling this woman a whack job. Like whatever's going on with this
that was
dude-
after.
Are you sure?
So he claimed. He said after she tried to kill me. Yeah, I'm sure
Why,
that's what
why
he
is
said.
he spying like where she's parking ahead of time? How
Well-
would she have knowledge that there was an order entered unless somebody at the courthouse called her and gave her a heads up? She would have no reason to know and no way to know short of somebody at the courthouse hitting her up and saying, hey, Justin just came in here and got an RO against you.
Right.
You know what I mean? And it's like, otherwise you have no way of knowing. That's the entire point of going in ex parte.
Right. Is the school or the place where they were supposed to meet, is that the thing that was walking distance from her house, that parked there, that whatever? Because in my mind, that's what was happening, that she drove to wherever she was supposed to meet Justin, had the baby out of the car seat already, in the stroller already, and then just said, I'll walk home, but I'm not sure. Maybe someone in the chat does. But going back to like what we were talking about, and me myself's comment and the judge yesterday, that's how she's saying both can be true. My sort of issue was I always thought it, that the way that kind of comes out as both memory, the perception is if it was kind of on the way or while she was rack and tapping or something. But the defense made it clear in openings that it was pointed here. So to me, it made it a little bit harder to say, like that he perceived it. But we talked about this beforehand, that it needs to that when it was we thought it was a jury, that you need that memory expert. And I agree. I think you also need it for the judge. You and I have talked about that
100% needed
extensively.
only for the judge.
Right.
Only for the judge. You need the best memory expert of note in this country to come in here and talk about you cannot trust anybody's memory, either person's memory. And that's reasonable doubt. I'm
Right.
sorry. It just is.
And-
That's how you win the case. Getting like all like, trying to trip him up on what he may or may not remember, to me is, you're just treading water. This case lives in defective memories. And that,
Right.
that this judge, because of that, and that
Recreated
alone,
memories. Right.
all of it,
Right.
if they don't have a memory expert, this is
And I don't know, not a recreation expert, but whoever would say how bodies move when they're shot, how that gun could get under her leg. That's bizarre, but the judge is not going to make that determination on his own. It's very clear he's not like he doesn't have this knowledge about tactical stuff and guns and like based on all the questions he's asked. So um so somebody saying if you're in the position that he describes and you're shot from this distance in this way and pushed that way and the gun is in your right hand, it's literally impossible to get under your left leg when this happens. And I think the judge needs somebody to say that, not just the lawyers to argue it. Um, but based like on what you said on the questioning, it doesn't seem.
Every comment in chat, you guys are all right, but I'm telling you, you don't need a psychologist. Like, I mean, it could be a memory expert that is also a you need a memory expert to establish reasonable doubt. I'm just telling you, you just do. It's like getting all like hearing both of their sides of the story is fine. And questioning them on that is fine. But you need that expert who's going to talk about incredibly high stress situations and our ability to be able to process and remember that information. And what do we do in terms of our own thought processes and our own perceptions in terms of remembering that? How do things like if he does have PTSD, how does that affect his memory? If he's got his career on the line, is that going to trigger something where he's going to remember something slightly different? Because it like to me, I mean, it's easy to say, well, yeah, he lied because he's got motive to lie, which we all know, which is true. But at the end of the day, ultimately, I mean, if I'm the Commonwealth in this case, I am making an argument that this was an attempt of suicide by cop. That's
all right,
it.
I'm going to put up right now.
Was there I thought I heard yesterday during the drive that there was no round in the chamber, which means that she didn't rack the gun.
So yesterday I was looking at, I kept typing in assault with a deadly weapon, which is why I couldn't find this. So this is the Massachusetts. Is this Massachusetts? I put in Massachusetts. So let me just double check somewhere. Yeah, Mass. Okay. So the defendant is charged with having committed assault with a dangerous weapon. An assault with a dangerous weapon can be proven either of two ways, either as an attempted battery or as an immediately threatened battery. To prove the defendant guilty of assault with a dangerous weapon as an attempted battery, the Commonwealth must prove 4 things beyond a reasonable doubt. And it's the first thing that's the issue. Okay. The defendant intended to commit a battery upon Noonan. Second, the defendant took some overt step towards accomplishing that intent. But if you believe Noonan, then taking a step is there, and you're dealing with what she intended. And then you have third, that the defendant came reasonably close to doing so, and fourth, the defendant committed the assault with a dangerous weapon. To prove the first element, the Commonwealth must prove the defendant intended to commit a battery. A battery is a touching, and this isn't the theory they're going under, it's the other part, but a battery is a touching that is either offensive or likely to cause harm. A person's intent is their purpose or objective. This requires you to make a decision about the defendant's state of mind at the time. You may consider any evidence about the actions or words of the defendant and all of the surrounding circumstances to help you determine whether she intended to commit a battery. And this is going to apply. I should just go down to the immediately threatened. I'm just going to skip to this one because this is the one we're doing. The defendant is also or is charged with assault with a deadly weapon by making an immediate threat to commit a battery with a dangerous weapon. To prove the defendant's guilt, the Commonwealth must prove 3 things beyond a reasonable doubt. First, the defendant intended to put Noonan in fear of an immediate battery. I mean, I guess it could be either one because he's saying she actually did do it, but sorry. Second, the defendant engaged in some conduct towards Noonan, which Noonan reasonably perceived as an immediate threat. That element is established no matter which one of the 2 theories that you believe. If you go with the theory of he perceived things differently and she was only intending to put that gun up to her to threaten herself, that she never had any intent to threaten him. Third, the assault was committed with a dangerous weapon. Okay, so this is the first element is at issue here. To prove the first element, the Commonwealth must prove the defendant intended to put Noonan in fear of an imminent battery. And a battery is a touching that is either offensive or likely to cause bodily harm. That is the element at issue here. That is the element that we believe or hope that the state cannot prove beyond a reasonable doubt. There are two people's stories here. All right. And then it goes on to say a person's intent is their purpose or objective, not just what he thinks it is. It's what she meant it to be. This requires you to make a decision about the defendant's state of mind at the time. You may consider the evidence about the actions or words of the defendant and all the surrounding circumstances to help you determine whether the defendant intended to commit a battery. So as to the second element, the Commonwealth must prove that the defendant engaged in some conduct towards Noonan, which Noonan reasonably perceived as immediately threatening a battery. I think they've got that element locked down. They've got that element locked down. This requires you to consider any evidence about what Noonan perceived and whether that perception was reasonable.
Right, because as soon as she put her hands on a gun, that element is established.
Right. So this case lives and dies at the first element.
It does. And let me ask you this.
Mhm.
Okay. Under the suicide by cop theory, if her intent is not to shoot him, but merely
to scare him,
to scare him in order for him to shoot her,
she's guilty.
So, all right, now I want to throw these two things up. So Mustang Sally had said, totally agree, Bob, but I don't think you need an expert to say that. I'm fully aware both could be remembering their versions of events. And then I'm going to follow it up with cigarette hush. Is it not common sense though, Bob? That's not how court works. Like, I think anybody who watched Karen Reed, we would all agree that the lack of injuries on John's body would indicate that he was not struck by a vehicle. That's
very
common sense.
Right?
That's very common sense. Do you think that they would have won the case if they didn't have ARCA? There's your answer. You need experts. The trier of fact needs experts. You need a record. It needs to be on the record, and it needs to be explained in scientific and technical terms so that the trier of fact has a reason to know. Because, yeah, I mean, there's obviously a common sense element, but there's more to it than that. So that's where I'm at. I mean, does that mean that they can't win the case if Bradl doesn't have a memory expert? No, it doesn't mean that. They can obviously still get the judge to, reasonable doubt. But in my estimation, and I saw a good question in terms of Kelsey's assets and the ability to pay for experts. They're not free, right? I mean, so that becomes a question. It's a question in every criminal case, Allie. And I lived in that world of people that were basically spending their last dime mortgaging their house, doing whatever they could in order to pay attorney's fees, which ultimately leaves you with little to no money to hire experts, which is a constant battle. It's that thing where we're always talking about, going against the power and resources of the government. They don't have those issues. The state always can get their experts because they have unlimited resources in terms of trying a case. That's not what defendants are dealing with in this country. If you're broke, sorry. I mean, you can go to the county on bended knee and say, hey, but are you going to be able to get the best expert out there? Of course not. You're going to get whatever you can afford.
And when Bob
based on
says
what the judge is going to give you out of the county coffers.
Right. When Bob says going on bended knee, even though you have your private counsel, so you had enough money to retain private counsel, you can still go file a petition to the court in almost all the states that I've ever seen and in federal court. So I'm just assuming here with Massachusetts, right, that if you can show that you do not have available funds to hire an expert and that an expert is needed for your defense, that you get funds from the county for that. And that's where Bob's saying you're not going to get the best, but you have an avenue even when you don't have money. But also there is a lot of fundraising here. So yeah. I would hope that this doesn't come down to
I mean, has
money.
Coakley done anything? I mean, in terms of like the other attorney, the female attorney, is she? I don't remember her doing
No,
any
she
cross.
hasn't done anything yet.
I like, and I know that you said this, babe. Like, I think the state might be resting after Noonan. I mean,
Yeah,
who else
I
are they
think
going
so
to put
too.
on?
No, I mean, why wouldn't you end with Noonan?
Right. I mean, I don't know who else they'd put on, to be honest with you. I just, I don't know, unless they're putting some kind of expert on,
Right.
you know? No, I didn't forget. All right. What numbers?
Can I say it?
Sure.
Or, so 1, 4, 1, 3.
That's right.
And that's on like, but again, the test needs to be you're really viewing something traumatic. And we still wouldn't be able to recreate when you're actually in that minute, like the adrenaline, everything going on. But
Did you guys like, so who, did anybody write it down? Because
everybody got it right. Oh, Jamie got it wrong, but everybody else got it right.
Classy Kate got it wrong. Oh, wait, no, she got it right. Let's see. I thought I saw one.
I shouldn't have said it so quick because it was stupid. Should let everybody get their words in.
Yeah,
Matt got it wrong. 1, 3, 1, 4.
I agree, girl Ryan. Girl Ryan, and thank you. It says if officer has perceived threat, muscle memory takes over. Muscle memory and training. Like, it's almost like second nature. Time from removing the gun from the holster to first shot is under 2 seconds for highly trained SWAT. 4 seconds doesn't make sense for a perceived threat. Yeah, I mean, in terms of like, that's what Allie was saying. The perceived threat, as soon as she puts hands on her weapon, that element has been met by the Commonwealth. Like, that's all it takes for that element. But as you guys know, at this point, you have to prove each and every element of each and every charge count. And in this case, we only have one. So they have to prove each and every element. And the problem for them is going to be Kelsey's intent.
Right.
That's why Kelsey's intent is going to have to come out during her
She's
direct testimony.
I think we are all of the mindset she has to testify.
She
She's
has
going
to testify.
And I just want to bring it back to Bob's original point about suicide by cop, or self-harm by cop. DB mentioned it, and I know we mentioned it yesterday, that if that is what the judge believed the evidence showed, that is guilty, because the whole point of doing that by cop is to scare them into thinking that there's enough danger to them to shoot you. So that is all that is needed. If she was either trying to put him in fear of a battery or actually planning to hit him with, do something with that deadly weapon directed towards him, or dangerous weapon, directed towards him, that satisfies the elements. And that's why this is a he said, she said. And that is why we say a he said, she said, but maybe with a little twist of how your mind works when something like this happens, and how it is possible for two people to remember two things very differently and both be their perception.
Yeah, to your point, which is spot on, per usual. But it's because if you think of it this way, in terms of like, if that's hard for you to kind of come to grips with, I mean, remember, they tried to charge her with the attempt murder, and that charge didn't stick. So, but because that would have been the thing, if the gun jammed, or even if, say, the magazine was empty and it did, like, she just had an empty magazine in there. Is that a magazine or a cartridge? I'm the opposite of Runkle in terms of.
And we actually gone over this on our live, but
I
people
still
forget
forget.
it. Right.
I still forget.
And you guys have told
But
us.
if that thing was empty and like she was literally just trying to scare him into shooting her, like Allie said, in terms of the assault, it's guilty.
But I'm surprised, because that's the kind of thing you see them charge just to have the lower charge hit. We saw it in Reed. So I'm kind of glad they didn't do that, because it's hard when you've got a jury saying, all right, fine, we'll meet in the middle. no to attempted murder, yes to battery.
Well, I think
Or assault,
I think they tried to indict her on that. Correct me if I'm wrong out there, y'all. I think that they tried and they couldn't get it. I think.
Oh,
I'm not 100 on that, but like for that rattles around in my brain. All Eyes had said, Bob, from memory, do you remember what the poster board said when that weirdo in Delphi did a battery onto you mid-interview? So that was during my man on the street interviews outside the courthouse. I don't specifically, other than I remember that it was, you know, it had a picture of the girls on it and it was, you know, justice for Abby and Libby. Can't remember any of the details of it other than it definitely had pictures of Abby and Libby, I think.
but that damn assault wasn't too shocking and scary for Bob.
Oh, I was terrified. Terrified. I almost
It did make for good numbers, though. Did make for good numbers on that live. I wish people would try to assault my husband more often. No, I'm just kidding. But while that was happening, I got like somebody messaged me like someone just like attacked your husband, and I was like, "What?" I was horrified. I was like, "What?"
All I
quickly got to
remember
me.
is what I said to her is, you know, I kept saying, "Do you hate due process?" That's what I kept saying. I don't remember what she said to me. And frankly, she's a little hard to understand in terms of making words. So it was something. It sounded a lot like, you know, like to me, what it really sounded like was probably, you know, the Peanuts teachers or parents, you know, like this. And I just started asking her, I'm like, yo, no, I don't have, that was like a year and a half ago.
Right now. But you have been saying that you've been having memory issues as well. We all know I've been very vocal about my perimenopause brain. But this weekend, our son-in-law said creatine is great for memory fog, male or female. So
Interesting.
remind
All
us.
right, don't be mad at me. I
about
got to
it.
dip off for a little bit. I'll be back though.
It's gonna leave me alone while we've
miss
got
you.
the
All right, I'll be
blur
right back,
screen.
y'all. It's gonna be a minute though. I got to do my
Yeah, but try to
weekly
keep
thing.
it to, you know, like where it should be.
What do you mean?
Like you only need to be an hour.
Yeah. All
All
right.
right. I don't know if Bob already said.
All right. I love you. Bye.
Love you. Bye. Welcome to Amy Boston. Thank you for becoming a YouTube member. Welcome to the family and family hug. Montana Lil says, I would like to know the angle of entry of Kelsey's wound. That would tell us if she was full on facing him, like he said, or at an oblique, like she said. So, yeah. And maybe that is their next expert. And it wouldn't be, people keep saying a medical examiner. It wouldn't be a medical examiner because nobody died, but there could be somebody from the hospital. But I don't know that would be angly enough, you know? So I don't know. I guess we'll have to see. Thanks for your generosity. Dog Grooming Danny says, got to listen to Garcia on the way. I think Bob might have actually talked on this. My first appointment this morning, enthralling as always, drove right past my exit. I hate when that happens, but trust me, it's happened. Okay, so yeah, Bob did go through these. I'm definitely going to check out Runkle's stream on that. You know, he always has very good insight. But one of you said in chat that he said it is possible for Noonan to miss. And was he saying like not because of stress, but just because of a moving target? Because I really liked that he couldn't do that. So, you know, but Runkle's going to call strikes, balls and strikes. You know, he's not going to blow smoke. So if that's what he said, you know, Loopy Lass 72 became a member. Ah, welcome. Family hug. Kathy, your realtor in Jersey. The guest judge was a great perspective. Yes. Judge Erskine was great. I was so glad to have her. You know, I don't know. I always like worry that so many of you like don't want us pausing and talking too much. But when we had the judge, when it was just me, I was trying not to do it that much. But when we had the judge, I wanted to get her perspective on everything. So I was ready to pause and let her comment on whatever she could, because that was such an amazing asset to have. Like literally, she just retired from the bench 3 years ago. So, and it's, you know, judges aren't going to very easily, even retired judges, just come out and speak poorly of a judge unless it's warranted. And she really felt it was warranted with what happened in this case on a lot of different points. Trial Lover says, Halo collar, oh, for the dog, no fence runoffs on your phone and you drop an electric fence anywhere. I think my sister mentioned that to me. We just were like, when he was a puppy, like, we don't even want to train him with the little electric shock collar or like whatever. And I guess, you know, they're designed not to be bad for the dog, so maybe we could have, but now we feel bad, like he's full grown. It's not something he became used to, but we got to think about it. Mermaid RM says, Kong filled with kibble, wet food, freeze it. And thanks for your continued support for 4 months. I don't know if I told you guys this the other day, but when I was trying to break him of the licking, man, I gave this dog peanut butter in the Kong, but I gave him so much of it. I just wasn't thinking that, like, you can't give him that much peanut butter in a short period of time. I think he like got sick from it. And I was like, oh, I'm the worst dog mommy ever. I felt horrible. So I'm definitely going to try the Kegel with wet food and freeze it. Not even just because of his, like, what need for attention earlier. I just like, if he needs the attention, I just like to give it to him. But he's not usually that needy, but he also has been doing this like licking thing that I think we might have broke him of. But thank you, Mermaid. And I put this up, but I wanted to talk about it a lot. So BRRK says Daly said Noonan told him she pointed the gun at me. Now I want to double check you guys in chat on this, on the like regular chat, and I'll flip over in a second. Bradl objected, yet Noonan testified she pulled the trigger, didn't fire. If so, wouldn't he have told him shot at me? Thank God it didn't go off. 100% agreed. But, and this is the whole memory thing. I actually thought he testified she shot at me. And that's like the thing that sometimes your memory, it's like you interpret what you think was being said. So that's what I was asking you guys in chat. Do you recall his testimony being she pointed the gun at me or she shot at me? Because that is very telling if all his words were she pointed the gun at me. As opposed to she shot at me. All right, I'm still watching you guys in the chat. See, Milo's mom thinks it was shot at me. We'll have to go back and listen to that at lunch too. Somebody put this on the list of 2 things we have to go back and listen to. Yes, this was yesterday, right? Yesterday.
All right, just for the record, Officer Noonan is not in the courtroom, correct? No. Okay, and Mr. Bradl, do you have additional counsel sitting with you?
Yes, thank you. I want to introduce my client, Julie Best. They're attorneys that are working with us in the probate court, and I wanted to ask if it'd be all right if they were up here because they've been assisting us with various factual matters. Would that be all right with the court if they sit here?
Commonwealth, you take a position?
No, take no position.
Yeah, I think you'll have to file these limited appearances for the day. That's fine. And let me just.
You can give him leave to do that. So it sounds like.
Your names again?
Sounds like the judge is going to give him leave to file limited appearances, and not make them, and let them sit.
Okay, welcome. All right, so let me just discuss what we were, or just raise what we were discussing at Sidebar. So Mr. Bradl came to Sidebar, asked for permission to explore 3 areas on his cross of Officer Noonan. The Commonwealth reminded me that this topic or topics are addressed in a motion in limine that the Commonwealth filed prior to trial that I deferred ruling on, which is paper 62, Commonwealth's motion in limine to prohibit questioning regarding current duty status. Mr. Bradl, let me just start by paraphrasing what I think the 3 areas comments are.
So this goes to the fact that Noonan he's been put on leave. So, and that's what the whole pause was. That's what they were discussing. So let's see what the judge, he's going to restate what the issues are.
Yes, sir.
And then you can tell me. You wish to explore 3 areas on cross with Officer Noonan on the grounds that the areas could show or
Yes, DB.
do show that he was offered promises, inducements, or rewards for his testimony. Right? That's the theory. The first being, generally speaking, that he was not drug tested after the shooting. Is that what you're saying?
That's right, Your Honor.
I'm sorry?
It was a town policy. It's a town policy that after there's a serious incident, that the town would drug test the officers involved.
Okay, so number 2, and I may not have these in the order that you raised them. Number 2 was that essentially you allege Officer Noonan missed a shift sometime after the shooting. Perhaps it was, let's say, medication related, generally speaking. And number 3, that Mr. Noonan, Officer Noonan allegedly was placed on administrative leave, but allowed to work details, and that you believe that to be in violation of some policy or CBA.
Yes, Your Honor. You're either a policeman who can work or you're a policeman who can't work. And you can't be performing details in uniform as a policeman while you're out on critical incident leave because you can't work.
All right. So generally speaking, we did address some of this pre-trial in the sense that there was a Rule 17 motions, right, by the defense to get Officer Noonan's IAD files from Lawrence and North Andover PDs, which I believe Officer Noonan agreed, which is really unprecedented in my view, agreed to provide a waiver for him to get those. So, Mr. Bradl, so did you get the files that you were seeking, the IAD files?
Yes.
Okay. And so let's just go through each point. The first point about the alleged, well, let me say this, is I stand by what I said. The Commonwealth argues that these areas or these questions, strike that, that there's no view of the evidence that could show that any of these 3 things would be promises, inducements, or rewards under our rules, because whatever the North Andover Police Department did, they did as a product of their own administrative duties, and it has nothing to do with the prosecution team. And there were no promises made in exchange for his testimony. So I'm sure that Ms. Moriarty could articulate that much better than I did. But let me try to cut to the chase.
Still biased.
I agree with the Commonwealth, as I said before at the Rule 17 hearing. But I think arguably, and I want to hear you folks, that they could be asked, again, I need to drill down more, but they could be asked to show some kind of bias in the sense that North Andover police, let's say, allegedly, and Officer Noonan are trying to curry favor with one another.
And I don't know, so I'm asking
in
too.
lieu of their testimony, in lieu of his testimony here. Okay, let's just say arguably for a moment. But let's just go back now, Mr. Bradl. What's your basis for saying that, for alleging that he wasn't drug tested and that there's some policy, or does the Commonwealth concede?
The Commonwealth concedes he wasn't drug tested, but that the Commonwealth's position is that that's not a policy, that there's no violation of any policy, because the collective bargaining unit policy trumps the general personnel policy of the city. And so So in that way, there's no potential promise reward. Can I put something else?
Yeah, please, please.
Write in my paper as I'm
Sure.
reading it. I think, again, it's supposed to promise reward. Officer Noonan provided grand jury testimony and a recorded interview to the Commonwealth days and then in August. And all of these incidents happened well subsequent to that.
I understand.
And there's no claim that Officer Noonan has substantially changed his testimony from what he stated in grand jury or what he told the police on July 3rd. So again, there's no plausible showing or consideration in exchange for his testimony that has been remarkably consistent since July.
But it's bias, is what the judge
What do you
said.
say
Did
to
you say
that?
remarkably consistent?
Yes.
Okay, so I don't think that's really the issue right here.
No, it is because the Commonwealth raises a good point. So even
Can I
on,
take a
even
crack
on,
at
well,
the
even
other
on,
side of it?
no, even on my
Hey.
theory, and just give me a moment. Even on my theory that arguably,
That's
let's say
biased.
that each side, again, not the Essex DA's office or the prosecution team under Rule 14, but let's say the police department and Officer Noonan are trying to curry favor with one another. Ms. Moriarty does make a valid point that there still needs to be some showing that he's changed his story.
Sure. I know that's a familiar topic that we all use in this area. Oh, they didn't change their testimony. That's not this, and here's why. This is a reward. It's after the fact. They're
Reward?
giving him rewards for his cooperation, to keep him happy, so he does well, so he's economically enriched, so he's treated nicely, and it's a reward. That's why that doesn't apply here, Judge. He is being rewarded for his continued cooperation. It's not the typical one that we often deal with.
No, but let me just push back on that. So he's cooperative, but does his testimony, but he gave, I think this is what I heard, is he gave a recorded statement to the state police a few days after the shooting, right? So.
But when's the drug test supposed to
He's
happen?
being rewarded for cooperation, what, for doing his legal duty, that is, show up when he's summoned to testify in open court?
I think the fact that there's a legal duty attached to someone testifying doesn't eliminate the fact that you can be rewarded for what you're doing. You can get special treatment outside the rules.
Yes, cigarette.
And I think that goes to the heart of cross-examination, where if someone has a rule made up just for them, that they can be a cop on a detail, but they don't have to be on the schedule because they're out on leave because they can't perform their job. That's a remarkable, unprecedented, in my research and investigation, an unprecedented accommodation.
Well, is it unprecedented or is it legally binding part of the CBA?
No, it's in violation of that.
Okay, so I don't, go ahead, Ms. Moriarty.
Judge, I'm frankly less concerned about this issue where you're the backhander. I think it's the right thing to do is to keep this as any other, as we would treat any other witness, where it doesn't matter what employment decisions of more Andover police and Officer Noonan have, that's the employment decisions, just like IA files, are not part of the prosecution team, are not part of the court team. North Andover couldn't promise Officer Noonan something without the approval of the district attorney's office. So I think that, again, that interplay, if there is any interplay there, has nothing to do with Officer Noonan's testimony here today.
Okay, but Mr. Bradl says that this absence of drug testing was in contravention of the CBA.
I don't think he hasn't brought forward the CBA. He has no basis to ask you questions.
We can lay a foundation.
Mr. Bradl, let's move on to the second point. Your second point is that Mr. Noonan, Officer Noonan, allegedly missed a shift related to some medication. Let's leave. I don't need to know more. I mean, I know more because you've articulated at Sidebar, but we don't need to rehash that. And you're saying, I think somewhere in your paperwork that
I don't
as a
know this,
result
but-
of that missing the shift, I think you referred to it as AWOL, he received a written reprimand as opposed to some more significant action, adverse action. Correct? Is that generally what your theory is?
Generally, yes, Your Honor, with a little more elaboration if I could.
Please.
So we've
Why
had
not so
a
quick?
number of whistleblowers from the department
Mm.
approach us with information. And as a result of that, I will proffer to the court that I have a good faith basis to assert that.
Town policy.
To assert generally what.
I won't say
Your sources,
Yeah.
what I'm trying to do here is, I'm trying to make sure that no witness's reputation is attacked and destroyed for on an illegal issue that I end up denying. All right. So I'm not saying that that's the case here, but let's just say, okay, let's skip you have a good faith basis to ask this. Okay. You say you have a whistleblower, et cetera. So you're saying that this again shows what? That he's receiving favorable treatment?
Rewards for his continued cooperation. That's
There's-
correct. That doesn't have anything to do with changing his testimony or not changing his testimony. That he's being lavished with rewards. He is, that this, and I won't say anything relative to any of his conduct, but that this reprimand letter was not going to be issued. And that at some point it was sort of a
Thank you, law girl.
thing that it was in fact issued for appearance's sake. And that originally there was going to be no sanction whatsoever and no exploration into and I won't say, but the reasons why he missed a shift.
Okay. So let's say there that the proposed question.
Sorry, I just want to pause real quick and ask law girls. Some people have said that this Flexerol has come out in a hearing. We're trying to figure out, is that rumor or has that been stated publicly, even as a rumor? And I'll bleep back, but hopefully, well, we've got the law girls in here. Maybe they know something. So
I don't think that's law girls, not attorneys. I think it's somebody else. So, but there's another thing that somebody brought up in our comments yesterday on Replay Crew about Kelsey being on Ativan, which I think it's been shown through testing that there's an aspect of suicidal ideation that's involved with that. But I don't know.
Oh, yes. People were saying that she was on a medication. Yeah, we'll talk about that at lunch as well. All right. I'm sorry, guys. Sorry for the interruption. I'm confused.
Exploration into
I blooped back.
but the reasons why.
Thanks, DB. Thanks, babe.
Missed a shift.
Okay. So let's say there that the proposed question is, Officer Noonan, isn't it true that on such and such a date, you overslept because of some medication, you missed a shift, you were deemed AWOL, and you only received a public a written reprimand when policy called for you to be subject to the death penalty. And so that's the question. Right. And he says, yes, no, okay, then what? Let's say he says, no, that's not true.
Well, we have the letter, Your Honor. Minimum, we have that.
All right. So, all right. And then the last item is that he was put on administrative leave and allowed to work details in violation of policy.
Right.
And you're saying that that's ongoing?
That's my information, judges, that he was working details and.
What's the source of your information?
Another whistleblower. And, they come.
Nah,
to
my
me
bad,
with
not
faith
yours.
And have you vetted these whistleblowers?
Yes.
Listen, frankly, if this was a jury trial, and I realize I'm talking out of two sides of my mouth again, because I said yesterday we're going to treat this just like a jury trial. If this was a jury trial, this would be an easy decision. The decision would be not even close on your proffer, denied. The objection would be sustained. I'm going to allow one question each as to each of these areas. Mr. Bradl, you'll accept whatever the testimony is under oath to that answer to that question. I'll just remind you, because I'm reminding you, I'm really saying this for our audience, not you personally, but I'll just remind counsel that questions of witnesses are not evidence. The evidence is their answers. So that's what will be used or could possibly be used in your closing argument. I'm going to allow one question each as to these areas, and you'll have to live with the answer that is provided under oath. Okay?
Yes, sir.
Okay. And do you need to speak with Officer Noonan about this before he returns Commonwealth? Okay. All right.
No.
So he may resume the stand. All right. Thank you, Officer Noonan. Mr. Bradl, you may continue.
So I'm just going to pause right there. And, you know, I was going to say this, that since this is a bench trial, you always lean towards letting the evidence in, because the judge can make a determination of whether he should even consider it, whether it's more prejudicial than probative, and what weight to give it. You don't have this risk that he's going to be tainted by something he should have never heard. Now, the fact that he's stuck with whatever the answer is, that's a little bit difficult, but, you know.
Hey, can you flush? So is this relating to in terms of the whistleblowers, is it the whack job comment? Like what?
No. This is all about whether it's policy that he's been getting favorable treatment, and that he didn't have to take a drug test, that usually after there's a shooting, there's a drug test. Now, I wouldn't have couched this as just favorable treatment. I would have said how it goes to bias, that his ability to interpret the events, and that they should be able to explore the fact that we don't know that you weren't taking drugs because they didn't do a drug test. And usually they would do a drug test. To me, I think that alone is relevant. And Bradl thought, well, it's better to tie it to he's getting treated favorably. Now, if the drug
I
test,
agree with you. I mean, how is it any different than attack? I think it goes to credibility.
right, for
Right?
sure.
But, like, I mean, how is it any different than a jail snitch? I mean, you know what I mean? It's the same kind of global concept in terms of attacking credibility because they're receiving favorable treatment. You know, do they have an incentive to lie? You know,
Right. And well, the judge's point was, but he was already giving this version of events. But how many days is the drug test supposed to be? You'd think that's supposed to be quick. And he didn't give a statement according to them. Oh, we've got the judge. Yay.
welcome, Judge.
Hey, good morning. Good to see you.
You too.
So we are actually just talking now, and your input would be amazing. Did you happen to hear the arguments that they were just making?
Yeah, I mean, I think the judge is probably right if it were a proffer and it was going to come in front of the jury. I mean, I think the main issue is what's the relevance? What's the connection to what happened in that room? So I think he's giving them some leeway because he knows it's a Sixth Amendment issue as well. So I think it's not uncommon for judges to try to balance that. You know, he knows from a relevance perspective and based on the proffer that, you know, probably doesn't have the requisite level of relevance. But on the other hand, if he opens it up a little bit and we see what the question is and then what the answer is, I think that's a pretty reasonable decision.
And like Bob was pointing out, doesn't it go to credibility, the possibility that that if there's some evidence, and I'm still unclear about it, but some people in the chat have mentioned, if there's some evidence that he was taking some prescription medications that could cloud his memory, that could cloud his perception, that could cloud his reaction time, doesn't that go towards credibility as opposed to just focusing on it as you've got a benefit? To me, that's
Right.
the least of the reasons why it should come in. And I would love to hear your perspective on that.
Yeah, I think the problem with that is that you just can't put it out there that, hey, this is a drug that could cloud your memory. I mean, it has to be some foundation. You know, there would have to be some testimony probably later on about the medication. Again, you know, I think what the judge is trying to avoid is just, you know, the defense just sort of throwing stuff out there. Well, well, you were on this drug, and what's the next question? Isn't it true that it can cloud your memory? And was your memory clouded? Then he's going to say, no, my
No.
memory was perfect, you know? So I'm not sure that's the road to go down.
So bearing in mind that that's probably the whole point of getting it in, right? That the defense is more concerned with showing he takes these drugs, he's had to miss work because of these drugs, and because he knows, he's got to know the judge is clearly not going to consider the fact that these things as like that gave him motive to lie. The judge has already made that abundantly clear.
Yeah.
So isn't it all for naught if they're trying to use it for this purpose that we know the judge isn't going to use it for? Meaning, if it was a jury and you snuck it in under one of these other reasons, and the jury
Yep.
can go, oh, he was on drugs too. But the
Yep.
judge is not going to think that. So why is the
Right.
defense pushing it?
Yeah, I think, they have their plan of attack, and their questions were basically set up, to get in front of a jury and to throw some things in there. But you're right, a judge isn't going to consider it. I don't think he's going to consider any of this. What I do think he's going to consider is sort of the inconsistencies and his, yesterday when he testified, he remembered every single detail, line by line, minute by minute, bit by bit. And then today he's like, well, I don't recall. And I don't recall that. And I thought they did a really effective job of saying, well, was she kneeling or not? And how far away was she? Because people think the questions were all over the place. And I think that's intentional, because I think it showed that, there's a lot of confusion there. That to me is something that I would have weighed heavily in terms of what actually happened in that room. I thought they made some great points. Hey, she told you to put it down. She wanted you to leave. I mean, I think they brought in some great points there about the fact that, her plan wasn't to kill him. I think in that respect, they did a good job. I don't know that I would spend time, confusing the issue with, the issue of drugs.
Right.
And Judge, I
I don't know what you think.
Hey, wait,
Bob.
let me just say this so I can take the comment away. Yes, tell your friends, tell your neighbors. Judge Erskine is here. I was trying to move the judge up so that if I put up a comment, we're not blocking the judge's
I
face.
lost your volume.
Oh, I was just saying I was trying to put
she might not have it back yet. She still looks. Can you hear us?
Can't hear.
You can't
maybe
hear us?
go out and come back in. Here, put a comment up. Let's see.
Yeah, let's
Judge,
see.
exit and come back in. I'll put that up so she can see it. But yeah, tell your friends, tell your neighbor.
Again.
Oh, my comment didn't go up. What's happening here? Oh, it's on this way. Okay.
Wow. Here.
Go ahead, babe. See if she can see it.
That usually fixes it. It's like an old TV. The old school TVs used to whack them on the side to get rid of the.
Maybe she's doing it. I want to wait till the judge comes back. We're so lucky to have her, so I'm gonna give her a chance to figure this out. But yeah, let's.
So I Am America's Daughter said, this is killing me. Did anyone else catch yesterday the chief, the officer involved in a shooting, his firearm and then handed to him what on earth is happening at this police department? Yeah, look.
What's happening here? I can't get her back in.
She left and she's going to come back in.
Oh,
I think.
Okay. I thought I heard her. Oh, there she is. There she is. Okay.
Does it work?
Hey, yes. You hear us now, Judge?
When I come back in, I am not being heard.
All the way out.
Technical
We can hear you now. Can you hear us? She can't hear us still.
All right, hold on.
She left and came back and still
No.
can't hear us.
When I say leave, I mean like.
I think she did because there were two of her in the waiting room.
All right, here's what I'm going to kick her.
I'm working on it.
Hold on, I'm going to kick her from the studio. Judge, if you can't, she can't hear us. All right, I'm just going to kick her. She'll be like, oh, they kicked me from the studio. Kick doesn't mean. All right, here, I want to kick her out.
We get it, babe.
Kick guest. All right. I kicked her. All right.
So
Maybe
hopefully she can come back.
hopefully she's not offended by being kicked. But the point is, I want her to leave studio and come back in fully. So
I thought she did actually, because I heard
I
her.
always saw her backstage down.
Yeah, but that was what you couldn't see is there were two of her back there. And I heard
did
when
see
she
two of her.
re-entered.
I did see
It
two.
happens. Yeah, that happens. That's probably her calling you. Tell her to refresh her screen before she comes back in.
No, that's not her.
Oh, it's not.
No, it looks like something else. So yeah, look, nothing disturbs me more about this case than the fact that they brought Justin to the party, the serving party. To me, it's inexplicable. I mean, you're inviting disaster. And am I crazy? But I heard testimony that Kelsey was told he was there, right? So she knows that he's there, right?
I mean, I think that that's what Daly said, and that she said, I don't want to see him. And Houston went down and told him to go into the basement. But it seemed like the only reason he went into the basement was because he wanted to get his
Shelley
suitcase.
says yes.
Yeah.
Because I mean, that changes everything in terms of Kelsey's mindset. You know,
All right. Should I start it back up until the judge comes, or give her another minute?
Start it back up.
All right. As soon as she comes, guys, I'm going to pause it. See
Your cross-examination.
Thank you. Sir, I want to ask you some questions about some of the treatment you've gotten by the North Andover Police Department since this incident. Sure. Okay. Now, after this incident, immediately after this incident, you were not drug tested by the town or the police department, correct?
No.
And you're aware that's a policy of the town?
That I don't know.
You don't know the town policy?
As far as the
Pull
drug
it out.
testing, no.
Pull it out.
Now, you also are on critical incident leave right now, or word to that effect, right?
Yes.
And that means that you're not able to perform the duties of a police officer for the time being, so you get put on leave, right?
Yes.
And yet at the same time, you're being permitted to work as a police officer on paid details. Isn't that true?
Yes, that was our union.
So it's just it's a yes or no question.
Yes.
And that is an accommodation that was made via a side, may I inquire, Your Honor, or?
I've already gone past one question.
Yeah, no. Stay. Next question.
That is something that is not ordinarily permitted, is it?
No, you've gotten your answer. Okay.
Okay.
Next question.
All right. Now, you also were absent without leave from a shift recently, correct?
Back in January. Yep.
And with respect to that, there was a reprimand letter issued to you, correct?
That's correct.
And at first, that wasn't going to issue, was it?
Let me just hear the question. What I was really expecting was one long leading question each, but that's all right. You're breaking it up. Let me just hear the question. Officer Noonan, please don't answer it until I hear it.
So
Go ahead.
The question, Judge, is that reprimand letter that appeared in your file was originally not going to issue against you, was it?
All right. That's the question?
Yes.
Okay. And you're going to live with the answer?
Yes.
All right. Yes or no?
I have no idea. I was just called in one day to sign it.
Okay.
So I have no idea if it was or it was not.
All right. So.
Next question.
Okay, that's all I have on your.
Okay. All right.
Thank you.
In that area, you're not done with cross, right? I'm assuming that you're.
In that area,
Okay,
right,
all right,
in
thank you.
terms of rewards. Judge.
Yeah, see, I mean, that was a non-starter. Like, that's what I was going to
Now,
ask the judge. Here, pause it real quick.
Yeah. Total
And
non-starter.
when the judge is telling you, if we were in front of a jury, this is a no-brainer, this is a no-go, that's telling you he doesn't care.
He doesn't care.
He
Right.
doesn't find it relevant. It's not going to sway him one way or another. Don't die on that hill. Don't die on that hill.
Oh,
All
Can you
right.
hear us?
I can hear you. Can you hear me?
Yes, we can.
We can. Sorry, Judge, I kicked you. I'm like, because I didn't want you to. I wanted you to go all the way out and come back in because a lot of
Well,
times.
that's what I did,
I keep telling him you did that.
along with technical help from my technical sons.
It helps. It
So
helps
he
to have
just,
young ones.
just so you know, he just asked like the one questions, and they all went basically nowhere, except he confirmed that they did not drug test him, but he does not know if that's a policy, if that's a policy that he was supposed to get tested, and the rest of it went nowhere. He's moving on to the rest of his.
Yeah, that's good.
Yeah, because before we had your technical difficulties, I was going to ask you that thing when you have a judge telling you, look, if we were in front of a jury, this is a non-starter, there's no way I'm allowing it in. That tells you how much weight or not weight he's going to be giving a particular subject matter. So to me, this wasn't a hill for Bradl to die on, because
Or
the
to even
judge
climb.
basically told you, I don't really find it relevant.
Yeah, it's sort of like you might throw it out there for a jury and they might say,
Right.
if I were listening to it, it would have no meaning to me whatsoever.
Exactly.
So I agree. It's telling you what weight. But then in the end, when he allows them to ask the two questions, he kind of, kind of takes away the issue for appeal, because he just sort of said, well, I'll allow a couple of questions. And then when they didn't go anywhere, even if they appealed that issue, it wouldn't be prejudicial because he allowed it. So I think he's straddling the fence, knowing that, the appeal would be a Sixth Amendment appeal. So yeah, I agree completely.
Yep. And as a mother of beagles says, he knows the world is watching. So he might have just been asking those questions for the world that's watching, because he had to know the judge was having no impact on the judge. And guys, I'm going to try not to put up your comments because I don't want to block the judge's face. I tried to.
Please feel free to block my face. So.
All right. I tried to move you ahead of me, but the system won't let me, I guess. I don't know why. Tried to remove myself.
And Judge, I just want to, I don't know if you saw my message. I thought you and Allie were fabulous yesterday. So thank you. And thank you for being here again today.
Oh, well, thanks. Thanks for having me. I enjoyed being with Allie. It was, a lot of fun. Great questions.
It was great listening. I had a 6-hour drive and I was just listening to you guys, and I thought the analysis was amazing. So I'm real appreciative that you're here. Yeah. Your insight as a judge is invaluable. So
yeah.
Well, I appreciate that. Thank you so much.
Thank you. All right, let's go.
I want to circle back on a couple of things. You gave a recorded statement to the state police on July 3rd, correct?
Yes.
And we talked back and forth about your belief or your expressed intent to section her, and you said that wasn't the case, right?
Can you ask that again?
Yeah, you said that there was discussion about sectioning her, but that wasn't your thought process, or you didn't know about her or whatever, right?
When we discussed it, behind the school, it was brought up that she may not take this well. She may have to get sectioned. She was sectioned prior. So
here you're saying that it was a speculative possibility. Is that fair to say?
It could have been a possibility, depending on how she took the restraining order, respectfully.
Judge, if I may, I'd like to play a recording from the state police interview from July 3rd.
For impeachment purposes?
Yes.
All right, any objection? Okay, sure.
I'm going to pause it right there because I heard the judge sigh. Can you tell people what it was about that testimony that got you?
Well, I think, I have a lot of issues with the fact that in my view, they were treating this a restraining order very differently. We talked a little bit about that yesterday, aside from the fact that they allowed civil citizens, non-police civilians, and was one problem. But, there seems to me, based on the testimony, that there was a predisposition that she was going to go off the rails, as the expression goes.
Right.
They don't say it that way. But I do have a problem with the fact that they keep bringing up mental health, because most restraining orders, people don't gather and say, hey, there might be we might have to section this person. She was sectioned before, because what they don't say is that she was allowed to return to duty after an evaluation, and that evaluation made clear that she didn't have mental health concerns. So the notion that they were talking about sectioning her is concerning to me, because they were treating this differently than other cases. And the reason that they're thinking that, because they knew that she was allowed to return to duty, is because they were being fed information, there's already testimony that Justin was saying, hey, things could, get really bad. She could hurt the baby. She could kill the baby. That's the reason. You were asking about that earlier. Why? I forget your exact question, I think, Allie, that you had, why they were talking about this and why they were talking about sectioning her. They were talking about it not because they thought, she's been sectioned before, because they all know she was free to return to duty. But they were talking about it because, they were given information that made them think that she needed to be sectioned based on what Justin is telling them. So my concern all along in this case is what information was fed to them, that elevated the risk in that home. As a judge, I would be thinking about that. They went in there with an elevated risk.
Yep.
And see, and Judge, to your point, which is that for me, I'm a lot less concerned about it, considering that it's a bench trial. I'd be way more concerned about the way they've been doing that if this was a jury, because I think the judge is going to do exactly what you said. And I actually think that may end up helping them, because I think that the judge is going to see, all right, the things that were said and done prior to them even getting to that house in terms of what they were told by Justin or what they may have read with respect to it, put them in a certain mindset walking into that house. You know
Right.
what I mean? And the question then becomes, because, and I can't recall whether or not, and Judge, maybe, because Allie can't remember either, was it put into evidence yesterday that Kelsey was aware that Justin had arrived at the house, that he was at the house? Do you remember?
I don't remember if she was aware that he was at the house.
I do remember Daly saying that Daly saying that, or did Houston also somebody testified that she said, I don't want to see him. And Houston went downstairs to make sure they didn't interact. And that's where I said he told him to go to the basement. But it seemed like he was already going to the basement. He had asked to go to the basement to get that stuff. So I don't.
Yeah, you might be right. I don't remember. But I mean, I totally, agree that, this could help. And that's, I think, part of my point. And I agree with you, Bob, on that, is basically, they went in with a mindset, and I think that mindset, who set that mindset,
Right.
that basically made this restraining order, this TRO, very, very different than many others, in many ways, not only that way and with Justin. And just as an aside, before you go back, I think, if this had been a jury trial, the minute Noonan said, well, I thought that she was going to I thought maybe she was going to kill Justin, and that's why she was going to let him go, I would have declared a mistrial in about 30 seconds.
Yeah.
100%.
Understood. And I just want to say before we go back, I think that both the judge and I are kind of keep going back to the way that the restraining order was handled, not as it applies to this case, but to the trial here, but just being so upset about how it was handled and how it was handled wrong, and the whole sectioning thing, and for those of you who are asking, that's involuntary commitment for mental health treatment. That's what we mean when we say sectioning. The fact that he's thinking she needs to get sectioned, and the fact that, and I don't know if you saw this earlier, Judge, but him going back to how weird it was, and we mentioned this yesterday, why the hell they thought it was so weird of where her car was parked and why he's even taking notice of where his car is parked, all just goes to say, look, if you already think she might need to be sectioned, why didn't you handle it differently? Again, not for the purposes of the trial and whether Kelsey's guilty or innocent, but just how this thing was handled. When you think that, when that's a possibility in your head, just have her come to the police department.
And what makes it even more inexplicable is if that was their mindset going in, how do they have a citizen, and not only a citizen,
what
but the
Judge keeps saying.
guy. Well, I've been saying it since
Right.
before the trial started. Like, I didn't know he was in the house. And when
Yeah.
we were doing our coverage, I think of the final pretrial hearing, I was stunned to find out that that guy was in the house during the service of this restraining order, because it's inexplicable. So when you compound the fact that this guy is in the house and they had walked into that house with this mindset about that she might need to be sectioned, is incredible.
And she could kill somebody.
All of it.
And you're exactly right, you know, and I think that's, you know, we've been making that point that, you know, how was this handled by the police department, you know, because it's a very well-known fact, and we talked about this yesterday, that you never have a civilian anywhere near it, you know, if you can avoid it, you know, having civilians when you're serving a restraining order, you know, frequently, because I would read these when domestic violence cases would come in front of me and I'd had to remove children, you know, read the affidavit. The paramedics were told to stage on the next street over. So they don't even allow paramedics to go near there, especially where there's a potential for to be sectioned. And don't forget, what's the standard for sectioning, you know, in Massachusetts and everywhere? The standard for sectioning is that the person is either a risk to themselves or others.
Right.
And so, so just the mere
Due to
fact,
mental health illness, which, as you're
Right.
saying, they've already cleared her, like that her mental health illness was not a factor at that point.
but exactly right. But, you know, they're saying, again, the reason she's being sectioned maybe is because they have this information that she might try to kill them. So they're thinking, okay, we might have to section her because she's a risk to others. That's the way they're framing it. But if they were thinking that, then they have to also consider the second factor for sectioning, which is a risk to themselves, which then puts it in the suicide frame, you know, which is what she's saying. So,
Right.
you know, so it could work to her advantage. It's just, you know, and I'll just say this, you know, before you go back, the way this was handled, you know, in the service of the restraining order, it has so many violations. And the other thing is, if they all were talking about the fact that she could be sectioned and they knew that she had previous problems, why didn't they use their community liaison social worker? Why wasn't she there? They're talking about mental health issues. And the one person they don't bring is the community social worker with them. And there's a reason they didn't bring that, because they don't bring the social worker in if they think there's an elevated risk. And why did they think there's an elevated risk? Because according to the testimony, Justin told them that she could be dangerous.
But
yet they bring the guy who went ex parte and said whatever he said, and who they're literally ripping her baby away from and giving to that house. It's there is no explanation that will suit me in terms of why that happened. It's insane. That alone, in my estimation, created this entire scenario. His presence there and knowing that she knew, to me, created this entire situation. I don't know that what happened in that room happens in that room if Justin's not in that house.
Right.
I agree 1000%. And I will, you know, I'll never, ever be able to explain or get over the fact that, you know, they're serving a restraining order. They're talking about sectioning someone and they're allowing civilians, not only civilians, to be like waiting in their car for the baby if they were going to take custody, which actually should have been DCF or their community liaison, but they're allowing them in the house. And not only that, it's like, I mean, Justin's the person that has legal custody and they allow the sister there, you know, so it has the specter of giving them some kind of special treatment that no one else gets. And whether that's because there's a relationship between the police and firefighters, or there was a relationship, you know, with Justin, you know, who in later phone calls, as you know, was calling using their lingo. Hey, you know, I need to talk to the OIC. He would talk to the dispatcher. You know, there's the sort of the imprimatur there of some kind of special treatment.
Yeah, and Your Honor, to your point about the liaison being there, now correct me if I'm wrong, they could have had, like you said, the liaison staged, went into the house, secured the weapons before they take the child, before they secured the weapons, and
Yeah.
then safely brought the liaison in to act as to do what, you know, do the
Yep.
mental health side of things.
Yep, great point, and that's the way it should have been handled.
All right. And just, you guys know, a lot of what we're discussing, again, it doesn't go to whether Kelsey is innocent or guilty, whether they can prove their case here. It just goes to how upset we all are about how they handled this. And them creating the situation doesn't change whether she's, you know, innocent or whether they can prove their case. And as the judge said yesterday, and we went on before she got here, it's that first element of her intent is all that is in play here. And,
That's right.
and, you know, so, all right, let's keep going. Thanks, Your Honor.
Great. Call me Carol, by the way.
All right.
I told her we
need to
can't
mark
do
it
it.
for ID at least, unless you're seeking to admit it, but let's take it a step. We need to mark it for ID at least, unless you're seeking to admit it, but let's take it a step.
I'm just I'd be playing a prior inconsistent statement, Judge, for.
Okay, so
mark
we're gonna have to mark it for ID. I don't, do you have a mechanism to be able to do that? Is it on a thumb drive or something that can be marked? Tomorrow morning, just please bring in the recording that's being played and we'll mark it.
All right.
Taken out a restraining order.
Sorry, I blew too fast.
Fiancé had just taken out a restraining order, and we were there to serve it, confiscate her firearms, and then we were going to section her.
Ooh.
So that's what you said.
Wow.
On July 3rd, that we were going to section her, right?
Yes,
So at the time, you had it in your head that she was someone who needed to be sectioned, right?
if that's what I said in the statement, then yes.
In other words, somebody who was mentally ill and a danger to themselves or others, right?
Yes.
And that never panned out, right?
No, it didn't,
Because she was shot in the chest and went to the hospital for 53 days, right?
because she tried to kill me.
Oh,
Which is not what she's charged with.
yeah, again, mistrial, because she tried to kill me, so
Now, I asked
helping the prosecution.
Right. Right.
you earlier about whether or not you talked to Ms. Fitzsimmons about PTSD type symptoms. You recall that?
No, I don't.
You recalled me asking?
Oh, you
earlier
asked me,
today?
yes.
And isn't it true that you went on a call with her in August of 2024? That was a extremely difficult call involving a murder-suicide where the murder was of a baby.
Yes, it was horrific.
And you and Kelsey went to that call, right?
I'm with other officers, yes.
And you had shared some texting after that, right?
Oh.
Yes, I was being a senior officer trying to help out a rookie go through a traumatic event.
And your phone number, I don't want to give out the phone number, but it's fair to say that you had Kelsey had your phone number.
Yes, I think we were all in a group text.
And it's a 978. Just leave it there.
That's correct.
Okay. And so in that text, you said to Kelsey, relating to your past career, I spiraled down a rabbit hole, a very dark place. This happened years later in my career. We can speak in person about that. I have a guy I've been going to for years, like 10. And when I feel like I'm off, I call him, and all I have to say is, I need a tune-up, and he does me in. Right?
I don't recall that, but if that came from my number, then I had that conversation with her. I don't remember that at all.
All right. May I approach you?
Yeah.
And I apologize, I have to do this on the cell phone. This just came up this morning. I can show you.
Okay.
So I'm going to show you some of these two screenshots, first of all. First of all,
More evidence he's
That's
going to
a
mark later.
contact, and that's your phone number and it says Noonan, right?
That's correct.
Okay, so this is the text I want to show you.
Which one? This one right here.
Yeah. And you can scroll up and down if you want, but this is, the black part is you and the blue part is Kelsey, right? You can get some context.
Wait, I'm in blue?
No, you're in
Kelsey's
black.
Oh, Kelsey's
and
in
you'd
blue.
be in black, yeah.
So can I just make an observation? So you asked the witness about this particular text, about essentially that perhaps he had therapy and needed a tune-up, et cetera.
Yes.
He said, his answer was, he basically is not contesting the
Yes.
authenticity.
So then what are you doing right
So
now?
what are we doing? now?
Well, it's tricky, Judge, if from where I sit, it's tricky that when a witness says, well, if that's what it says, so I feel like I need to establish that's what it says, that's all.
Okay.
And
Fair
so,
enough.
He's right.
and
Yeah.
I think I can leave it there. Officer, is that what it says? What I suggested?
It does.
And so we agree that you communicated that to Kelsey?
Yes.
And we can agree that that's pretty personal stuff
Mhm.
to share with somebody that you say that you didn't know very well, isn't it?
Again, senior officer, she's going through a lot. I was just trying to be there for her. And that was one horrific call.
And we
you
agree
suffered from it.
that that's something that can create very profound bonding between officers when you have a common tragedy that you have to deal with.
Yes, but you move on. You go back to work.
And it can also cause post-traumatic stress, right? That's the type of incident.
Yeah, that's the implication. The implication is maybe he overreacted because
Right.
he had other trauma. I think that's where they're going.
Bring it home, though.
Yeah,
I'm gonna
exactly.
go back to the bedroom
Mm.
where Kelsey's on the floor and you stop holding the gun on her. You assist Lieutenant Daly with first aid,
Yes.
okay? And you were asked by the ADA, what did she say when she was on the floor? Recall that?
I
Just
don't
yes or-
remember
just
that.
yes or no, just the context of being asked that.
Maybe.
And see if this refreshes your memory. You said that she said, it hurts. She said, it hurts. I, meaning you, said, keep breathing. You have a baby to live for,
Yes.
right? And that was your testimony about what she said and what you said, right?
Yes.
And that was the truth?
Yes.
And that was the whole truth.
Yes.
Now, when you were in,
Now, let me ask you before he follows up, is that something you think you don't press him for? Why did you say that right there? You leave it for closing to argue. He said that right there because that was what was in his mind, that she attempted to unalive herself.
Well, I think what he's doing is looking to impeach him with something else that he said, to say, why didn't you say that before to the grand jury or to the state police?
Okay.
That's my impression about where he's
Where he's
going.
going. All right, let's see.
interviewed by Attorney Bennett.
Let me go back. Yep, you're right.
Now, when you were interviewed by Attorney Bennett of the CIC investigation,
Yes.
you painted quite a different picture, didn't you?
No.
You had something to add that made you look good, didn't you?
No.
You said to Attorney Bennett, if I could have one moment, Judge, I just want to get this exactly right. Just need a moment. all right?
No problem. Take your time.
I don't know if it's going to be helpful to get in something else he said that was helpful to him that he didn't say on the stand, but I guess we'll see, because he might be like, oh yeah, I did say that too. I forgot.
Yeah, maybe, or just that, his memory isn't as accurate as he thinks it is when he's testifying. It's hard to know until we hear how they're going to impeach him. This is that report that they fought over, right? The one from Dan Bennett.
I'm assuming so. Yeah. Oh, yeah. And where he's got the 80 pages, but not the actual recording.
Bennett's the former, I don't know, commissioner or secretary of public health. He actually worked in Worcester County for the DA's office. So if it's Dan Bennett, I had met him a few times. And now he does a lot of these investigations related to complaints filed against the police.
All right.
With respect to the CIC report, you did say the part that she was saying it hurt. I told her to just keep breathing. Do you recall that?
Sure.
You have a son, you know you want to be here for your kid. Does that ring a bell?
I didn't hear that.
I'm sorry. You have a son, you know you want to be here for your kid.
Okay.
You said that to Mr. Bennett?
If it's there, yes.
Then you added something quite memorable that you didn't say here in court. Isn't that correct?
You tell me what's in it. I don't know.
You said that she reached up, she grabbed my hand, I held her hand, consoled her, and then I asked her, why? And she stopped talking and just literally just looked right through me, death stare.
If
That's
it's there,
what you
then
said.
yes. If it's there, that's what I said.
And you didn't say that here in court today, did you?
I didn't remember. I totally forgot about that.
You forgot about something like that.
Mm-hmm.
Nothing further, Your Honor.
So, Judge, do you think, or Carol, do you think that accomplished a better, like that was more meaningful to establishing this guy's memory is not what it should be, or actually they should have maybe avoided it? It didn't help.
Yeah, I think, it didn't help. It does. The whole purpose is, you had this big long interview and you said this other stuff and you didn't say it here. So your memory's not quite accurate. That's what they were going for. I'm not sure how I would view that. I think it's a wash either way.
Okay.
I'm sorry. No more? You're done?
Yes.
Okay.
Even the judge is surprised he's done with his cross-examination. It seems there were so many other avenues that they could have gone down.
Yeah, I don't know if they're bringing things in through other witnesses or not. I definitely think they established, with what happened in that room, that there's some reason to believe that it might have happened differently. Was she on one knee? Well, how did she reach it? She was, an arm's length away from you. And he's like, no, it's 15 and then it's 7. I mean, I think that was probably the most, important part of the testimony. But I'm surprised that they ended it there.
Okay.
Redirect.
So I'm going to show you what's been previously marked as exhibit number 57. Is that a better picture of that
Yes.
area that you put the gun?
Yes.
That Officer Karp took?
Yes.
You also stated just during cross-examination that you knew Ms. Fitzsimmons had been sectioned before, correct?
That's correct.
And did you know that before the call?
I did.
Okay. And did that factor into how you were assessing the situation in the house?
Yes.
Did that factor into the team, you, Houston, and Daly, about the fact that you were never going to take your eyes off her?
That's correct.
Counsel had asked you about the first time you making a statement about what happened was July 3rd, correct?
Yes.
Did you tell anybody what happened before that?
Before
I didn't
July?
hear that.
Oh, sure. I'll say it again. Counsel had asked you whether you had the first time you made a statement about what happened in the room was July 3rd, correct?
Yes.
Okay. Did you tell Officer Corr what happened?
I did.
Did you tell Lieutenant Daly what happened?
I did.
Did you tell Officer Houston what happened?
I did.
What did you say?
I said she tried to shoot me.
Thank you. Nothing.
Well, that was hearsay.
Objection, Judge, that's hearsay. And I have a motion to strike.
Okay, it's overruled. Do you have recross?
No, no.
Oh, wow.
I mean, you're supposed to
I'm
object
not
before.
just to be clear, I'm not, Mr. Bradl, I'm not, I did not allow that last statement in for the truth, just for a state of mind.
Thank you.
And to rehabilitate as well. All right, no further questions for Officer Noonan from either side? I take the silence as a no. Before we move fast enough. All right, yeah, we can go to sidebar.
Yeah, so to me, the recross, should have been, I don't know how they missed that, but the recross is, you're aware that she was allowed to return to duty, correct? So she couldn't have been a risk to herself or others when it was time to serve the restraining order, because you knew she had been cleared to return to duty. I mean, I think that's probably the question I would have liked to have heard them ask. I just think, the reason that they did that on redirect is because they're worried about it. They're worried about the fact that they made all these predeterminations. And so they're trying to basically, prove that, they should be thinking that way. But I certainly think there was evidence, and maybe it will come in otherwise, that she was allowed to return to duty.
Right, but your point's well taken that they should have asked this witness, who was still testifying that I thought she needed to be sectioned. I was worried about her mental health, whether he knew she had been cleared for duty before. And I think yesterday he did ask him in the very beginning, did you know she had been cleared to start July 3rd or July 4th or something?
But they bring that up in their closing with the judge, saying, look, she had been cleared already. So, because, I mean, how much impact it has on what happens in the room is one thing, I don't know, but you're talking about him going into a room with her with the predetermined mind that, she's a risk to herself or others, which again asks the question, why was she allowed to go upstairs? Why was she allowed to go in that room and get things? Every aspect of the way they handled the service on the restraining order, in my view, is, disturbing to the point that it just doesn't seem to comply at all with the standard procedures for keeping people safe. And, this is something, that and judges have a lot of training on domestic violence, as I did. And there's a lot of information provided during those trainings as sort of what are the types of factors that can tell someone that there may be the potential for lethality. There's actually a graph, a bench card that goes through the kinds of factors that are considered, where there's potential for lethality. And those are given because you have to give restraining orders, and sometimes ex parte restraining orders. And so when people are talking to you on the phone in the middle of the night and they're giving you these things, and I'm having to make a decision about whether I'm going to issue an ex parte restraining order, I have to consider the potential lethality factors. And so, I just think that understanding how they handled this in terms of, okay, they're thinking she might need to be sectioned, which means she's a risk to herself or others, but we're going to let her just go up to this room and get some clothes and walk around the house before they get the guns. How it factors into the judge's decision, I don't know.
But to your point, it also clouds his perception, his memory of what happened, because those were the things already in his mind. She might kill someone. She might need to be sectioned. So when he's using that to his lens to perceive the events and recreate the events in his mind to report them, that is influencing him.
Yeah, it's easier, to say, I went in there and understood that this was an escalated situation. But, you know, because they knew her and they knew that she had been sectioned before, you know, his testimony is, well, that's what we were using. What they don't say, and, you know, they did, I think, bring it out in other ways, is that, you know, the information they were getting was the information from Justin, that
Right.
she was a risk. And to me, that's just absolutely unforgivable, unconscionable in the way they just took that information from him, didn't do anything
Didn't vet
further,
it. Right.
and just accepted it. You know, and it doesn't, you know, it's frustrating to think, you know, did it have to unfold that way? Okay, yeah, you can go up and get some clothes for the child, all of that. But I think they did a good job bringing in the fact that, you know, that they're the ones that basically said she could have been a risk to herself or others, because that helps Kelsey in the sense that, you know, that's such a consideration of sectioning someone who's a risk not only to others, which is the way they're looking at it, but it's also a risk to themselves.
Right.
So,
All good, great points. All right, let's see if the state's about to rest. Maybe not. Oh, I got another
Swear
witness.
that the testimony you're about to give in this cause now with hearing shall be the truth, the whole truth, and nothing but the truth to help you God.
Yes, I did. Thank you. Good afternoon. You can have a seat. Or I guess good morning still.
Good morning, Your Honor. If I may.
Yes, please.
Sir, in a loud, clear voice, can you please introduce yourself and spell your first name and your last name?
Good morning. My name is Officer Stephen Corr. Stephen spelled Steven. Last name is Corr, Corr.
And what do you do for a living, sir?
I'm a police officer with the town of North Andover.
And how long have you been doing that?
About 15 years.
Okay, what are your duties and responsibilities now?
I'm on patrol 4 to 12 shift. We respond to everything, 911 calls, domestics, motor vehicle accidents. If somebody calls the police, we answer.
Okay, I'm going to turn your attention back to June 30th of last year. You were working that day.
Correct.
Okay, at some point in the early evening, did you get a call to go somewhere? Or did you get a call that you decided to respond to?
There was a call. We had several officers involved in a document service.
Okay.
I was assisting another officer at a time with an arrest.
Okay, and the document service was a restraining order?
Correct.
Fair to say that was being served on Kelsey Fitzsimmons?
Yes.
Okay, did you know where she lived?
I did.
You did?
Yes.
I'm sorry. I was about to say I didn't hear your answer, but he repeated it. So you knew where she lived.
I do. Yes, correct.
We're having trouble hearing the gentleman too. If you could
Well,
just
I'm
try to
sorry.
keep your
Excuse me.
voice up. Thank you, sir.
Sir, you said you were on another call, correct?
Correct.
Whereabouts was that?
It was down the road on Waverly Road by the cemetery.
At some point, did you receive information that necessitated your presence at Ms. Fitzsimmons' residence?
After I had cleared that call with another officer, I had saw on the control board in my cruiser that they were getting out at that residence, and I started floating that way prior to receiving radio transmissions.
Okay. And before you got there, did you receive another transmission?
I did.
Okay, what was that?
I believe it was Lieutenant Daly had called off, and in the background, it was just a woman screaming and him saying shots fired.
Okay. And so did you head that way?
I did.
When you got there, was anybody else outside when you got there?
There was another person in a small red car that had pulled up next to me as I had gotten out. I spoke with her briefly about somebody running down the street with a child.
Okay. Had you seen that person running down the street yourself?
I did not, no.
So what did you do after you stopped?
After I stopped, I grabbed my med bag and I radioed up to Lieutenant Daly. I said, where are you, sir? And he answered me on the radio, said, upstairs. I think he said upstairs.
Had you ever been in that residence before?
I have not, no.
Okay. So where did you go?
I went in the porch on the left side, went in through the front door. I could hear a female screaming. I think I went inside and asked her, where are they? And she said they're upstairs. I went upstairs, and there's a weird kind of layout of the house where you come in the front door and the stairs are right behind it.
Okay. Now, you said the woman screaming. Was that the woman downstairs was screaming?
Woman downstairs, a living room, family room on the left, yes,
Okay. You went upstairs.
correct.
When you got upstairs, what did you see initially?
I got upstairs, there was a landing way with a left exit and a right exit. There was 2 doors. I could hear commotion on the right side, so I entered that doorway.
Okay, and who did you see when you entered that doorway?
I saw Lieutenant Daly, I saw Officer Noonan and Officer Houston.
What were they doing?
They were performing first aid, rendering aid to Ms. Fitzsimmons.
At some point, did Officer Noonan ask you to do something?
He did.
What was that?
He pointed right where his hand had been, and he said, secure that firearm. And I had looked down, there was a firearm sitting on I want to say a white-looking bookshelf.
Okay. Was that near the door?
Correct.
Am I wrong? Is this not the mental health liaison?
I think from what I read on the North Andover site, I thought it was a female, so I'm not
All right, I'm
really
going to edit this until we know for sure.
He said he's a police officer in North Andover, right?
Yeah.
Yeah. The community person that they hire, I think, is a separate social worker. I don't think it's a police officer, but I'm not sure.
All right. Thank you. I'll fix that. All right. Let's keep going.
Can't find that picture right now. I'm going to show you what's been previously marked as exhibit number 57. Do you recognize that?
I do, yes.
And what is that?
That was where the firearm was located, on top of the white-looking bookshelf. I guess it's not a bookshelf, but
So this is the room you entered, correct?
correct,
And this is the door you went in?
correct.
And is this the area where the gun was?
That's where the gun I saw was, yes.
Okay. And so you didn't know anything about the gun at the time, whether it was loaded or not, right?
No, I did not.
Okay, so what did you do?
I had gloves on at the time. I picked up the firearm. There was a small black box on the bed. I saw that was an open box where I could store the firearm because I knew paramedics and fire department was going to be coming in that room. It's not a huge room, so I wanted to get it out of the way so it wouldn't be trampled, wouldn't be disrupted or anything. I took the firearm. I looked at the box. There was nothing in it. I kind of did one of these motions to make sure there was nothing in it, put it down. I dropped the magazine out of it.
And what does that mean, dropping the magazine?
I hit this release button on the side of the firearm. It takes out all the bullets that are in the magazine.
Okay. Bullets stay in the magazine.
The bullets are in the magazine, correct? And then after that, I racked the slide, had it sideways, and I emptied a round out of the chamber into that box.
Okay, so there were a magazine with a number of bullets in it.
Correct.
The one round or bullet was racked into the chamber itself, correct?
Correct.
And then did that go in the box?
That went inside the box.
And what did you do with the firearm itself?
The firearm, I put everything in the box.
Okay.
And then brought it outside of the room.
May I approach, Your Honor?
Yes.
I'm going to show you a picture and ask if you recognize what that is.
Hold on a second. So this
is
image.
not agreed to, so it's a picture that.
Okay. All right. My question was, you just answered it by your movement, was whether you wanted me to look at what was on the screen.
No.
All right. So you've handed him a photo.
Do you recognize what that is?
I do.
What is it?
It's the box that I placed the firearm on the ammunition in.
Okay, can you see the firearm, the magazine, and the round itself?
I can.
Okay. Where is the pic? What did you do with the box after you placed the items in it?
Like I said, it was a small room. The landing that was at the top of the stairs, I backed up out of that, and I put the box in the corner away where I kind of stood over it, made sure nobody messed with it as the fire department came up and down for medical aid.
Thank you. I brought right on. This picture is next exhibit.
Any objection?
No, Your Honor.
Okay. It may be admitted.
Exhibit 80, so marked.
If I may trouble.
Please.
Is that in the position where you had placed the box itself on the landing?
Yes.
You said you stood guard over it. Until when?
As they were doing render and aid, Officer Noonan backed out of the room along with Officer Houston and I believe Lieutenant Daly. As she was being removed from the room downstairs, there started to be some issues. I asked Lieutenant Daly, who was standing next to me, I said, do you want me to go down and make sure the fire department's all set, putting her in the ambulance, make sure nobody interferes with that? And he said, yep, I'll take watch over the firearm. And he basically stood over it and made sure nobody, after I had left.
Okay. When you initially went into the room and you saw Ms. Fitzsimmons on the ground, I'm assuming?
She was blocked my view. I could see feet.
Okay.
I assumed that was her. Once everybody kind of moved out of the way and I walked in, I said, what do you guys need for help? They already had a med bag up there, but she was on the back side of the bed.
Okay. Where was Officer Noonan after the fire department left?
Standing next to me in the hallway, the landing area, I want to call it.
Did you do anything with regards to him? Did you make any observations?
I asked him if he was good. It's basically me making sure he's okay. Adrenaline's rushing. As I came up the top of the stairs, there was a little glass door on the left, and it looked like there was like a pinhole through it. I thought he might have been shot at, so I asked him, "Hey, did she get a round off on you?" And he
object.
basically, I don't know.
Overruled only because it's been admitted and it's of marginal relevance. Just to explain the scene. Sure. Cross?
All right. That was that.
Nothing.
Why they called him after Noonan, I mean, I guess it doesn't matter with the judge. You're not as worried about the showmanship of it and ending.
Cross?
Thank you, Your Honor. Thank you, sir.
Yes, take your time.
Good afternoon.
Now, I'm sure that you memorialized all these important facts you testified to in a police report somewhere.
No, we didn't generate a police report at that time, no.
Well, I'm not
That
asking
time?
if we did, I'm asking if you did.
I did not know, sir.
Oh, sorry.
Only because to make sure that the audio gets picked up.
Everything you testified to was not memorialized by you in a police report, correct?
No, I did not read a police report, no.
Wow. Yeah.
Now, also, you weren't interviewed until 30 days after this incident, correct?
Interviewed by who?
By
Anyway,
the state police.
I don't remember the exact time frame.
Isn't it true that you were interviewed on July 30th?
I don't know the exact date. If that's what you say it is, then I assume you're giving me correct information.
I appreciate that. You were also working with Officer Noonan, correct? At the time-
I work
in
with
that
him as a
time interval?
coworker.
Did you work with him in that time interval?
From when the
Incident
incident
to the
happened to
30th.
July 30th,
July.
he's on a different shift, but yeah, I do work with him.
And did you speak with him about the case?
I don't recall if we did. I'm sure we had talked at some point about if he was okay.
Did you speak to him about what happened at the scene? Just yes or no?
At the scene we did, absolutely. We were on the same scene.
Okay. And did you speak with him in the days following?
I couldn't tell you. I'm sure we at some point talked.
And what about prior to your state police interview?
I'm sure we talked at some point.
So you spoke with him at the scene, spoke with him probably shortly after, and spoke with him prior to the interview as the interview approached. Is that fair to say?
Yes.
Thank you very much. Nothing further.
Anything you got?
No.
Okay. All right. Thank you, officer. You may step down.
You're welcome. Thank you.
Commonwealth, you can call your next witness.
As far as now, hearing shall be the truth, the whole truth, and nothing but the truth to help you God.
I do.
Thank you.
You may have a seat. Just pull yourself up to that mic. Thank you.
May I?
Yes, please.
Good afternoon, sir.
Afternoon.
In a nice loud voice, if you could please state your name and spell your first and last name for the record.
Sure. My name is Detective Lieutenant Michael Bonasoro. Last is spelled Bonasoro.
How are you employed?
I work for the Mass State Police.
And what is your current assignment?
I work for the Firearms Identification Section.
How long have you worked for the Massachusetts State Police generally?
Almost 20 years.
If you could give us a brief recitation of your assignments within the state police?
So I should have paused it right after that last witness. What did you get from the state Commonwealth calling him, the significance that he added that other witnesses didn't, if anything?
I didn't get much from him at all, but what I did get was that you have an officer who's at a scene of an incident with a shooting, has some role in it, and especially getting the firearm, and didn't write a police report. I'm actually shocked by that. I don't think I've ever seen that in a case. I mean, basically, there should be a packet of police reports from everyone that was at that scene. So I'm not sure, how things are operating there. But, to this day, here you have this guy testifying, and there's no police report for the lawyers to go back to. And
he had an actual role. I mean, he secured the weapon. He did whatever.
A role.
Yeah.
And no police report. I'm stunned by that. The question I would have asked is, isn't it, in your police department, whenever you respond to a scene, isn't it policy that you ought to provide a police report that must be reviewed by a supervisor and approved by the chief? They didn't ask those questions. They did ask about the police report. I was very surprised about that.
Yeah. All right, let's go with the firearms expert.
Yeah.
Probably going to be just identifying it and moving on, but
yeah, I mean, I don't know that you need his credentials, but I'm sure he's credentialed. But
Assignments are what I'm doing now.
Start from when you graduated from the academy, briefly.
we're going to blow past that.
yeah, I agree. Get him to take
Abilities as the detective lieutenant in charge.
So I look at training, make sure we're up to accreditation standards for lab programs, semi-automatic pistols.
Over the years with respect to firearms.
We're going to get to him at the current involvement in this case.
Yes.
Try to.
And one of the components of ammunition is projectiles.
Correct.
And you've examined estimate how many projectiles over the course of your career?
Thousands.
And how many scenes have you responded?
Okay.
Firing pin will strike the primer. Primer will ignite the powder inside of the casing, which holds everything together. Once the gases build up from the burning of the powder, the projectile will leave that casing.
All right. He's just telling you how firearm examination works.
And is it fair to say that when a cartridge or when a...
Sure.
And that's the stamp that reflects
Back up to hear what the judge asked.
the caliber of ammunition?
The caliber as well as the manufacturer.
When a casing...
But it deflected off another object.
Okay, wait a second.
Based on where a casing or casings are recovered.
You can't really determine the exact location. It should land in the general vicinity of the shooter, but you also have variables if that casing was kicked or manipulated in some way, or if it deflected off another object.
Is that what you're going to say now?
I think we just talked about this, but what does caliber refer to?
Caliber is the diameter or length of the trigger pull per firing of that weapon. So you pull the trigger, it will cause either a hammer or a firing pin to move forward. Will strike the primer. After it strikes the primer, it will cause an explosion. Explosion is going to cause that slide to go backwards. The extractor is going to extract that casing, which is attached to that slide, It's going to hit what's called an ejector. The ejector is going to extract that discharge casing out of the ejection port, and it's going to continue the cycle. This slide is going to move forward now because it's under spring tension. It's going to pick up that other live cartridge that's in the magazine well and load the next live cartridge.
But does the user have to do something first before they are able to pull the trigger and have a projectile fire?
So they would have to load either manually or with a magazine. So a live cartridge has to be inserted into the chamber.
And does the slide, or does the slide have to be pulled back?
The slide has to be racked to the rear, yes.
Okay. And so the slide has to be racked to the rear just one time before the shots are fired?
Yeah, so you have to essentially cock the firearm. So you have to put some external force on that firing pin or that striker to hold it in place. When you pull the trigger, you're going to have that transfer bar or that trigger bar, whatever you want to call it, will actually drop. We'll engage that trigger bar or that striker to move forward and move past the aperture, which is the circular portion, and right in front of the primer that sits in front of the chamber. So all these things have to happen, but initially you have to have a cocked firearm for it to happen. So you have to load that live cartridge and put some external force on that slide to cock it.
And is cartridge synonymous with magazine?
Cartridge versus magazine. So a cartridge would seat in a magazine.
So the cartridge holds the projectiles or casings in the magazine?
Yes.
Okay. And what part of the gun is the magazine?
So it's an external piece that's inserted into a magazine well.
So a user would take the magazine, enter a cartridge which contains the bullets, and then seat it in the handle of a semi-automatic weapon.
So the person would load the ammunition inside of the magazine. The magazine will have a spring tension as well as a follower on top. That spring tension pushes that live cartridge to the top of that magazine at all times. That live cartridge is stripped by the slide or manipulated by putting that live cartridge in the chamber manually, but ultimately you do have to cock that weapon to fire it.
I'd like to direct your attention to June 30th
There we
of
go.
last year. On that date in the evening hours, did you get called to go somewhere?
I did,
Where did you get called to go?
to a residence in North Andover.
What information did you have when you arrived?
Information I had was there was a police-involved shooting, which required a supervisor to attend the scene.
And that's why you went?
Yes,
What time did you arrive?
I don't recall exactly what time. It was in the evening hours.
Did anyone else from your unit respond?
Yes, I had a trooper, Chris Pierce, as well as trooper Andrew Valeri.
And the three of you responded from the firearms identification unit?
Yes.
And what was your purpose on scene?
We wanted to document the scene. We wanted to inventory all personnel that were involved in the shooting, whether they fired or not, to inventory their weapons, to account for all live cartridges.
And again, is that standard procedure for an officer-involved shooting?
Yes.
When you responded, who was on scene?
There was several detectives from the Essex County Detective Unit, as well as Andover police personnel.
North Andover police personnel?
North Andover, yes, Mike, sorry.
Were you directed to a particular part of the house?
I was. There was a particular part on the top of the stairs where there was a firearm located in a safe, as well as a bedroom where we recovered two discharge casing as well as a projectile.
And did you or someone from your unit or someone from the state police take photographs that evening?
Yes, we had Crime Scene Services photograph the scene.
And what is crime scene services?
So they're a unit in Massachusetts State Police. So they document, they photograph the scene, they videotape the scene to preserve the scene, as well as do prints on firearms casings and so on, as well as footwear impression markings.
May I approach?
Yes.
That you take a look at those, and let me know when you're done.
Counsel, Mr. Bradl, will the defense be objecting to any of these?
I don't know what counsel has up there.
Okay, thanks. When you're done, when the witness is done, if you can show them to Mr. Bradl, and if, to the extent that you were able to mark a few.
Speed
and
this up,
you can object
right.
to a few, or all of them. Or...
You're supposed to hand them to the defense attorney, but you go up to the witness and just say, hey, I'm going to put these in, because then what happens
Take
is
your
it's
time, Mr. Bradl.
happening now. You know, it's like she shows them to him, do you recognize these? And then he says, Mr. Bradl, have you seen them? It's like, no, I haven't seen them. I mean, the standard procedure is, you know, you take your document, you go over to the defense side and you say, these are the pictures I want to admit, you know, do you have any objection? Or at least give them the opportunity to tell the prosecutor, I'm going to object. And she kind of did it backwards. It just takes a little longer this way.
Right.
I understand there's no objection.
No objection.
Okay, let's have Mr. Wayne mark those individually. Yes, please.
Sir, I'm showing you first what's been marked as 81. Do you recognize that picture?
The picture dictates plaque number 3. I believe there was a discharge casing around that vicinity of plaque number 3.
Sir, what number was that again?
81.
81, thank you.
Is Exhibit 82 a different angle of that same, you were trying to photograph that same discharge cartridge casing?
It is.
Showing you Exhibit 83.
But that was just 83.
Picture 83 show.
Discharge cartridge casing with the closer up appearance.
Has it been moved?
I believe it has been moved.
And why would it been moved?
Where it was located was kind of in a confined space in the corner of the room.
Showing you Exhibit 84. Do you recognize Exhibit 84?
Yes, it's where a sprint projectile was recovered right above the air conditioning unit inside the curtains.
Exhibit 86.
I'm sorry, can you just give me a moment?
Sure.
Just step up.
Do you need the picture?
Yeah, do you mind putting that back on? Thank you.
What does picture 80, Exhibit 86 show?
It's a close-up picture of placard number 4 of that sprint projectile that was recovered in the curtains.
And showing you Exhibit 87. What does Exhibit 87 show?
The projectile from placard number 4 that was moved for a close-up photograph.
So it's taken from the air conditioning unit and moved for this photograph?
Taken from the curtain and moved on, I believe, the bed, taken a photo of it.
Showing you Exhibit 89. What does Exhibit 89 show?
It's where a projectile possibly struck. We looked at the air conditioner inside and to the rear of it. They had a hole consistent with a strike on the outside of that air conditioner. Can't determine exactly, but it appeared to be a projectile strike, and there was another hole on the exterior or the back end of that air conditioner as well.
And is that what Exhibit 88 shows?
Yes.
And did you ever find a projectile associated with this air conditioner, the one that struck the air conditioner?
I did not.
That last photo down there, is that 85?
88.
I'm sorry, 88? Thank you.
So I'm assuming what happened is that the projectile went into the curtain goes back, strikes the air conditioning unit, but then it locks it in to the curtain. Because I was kind of wondering, I mean, why wouldn't it have gone through the curtain? So that's what we've got to assume happened. Would you?
Yeah, I think so. Yeah.
Okay.
Detective Lieutenant next showing you Exhibit 76. Do you recognize what's depicted in Exhibit 76?
It appears to be another discharge car's casing by placard number 1.
And is Exhibit 77 a close-up of that discharge cartridge casing?
It is.
And what did you do with the discharge cartridge casings and the spent projectile that you recovered from the scene that night?
So all pieces of evidence were documented, where they were located by placard number, the time of location, who recovered that evidence, and any particular features of that discharge casings, the head stamps or bundle marks.
So you collected the evidence and documented it, fair to
Yes.
say? And is it, in summary, fair to say that you recovered 2 discharge cartridge casing and 1 spent projectile?
Correct.
Sorry, I was distracted. Can you ask that question again?
Sure. In summary, is it fair to say that you recovered 2 discharged cartridge casings and 1 spent projectile that night?
That's correct.
Thank you.
Did you continue your search of that bedroom?
I did.
And what else did you recover from that bedroom?
I don't believe there was anything else from the bedroom other than the 2 discharge casing and the projectile.
May I approach, Your Honor?
With what?
Yes.
She's doing the same thing.
Let's
Show it to the.
we'll take a 5-minute recess.
All rise. Let's do a 5-minute recess.
Good thing we've got blooping time.
Inspect.
Yeah.
Did.
Court is in session, please be seated.
We're back on record on the Kelsey Fitzsimmons.
Thank you. Detective Lieutenant, is it true that you took possession of a number of firearms the night of June 30th, 2025?
I did.
And whose firearms did you collect?
There was 2 North Andover police officers' firearms and another firearm that was recovered at the top of the stairs at the residence.
And the 2 North Andover police officers, was that Tim Houston and Patrick Noonan?
Yes.
And did you also inspect Lieutenant Daly's firearm on scene?
I did.
And what did you determine with respect to Lieutenant Daly's firearm?
He had.
This almost only happens in Lawrence. But the window's open over here, which is what we need for, because of our HVAC, but I'm having trouble hearing. Do you mind closing that?
It sounds like she had to go back and lay a little foundation
Sorry,
for
you're
what
gonna have to repeat the
picture she was going to
last
get in.
question and answer. I didn't-
Yeah, again, it's hard to know if she's, getting an agreement from them ahead of time, putting them in front of the witnesses, which is what you're supposed to do. It's hard to tell. It was easy on the first
Sir,
one.
what was your finding with respect to Lieutenant Daly's firearm?
He had 1 magazine, so he was fully loaded. There wasn't any unaccounted for rounds of ammunition.
Okay.
Wait, I'm confused because I thought you took Officer Houston and Officer Noonan is what I wrote down, but is that?
Fair to say you took Officer Houston's the firearm and Officer Noonan's firearm?
Correct.
And did you take Lieutenant Daly's firearm?
I did not.
Did you just examine the number of bullets in his magazine?
Yes, I,
Well, she's leading because the judge was distracted by the outside noise, so, and I'll allow you to do so as well, Mr. Bradl. So overruled. All right, so now I understand. Thank you.
And sir, I'm next going to ask you if you recognize what's shown in Exhibit 10.
yes, that is the firearm at the top of the stairs, as well as a magazine with numerous live cartridges in it, as well as one loose live cartridge.
Is this the loose live cartridge here?
It is.
I'd like to ask you about your major findings in this case. Based on your training and experience, did you conduct microscopic analysis with respect to the projectile and cartridge casings that were recovered from the bedroom of Phillipsbrook Road?
I did. So I test fired all three weapons and conducted a microscopic examination of the class characteristics, as well as the individual markings that were left behind from the firing process. I was able to conclude that the weapon that was fired by Officer Noonan created the discharge casings that were recovered in the bedroom, as well as the spent projectile that was recovered above the air conditioner.
And were you able to exclude any weapons?
I was able to exclude the other firearms.
I'd like to change gears a little and talk about the weapon that was recovered from the black safe at the top of the stairs. Did you do anything with respect to that gun?
I test fired that weapon with 2 live cartridges from submitted ammunition.
And what was your conclusion?
That weapon did not fire the discharge casings, as well as the projectile that was recovered.
So the gun from the black safe was also excluded from the discharge casings and the projectile that were recovered from the bedroom?
Correct.
But did the gun operate?
It did operate, yes.
Was there any problems with its operation?
There was no malfunctions.
Did you bring with you today a box?
I did.
And what is contained within that box?
I believe it was the that Glock firearm that was in question that was recovered at the top of the stairs.
Is that box packaged in the standard way that the ballistic unit packages firearms?
It is.
If you could open the box and explain what is in the content, what's contained within.
Later. All right, we have a trigger lock that was provided later. We have the firearm in question. It's safe and empty. There's nothing in the chamber. The slide is locked back to the rear. There's nothing in the magazine well. The weapon safe is safe and empty. Also, contents of this is you have the 2 magazines that were recovered from the vest that were downstairs on the first floor of the residence. You have the magazine that was recovered in the safe. It was originally loaded with 16 live cartridges.
Why is it open like that?
And you have 2 test fires that conducted using that live ammunition from that magazine, as well as the single loose live cartridge that was recovered in the safe.
Are you going to ask more questions about that? Because I couldn't keep up. Or should I have them repeated?
No, I will ask.
Okay, thank you.
But in the meantime, may the box and the contents be marked for as an exhibit?
Yeah, let's. We're gonna have to do them individually. I don't want the ammunition to be with the firearm. So let's do that, Mr. Ruane. And also, any objection if he puts, Mr. Bradl, if he puts the trigger lock on there?
No, Judge.
I don't know, are you able to even?
Object to the meeting either for this. I don't object to any meeting for this.
Good for
I
him.
would ask that you just wait to
Sure.
put the trigger lock on, certainly before it's submitted.
Sure. Thank you.
How about we do the gun in the box and then the rest we can tag individually?
Sure.
See that one? That one's all
With
open.
the ammunition,
Look at that.
is it, with the ammunition?
Yes.
Okay.
Covering that it's open.
Yeah, they're just gonna mark those individually, which is the right thing to do.
Magazine was in 5.
The magazine that you recovered from the gun in the black safe, what was the total capacity of that magazine?
17 live cartridges.
And is that how many live cartridges that weapon can hold?
That's how many cartridges the magazine can hold. So what's called a top-off method. So you'd load the magazine with the 7 live cartridges. You would chamber around. You'd take the magazine out of the magazine well, and then insert another live cartridge. So essentially, the magazine will be fully loaded with 7, and then there will be 1 live cartridge in the chamber.
So you said 7, not 17.
My apologies.
I thought he said 17 too.
He did say 17.
You mean 7, right? Not 17?
7. The magazine is 17 live cartridges capacity.
17
17.
is the capacity. Okay.
17 is the capacity for the magazine that was recovered from the black box.
Correct.
And so when you add an extra round, what's the capacity for the weapon itself?
So we'd call it 17 plus 1. So essentially 18 live cartridges.
So getting back to that, in that black box, in this, I'm showing you Exhibit 80. Exhibit 80 is the gun, the magazine, and the single live projectile that is contained within the box in front of you. Is that correct?
Yes.
Okay. And when you examined this firearm, how many bullets were in the magazine?
There were 16 live cartridges in the magazine.
And how many live projectiles were in the safe?
There was 1 loose round live cartridge in the safe.
And that is reflected in the 1 loose round cartridge. That's in Exhibit 94, is that correct?
Correct.
Are you familiar with the term dry fire?
I am.
What's that mean?
So you are cycling the weapon without a live cartridge in the chamber. So all the same steps are going to happen. You're going to cock that weapon. It's going to have that trigger bar or that striker be sent to the rear. It's going to be held in tension by that trigger bar. When you depress the trigger, it's going to create that trigger bar to drop. The firing pin is going to move forward through the aperture and potentially strike any live cartridge that's in the chamber.
And what happens if there's not a live cartridge in the chamber?
So you'll hear an audible click.
With the court's permission, may Detective Lieutenant demonstrate?
Any objection?
No.
Demonstrate
A dry fire with no projectile in the weapon at all, no projectile particularly in the chamber.
Yes.
So if you could stand up and demonstrate.
All right. Again, there's nothing in the magazine well, nothing in the chamber currently. So the weapon currently is cocked. You've moved the slide forward, still in the cocked position. You still have that trigger bar, it's moved backwards. And then when you pull the trigger, you'll hear an audible click because it's releasing that striker. That striker is going to move forward and hit where the aperture where the firing pin would protrude. So you'll hear the click. And in order to reset it, so right now you have a dead trigger, it's not going to do anything. Again, pull the trigger, audible click. And that's what you'll hear. If you have nothing, if it's halfway, you'll have a click as well. So if it's not all the way chambered, it'll click as well. So what we call it is out of battery. So the weapon is locked to the rear. You'll have the slide forward. Now the weapon is battery. So you have an enclosed live cartridge. There's nowhere for that live cartridge to go when it's fired, but out the barrel.
And I'm sorry, the term that you used, batteried?
It's out of, so once the live cartridge is loaded, that weapon is now in battery. So you have the breech that is right behind that live cartridge. So when you fire that weapon, an explosion is going to happen. So you're going to have the firing pin is going to hit that primer. Primer's going to ignite the powder. Powder's going to build up gases.
Just talk
Gases
normal.
Go down simultaneously. You're going to have an explosion, which is going to cause that slide to go backwards. The extractor is in contact with that live cartridge. It's going to rip that discharge casing out. It's going to hit the ejector, which is pretty much a metal rod, and it's going to eject out this ejection port, which is right here. There's an ejector right in there. An extractor is like a little claw that's attached to that rim of that live cartridge or that discharge cartridge after firing and pulling it right out. All one function, and then that slide is going to go forward and load the next live cartridge.
Thank you.
So based on your training and experience, would you hear that click if there was a loaded magazine in the weapon, but no bullet in the chamber?
Yes.
And based on your training and experience, what would happen if the gun was cocked and there was bullets in the magazine and you pull the trigger?
If there wasn't any live cartridges in the chamber, nothing would go off. You'd hear a click, but nothing would go off.
And then how would you get a bullet to go into the chamber?
You'd have to physically, manually load that bullet or push that slide forward to load that live cartridge from the magazine.
May I have a moment, Your Honor? Thank you. No further questions.
Before we go to cross, is there anything you want to say about that?
Yeah, I mean, it's important testimony and you have to have it. I always found it really hard because I just didn't have any background, with firearms, and the charges that I would be hearing were possession of a large capacity firearm with something loading or whatever. And so, so when you're hearing in a trial, I always think back to when I was a brand new judge and listening to a firearms trial, and I had an expert like him and sort of picked up the gun and was kind of surprised at how heavy it was. And then when the jury was deliberating, they wanted to see the gun and the magazine and all that, which they had a right to do. But I remember as a new judge telling the court officer, did I send the gun and the magazine into the jury room at the same time? Can you just go and, take the magazine out? And if they want it later, I never made that mistake again, but just something I remember from being a judge. I think, his testimony is necessary. The lab that they use, the ballistics lab that he's talking about, which is in Maynard and maybe in Sudbury now, they invited a group of judges, and I was one of them, to go and see how they process evidence. And one of the parts of it was to go into that ballistic lab to see how they do it. So it was really helpful for future cases to know about that. But I think they're probably getting close to a break anyway in the case at this point, because they always break.
Do you think it's strange that they didn't ask him the mechanism of the tap and rack and what's happening?
I think that they probably feel that Noonan described it well enough, so that they didn't have to do that. Maybe on cross. I'm not sure how much they're going to ask on cross, except maybe about the placement of the casings.
Right.
Because the casings fall very close to where the gun goes off, because the casing just comes right out. That's generally, and I think that's what he said.
Okay.
I'm no gun expert for sure.
Right.
Lieutenant Detective Bonasoro, do I have that right?
Detective Lieutenant Bonasoro.
Bonasoro, nice to meet you. We had never spoken before, correct?
Correct.
So What's a head stamp on a cartridge?
It's the indicator that tells you the caliber and the manufacturer.
Was that something that you took note of for all the cartridges in this case?
Yes.
And and you can look at any of your reports if you like, or anything you need to look at, you can just let me know. Or you can just go right ahead and do it. Do you have your reports with you?
I don't have them with me, no.
Okay. And let me know and I can show you. In this case, relative to the spent projectiles that you recovered and the loose round you recovered, did you check the head stamps of those?
All head stamps were recorded on all evidence, yes.
And they're on your ballistics worksheets, right?
Yes.
And if you need to look, just let me know. All the head stamps for all these cartridges were the same, right?
I believe so.
It was Hornady 9mm.
Yes.
Okay. And so just out of an abundance of caution, I don't want you to believe so. I want you to look and just tell me. Is that all right?
Yes, that's
I'm pretty sure I'm giving you everything. And if I don't, just let me know. And I have 3 ballistics worksheets here. May I approach, Ron?
Yeah. And then, just so I'm clear, Mr. Bradl, the question is whether all the ammunition recovered had the same head stamp?
Yes.
Okay,
Correct,
thank
Your
you.
Honor. So with respect to, actually, I should qualify that a little more, Your Honor.
Sure.
The question was the 2 spent projectiles and the loose round. Do they all have the same head stamp?
The 2 discharge casing as well as the loose live cartridges all have the same Hornady head stamp.
And I apologize, and you just corrected me. I said spent projectiles. So that's wrong, isn't it?
Correct.
So I should rephrase that, Your Honor. The 1 live round, live cartridge, and the 2 shell casings all had the same head stamp. Correct. Thank you. And I said that right that time, right?
Yes.
All right. I'm just going to retrieve those from you.
Sure.
As a state police detective, you go to various towns and you investigate ballistics evidence, ballistics issues at various calls, right?
Yes.
And oftentimes you get there kind of well after the fact of the incident, right?
Correct.
And in this case, I know you don't exactly remember the times, but let's break it down a little bit. How long did it take you to get to the scene, if you recall?
Probably over an hour to get there. I was traveling from Maynard.
Okay, so Maynard to North Andover, and it's was it dark out when you got there, if you can recall?
I don't recall exactly what time I got there.
Okay, it's fair to say that the scene was secured and there was no there were no civilians around. It was a crime scene that was in the possession of police.
Safe to say there was a secure scene, yes.
Okay. And you saw colleagues from the state police that are assigned to the state Essex Detective Unit, right?
Correct.
And you also saw some North Andover police officers as well, correct?
Yes.
And it's fair to say that the North Andover police officers were having free reign over that scene when you were there?
I wouldn't call it free reign.
Well, nobody was keeping them out of there, right?
I believe they had a log of who was going in and out, but it's not my responsibility to keep track of who's in the scene.
Certainly not. And you oftentimes don't have personal knowledge of what goes with what cartridges from what gun, things like that.
Correct.
And you often have to rely on what people at the scene tell you.
Yes.
Yeah. And then you can also, however, apply your science and figure out to a reasonable degree of ballistic certainty what the relationships of certain projectiles, cartridges, and firearms are, right?
Yes.
And in this case, You don't have any personal knowledge of the chain of custody of these various firearms, do you?
What was recorded in my notes of who I recovered these firearms from is all I can.
Well, we can start there and we'll go through it. So you wrote a report. And again, if you want to look at this, just let me know. You wrote a report that involved 3 Glock firearms, right?
Yes.
Okay. And actually, it might be quicker, Judge, if I give him one of these, so I don't have to keep going back and forth with that.
Do you think that now's a good time to break for lunch? Do you think?
Sure,
And then,
that's fine, Judge, and I'll have the paperwork for him, and we can just go without having to go back.
Yeah, maybe let's do that. So we'll stand at recess and let's start back up at 5 of 2.
Should we have him put the gun lock on?
5 of 2.
Should you put the gun lock on?
Yeah, do.
Okay.
All right, we're going to put the lock on the gun. They're going to be back at 5 of 2. So what is it that you hope to see on the cross-examination?
You know, it's really hard to say. I don't know where I think their argument is might be a chain of custody thing here, and that, you know, casings and bullets, I think the implication is whether or not things were moved to make the scene look more like, Officer Noonan described it, as opposed to something else. So I think they're going to go in that direction. I'm not sure how they're doing it, but basically what they're already saying to this state trooper is you got there afterwards, so you have no idea, where these casings were before you got there. You have no idea if things were moved, and you also have no idea where the gun was. There's been varying testimony that it was found sort of under her, or it was moved. So I think that they're moving in this direction, that, the chain of custody makes a difference, because it relates to, essentially it relates to how things were fired in that room and how far away people are. So I think that's probably, all where they're going. I think, just to let you know, because I see the people saying, oh, he should be charged, that Noonan should be charged. He's already been cleared, so that's not going to happen. He's not going to be charged. He's already been cleared, not only by the police department and I believe the state police, but he's already been cleared by the district attorney's office. And of course, he's their main witness. But I think, as I tried to explain yesterday, just to sort of educate people, it does, you can charge, they could have charged a crime, maybe like, let's say they wanted to charge him with attempted murder under Massachusetts law. That's not where the analysis ends. I mean, they have to be able to say that any other police officer would also find what he did objectively reasonable. In other words, he's in a small room and a gun comes out, and someone asked him, well, why didn't you use your taser? And he says, it doesn't work that way. The response when a gun comes out is a gun. And under the constitutional standard of these 2 cases, one, Graham versus Connor, which is the use of force case, in every use of force case, Fourth Amendment cases. And then just last year, in the case of Barnes versus Felix, they have made clear that you cannot decide the case based on hindsight and what you look at afterwards. It's based on whether it's objectively reasonable based on the circumstances that occurred, not only at the moment of the shooting, but leading up to the shooting. And in this case, despite, my frustration over the fact that there was all this information given, that decision was made based on the information that Noonan had been given. This is dangerous. There's a restraining order. Justin saying, you might get hurt and all that. You have to consider that in the reasonably objective standard. It's It is simply part of the analysis. And when you do that analysis based on the constitutional requirements, there was no way that he was going to be charged because he's in a room, it's during a domestic, a gun comes out. Whatever the motive was, and whether she was, suicidal, that's a completely different analysis for this case, and that's proper. And it might be in her favor, but that's not the constitutional analysis. So I wanted to answer that because people were asking that. Someone also said, I like the fact that the judge asks questions. Well, the thing I will say about that is there's a lot of law in Massachusetts about that. If it was a jury trial, I tried not to say much of anything. If it was a bench trial, I could ask a lot more questions. But even in a bench trial, like every child abuse case where we're deciding whether we're going to terminate parental rights and put the child up for adoption because the child can't go back because it's not safe and there's clear and convincing evidence. In all of those cases, judges can ask questions, but and rightly so, because you're deciding, whether a child's going to go back into a situation that could be unsafe or not. So, I'd ask a lot more questions in those cases. But what I want people to know, the law is very clear, and this judge is doing a really good job complying with that very clear law that you can ask questions, even in a jury trial, but you can ask questions in a bench trial as long as they're clarifying questions. You cannot, as a judge, ask questions that makes it appear as though you are favoring the prosecution or defense, or in essence, acting as the prosecution. Seemingly your questions seem to benefit the prosecutor. This judge has done a really great job of complying with the law in Massachusetts, the case law in Massachusetts that says ask questions, but they have to be clarifying. Every question he's asked has sort of been clarifying. Can you explain what that means? What does tap rat mean? All clarifying. He's done a really good job of that, and it's okay to ask those questions. And especially in a bench trial, when you need clarification because you are the one making the decision. So I just wanted to answer those, things that came up in the.
Yeah, and to the judge's point, what she's saying is like the judge in a bench trial is not supposed to ask a question that goes to an element that the prosecutor didn't establish already with the witness, and like hand him a gift of, you forgot this in your case, and that you're noting that this judge has been doing a real good job of just clarifying. And then to your earlier point, and as me myself mentioned, and your honor mentioned yesterday, that these are two different things, and they can both be true, that Noonan was justified in the shooting given the circumstances, given what he was told and all that, but Kelsey is still not guilty because she didn't have the intent to commit the offense.
Right, because that's the bottom line. I mean, one thing they just had to do with this witness is they had to establish that it's a working gun. That's a clarification that has to be made. And sometimes we would have testimony about that, and sometimes the defense and prosecutor, in my cases involving firearms, because my court was in an inner city, and so there were a lot of firearms cases. And so you couldn't really move ahead with trial until there was that certification that the gun was actually operable. And so this testimony that the prosecutor is getting in is mandatory, because these cases involve guns. There's a certain criteria or certain things that have to come in. So that's that. So
and then I wanted to ask you, because Tony mentions it too. She says, "Thank you, Bob, for bringing in the memory issues. This is what I thought. Memory is so complex. Many things affect memory, especially stress." So Bob and I have been making the point, even when we thought there was going to be a jury trial, of getting a memory expert to talk about how when you have a traumatic event and your perception is so important, and if you recreate the event based on what you in your heart had wanted it to be, what you think it has, that Noonan could hold a memory as true, but it be not true because it's based on his perception and what he wanted to happen, because that's the way the mind works. Do you think with a bench trial, because Bob and I still thought it would be useful to this judge that kind of testimony from that kind of expert can help him say, all right, I can find that Noonan's account is not proven beyond a reasonable doubt, not because he's a liar, but because of the way memory works in these kind of situations.
Yeah, so let's say you bring in a memory expert, and the memory expert says, you know, in these situations, it's a traumatic event and memory can be skewed. The problem with that strategy is there has to be a nexus between what the expert says, has to be a nexus or connection to Noonan himself. And so, you know, how does that go? So the expert comes in, and then and then what does the prosecution say? You've never met Officer Noonan, have you? No, I haven't. You didn't talk to him, have you? You didn't talk to any of his colleagues, and you didn't see any evaluations by any psychiatrist or anyone else that any trauma caused him memory issues, did you? You know, so then that's what the judge is considering. No nexus whatsoever.
So there would be no benefit to the defense putting on a witness that just says, when you perceive an event like when you're involved in an officer shooting or somebody shooting somebody, and that event being traumatic in and of itself, or I don't know, maybe not using the word traumatic, that the way memory works when you're recreating an event is that perception ties into it, and somebody can hold, just like as a general proposition, that somebody can hold as true an event. But what we know about memory, and I'm just pretending that this is fact and assume that you know what I mean, but what we know about memory is your perception, and what you wanted to see comes into play when you recreate it, and then you form a firmly held belief that is what happened, as far as just showing it's a possibility. Like you're saying, because there's no flip side of that. You talked to Noonan and you've seen some of this. Do you not think that you can put in an expert just to say that's how memory works in general, and to explain what could be happening here?
Yeah, you could do it. It goes to the weight. So you know that there are jury instructions now based on studies with witness testimony, right? I'm sure you've seen that, eyewitness testimony. You can have eyewitness testimony to something, and 3 people that were at the scene, and they all come in and say something different. No, he had brown hair, he had blonde hair. It's inherently unreliable. That's why there are witness instructions that basically saying that there have been studies that show eyewitness testimony is inherently unreliable. I mean, it's happened, you know, thousands of times where, you know, eyewitnesses have testified, and then to what they saw and who they saw, and then someone's incarcerated, and then you find out that their DNA didn't match the scene, and that the witness testimony, which that's, you know, in decades past was considered sort of the, you know, the best standard, you know, the gold standard. It's now not the gold standard. It's almost no standard. So I relate it to that, you know, because, you know, again, you know that you're in sort of in that genre of, you know, of memory, and how good memory, how effective, you know, memory and testimony about memory is. You know, they can do that. They could bring someone in to say that. But if you're listening to it, and you're listening to it as a judge, I'm not sure it would be allowed in. So like you go back to the Karen Reed trial, and you have someone testifying, look, I've seen all these dog bites. Whether people believe, I'm not getting into whether people believe there were dog bites or not dog bites. I'm using this purely as an example for how you have to create a connection. And so, you know, you have a witness testifying about dog bites and how they look and what their appearance is. And you have all this expert testimony about dog bites. So let's just say they brought that witness in, and then they had that testimony, right? And that was the only testimony, all about dog bites. What weight would it have? I mean, it would have almost no weight until the dog bite expert said, now I'm looking at the picture and I'm talking about this case. And when I talk about this case, this is what I think. I mean, it holds so much more weight, because then you're getting an expert opinion. But if you bring someone in on memory, it's really hard to get an expert opinion when they haven't evaluated the police officer. So that's how I relate it. You know, they can do it, and it'll be interesting to see really interested to see what their defense is, because they sort of dropped, some of these things with Officer Noonan, but I suspect that they might be bringing someone in. They might be bringing in people who cleared her for duty, which is, one of the things that they didn't ask when they asked Noonan about, well, you knew that she had a previous section. Well, like I think I said earlier, I would have followed up if I was the lawyer on that, saying, but you also know that she was cleared for duty, and so that there were no mental health issues. I would have followed up with that, but maybe they're going to do that.
So what did I miss?
Wait, before you do that, I just want to wrap up this discussion and we'll tell you. So to the whole memory thing, do you think it's possible for the defense to argue that common knowledge tells us how memories work, Your Honor, and he can form this, firmly held belief about what he saw, but it's through his lens and it's through it, like without calling an expert? Could they make that argument?
Well, I don't know whether he would allow that or not, because he's going to say, how relevant is that if there's no nexus, to the case? And so he just might not see the relevance. Could they do it? Could they call it? I suspect the prosecution would object to it, saying, hey, this is just general. Where's your foundation? They would, if you're going to bring someone in to testify to that, are you going to make that argument? That's what he says, your lawyers, there has to be a foundation. How are they setting the foundation for that? So I think there are lots of problems with that. It doesn't mean that they couldn't do it. How much weight it would have, I'm not sure. I don't know that if I were hearing it, I don't know whether I would allow it in the first place. But even if I did, because they made the argument that you're making, like maybe there were memory issues because he's testified to some things and has forgotten other things. Maybe. You
don't think it's a nexus enough just to say this is the way the mind recreates stressful events, shocking events, whatever words you want to use, something about when someone is involved in a shooting that almost kills someone, or in a whatever, that there's not enough nexus there without some evaluation of him directly to just say the event's the nexus.
Right. Or some foundation for it, like why is it coming in? In general, you're going to testify that when people have traumatic events, they forget. Yes, that's very true. The problem is that can really work against you, because they're going to bring in statements. I don't know. You don't know if Kelsey's going to testify. They're going to bring in statements, that maybe she has made, and then they're going to question her memory. So
see, but that's where I'm at. I don't care, because
right, then it's too wrong.
Both memories, that's reasonable doubt.
No, but I appreciate the judge pushing back on us as much as we want. We want you to say, oh yeah, you could call a memory expert on that. So we appreciate that you're saying, well, no, I don't know if that would get in, but I think the nexus is just the way memory works, as far as when you think of something each time, even in that 5-minute time, that you're recreating your memory, and it's not really your memory, it's your recollection, which could include what you wish had happened, what you thought was happened, and you latch on to that. But you're saying those kind of general things alone, you don't believe is nexus enough for a memory expert in this case.
Yeah, I mean, I'm not saying that they won't call someone, to testify about memory. But again, I think you're going to hear, as this judge has questioned frequently, these sort of attempts by the defense to bring evidence that they view should come in, just like the whole issue where they had a sidebar about whether he was taking medication and all of that. You have to assume that the judge is going to really put some limitations on that and ask a lot of questions, just like I would. Okay, where is this going? Because this judge is really good about that. He said, okay, let's say, blah, blah, blah. He would say, okay, let's say this person comes in and says there are memory issues. how is that relevant to this particular person? He's going to ask that question because he's already done that frequently during the trial.
And then the answer could be, well, Your Honor, I want to introduce evidence that helps explain how both, both people could be presenting what they think is honest, but have formed a memory that's based not on fact, but on what they think was happening and what they wanted to happen, so that Your Honor can understand that that's the way memory works. And
Yeah, let me jump in here. And Judge, I don't know if you've followed any of the our coverage of the Richard Allen case, but in that trial where we had a judge who everyone who was talking about Noni being biased, she was a shining prism of judges compared to Judge Gull in that case. And in that case, they they brought in an expert, the defense did, regarding false memories. And this particular expert had never interviewed Richard Allen, but was just coming in with general principles about how the human mind works. And that's kind of what my thing is, where I think there's enough of a factual scenario because we know it was a high stress moment in time. And just generally speaking, you as a judge, would you find it helpful if, we're talking about peer-reviewed science and they've done the research on this, and this is how the human mind operates typically in this type of situation, wherein, because at the end of the day, for me, all I'm trying to get to is a reasonable doubt with the judge, where if I can give him enough to say, well, in that particular situation, I think that both of these people think that they're telling the truth. But based on what I learned from this one particular expert on how our memory operates, because this particular expert they used in Delphi was fascinating. I wish they would have kept him on far longer than they did. But, he was like, whenever you have a memory, the first time that you have a memory or you're restating what you remember is going to be a little bit different based on all the other things that we're talking about. But every time that you are going back to that memory, you're actually going back to the last time you remembered it. So it continues to kind of morph. Gracian, thank you. So it's just an interesting thing where I would have certainly have given it a shot here, just because we have this he said, she said situation in a very, very high stress situation where I just don't know, if I could trust what either of them are perceiving happened in that few seconds where this thing took place. So I don't know.
No, you make a great point, and they could try it, but I think the bottom line is I think that if the judge is going to see reasonable doubt, he's going to see it based on the evidence that went in when Noonan testified on direct and then on cross. I thought they did an excellent job of calling into question, like, well, how far back were you? Were you that close? How close were you? And information that we're going to be seeing on the bullet casings. I mean, to me, I think, and the fact that they put some excellent evidence in that she was like, take this basket of books and go downstairs. And then she said, take these clothes and go downstairs. That she worked pretty hard to get him out of that room. So I think they did a really good job of establishing evidence without getting into the memory thing, which is more murky, because it's not even questioned at this point by his own testimony. She did tell me, she did tell me to take it downstairs, and she did tell me to take the clothes. I mean, he couldn't argue with the fact that she was working pretty hard to get out. And of course, he knew what he knew was that was very damaging to the case of her wanting to shoot him. So what did he do? So then he throws in this statement, which, as I said earlier, I would have declared a mistrial.
100%.
Judges, where he says, well, I mean, maybe she was trying to kill Justin. I mean, come on. But what did that tell you? As a judge, to me, what that told me is there's a witness here who understands that she was trying to get him out of the room. And therefore, why and again, they also established great information. It's like she wanted you to hold the baby. So why would she want to kill you? She wanted you to feed the baby. So why would she want to kill you? She wanted you to get out of the room with the book. So why would that, that's to me, that testimony really tended in favor of Kelsey Fitzsimmons' plan that this was a suicide, and therefore she didn't claim the intent. She didn't have the intent, because if she was trying to get him out, and she tried twice to get him out, and she wanted him to hold the baby, and she wanted him to feed the baby, that goes to the one element that is foremost in this case, and that is what is her intent.
Exactly.
And I think they've established it without getting into something a little more murky.
So what did I miss? So I saw all that, but
Wait,
what?
babe, let me just bring this one more part around, and maybe we shouldn't be calling it a memory expert, but a reconstructive processing expert, where I'm going to use the word memory, but it's your recollection of the events is driven by belief-driven reconstruction. An expert that could testify that a person's attitudes, expectations, or desires for a certain outcome can unconsciously color the memory. And even if a person strongly believes they acted in self-defense, their mind may reconstruct the memory of the threat to be more immediate or aggressive than it actually was.
Yeah,
And
it's definitely a thought, and they could do it, when you're talking about reconstructing it. But isn't it fair to say they reconstructed it quite well just by asking those questions? Didn't they reconstruct the whole, aspect of him? Like, she took a gun and she pointed it at me and she shot it, and that was her intent. Her intent was an assault, with a dangerous weapon, because she pointed the gun, and of course he didn't fire it, at least fire it in a way that hurt him. But as I just said, they reconstructed it in a way that where it's not disputed, and where it's not a little more abstract. They reconstructed a scene where she's telling him, hey, get out. It's 4-month-old and she's stacking up books, right? Not that you don't read books to a 4-month-old, but she's stacking up books in a basket and saying, hey, get out of here. She's stacking up clothes, saying, get these to my mother. She's doing all these things. Hey, I want you, Officer Noonan, out of everybody in this room, to hold my baby, and I want you to feed my baby. And he did all of those things. So in my view, if I were, if it was a bench trial, I would say she worked pretty hard to make sure that he wasn't there. And that's powerful evidence
of her intent.
Her intent wasn't to hit him. So, and if you guys don't mind, do you mind if I take a little break here before?
No,
of course not. Of course not.
Some calls and
all right.
You've got an open door, Judge. Whenever you want to hop in, hop out.
Thank you.
I'm trying to figure out how to. I don't want to, like totally go off of it, right?
Here, I can just put you back here, and then you can be there until you're ready to come back. So I saw some people in the chat.
And if you want to come back, just wave at us and we'll pull you back on.
Well, so I'm just thinking, so if I can go off like that, right?
Yes.
Perfect. Yep. That's even better. Exactly. And then, babe, I'm going to hop off to take care of a call too, but I just want to say, I saw a lot of people saying there is no memory expert on this witness list. We don't think there actually is one now. We were just trying to get the judge's opinion on our position, that for all the reasons, like I just said, the reconstructing a memory based on belief driven, so that some evidence that, look, he might not be lying, he might just be reconstructing. That's a thing that happens.
Well, yeah, that's what that expert that I was talking about. It was like false memories. Right. But it's like all eyes had made I was going to put it up, but it was big and it would have covered the judge's face. But she had said, it was, hold on, let me find it. I want to get it. She says, all I said, our brains can't always tell the difference between what we saw versus what we're picturing in our minds. Every time we access a memory, we alter it and we bring memories in line with our beliefs, which is exactly what that expert was saying. It's in like, to compound it, you're remembering the last time you remembered it. So it's much like the telephone game. Over time, it gets more and more bastardized the further out you get, so what did I miss though? Like, that's what you're not telling me. I keep
Okay,
asking.
so I forget, what's the last person you saw?
It was Noonan. It was in the middle of Cross.
Oh, so after Noonan, they called Carr, who established nothing. He took the gun, he put it in a box, so maybe chain of custody. And I think the judge might have mentioned some other thing that maybe he helped do, but it was nominal. And then they called a firearms expert who didn't mention anything about the mechanism of cock and block.
Wow. Cock and bull.
Cock and bull, about snap and hack, whatever the hell it's called.
Tap and rack.
Tap and rack. Who just testified to how, how firearms work, and that it makes a click. If you fire an empty firearm, it makes a click. So that would be the click he saw. And it sounds like you'd have to kind of tap and rack to get the next bullet into chambers.
Yeah, you got to chamber the round.
Right. And they, and they kind of just talked a little bit about where the projectile or the casing, or I'm going to get all the words wrong, would be in vicinity to the person who pulled the trigger, to the weapon that was being fired. We're kind of hoping that that's something that the defense is going to kind of follow up on and point out.
So did they rest, or are they still going?
No, we're in the middle of cross-examination of their firearms expert.
Did you remind everybody that we have a big show right after?
Tell them that. Well, I'll be back.
All right. So big show tonight. We are having David Osborne Jr. and a juror from the Afro Man trial, the big free speech trial. Victory for all of us here that love free speech in this country. It was a huge win. So we're super excited to have his attorney on tonight and one of the jurors who are the real heroes of the story, because they ultimately are the ones who said, nope, no liability here. That is allowable under free speech. So we're excited about that. And Allie had said something about potentially maybe getting another juror. I don't know. Like, I'm not privy to it. But we're really excited about it. Hopefully you guys will be joining us for that. We think it's going to be a great conversation. And I've been looking forward to it since we got it scheduled last week, right after the trial. So hopefully you guys will come and hang with us. So where are you guys at? Where are you guys at right now? What are you guys feeling? I feel like I need to do a poll. You know how I love my polls over here. So I'd say probably 3/4, if not more, into the Commonwealth's case in chief. So I'm going to make a poll and where you're at right now. And I'm talking about you personally, not what you think the judge is going to do. And obviously we don't have a jury, so that doesn't make any sense to even ask that question. So where are you at right now with the evidence that has been presented? Okay. And you have to put to the side all of our feelings about how shitty Justin is and all the crappy things that he did and said and how he put this all in motion. You got to go on the facts as they've been presented. All right. Okay. And I know that's hard to do. To put away like all the shit that we know. It makes it very difficult. Okay. All right. I have a feeling I know which way this poll is going to go. All right. But let's get it in stone here. Okay. Wait, let me add a question mark. All right, start answering. The poll is up.
So yeah, so did Allie give me the full 911? She give me all the 411, the information, not the like, what do you guys think? Did she give me all of it? Is there anything she missed that I should know? Because I missed, a solid hour or 40 minutes or whenever they went to lunch. I don't know. Let me see. Oh boy. Polls right where I thought it would be. So we're at 250 in, 93% not guilty, 7% guilty. So this is interesting. And if you don't want to out yourself for fear of reprisal from the chat, I understand, but you shouldn't feel that way. We try to keep a very safe space for people to have their own thoughts here, because we're all allowed to have our own opinions. And while people may disagree with you, tough shit. Too bad for that person. They're allowed to disagree. We're allowed to agree to disagree. So 7%, 8. What is Turtle Boy has nothing to do with this case. Nothing. I don't even like mixing the cases up. They're completely separate cases. So I'm not putting that into I hope that's not true. But for those folks that are feeling that guilty is the right call here, what evidence has turned you? What evidence makes you feel that she's guilty? I'm curious. I'd like to see it. Is it, I mean, it has to, I'm assuming it has to be Noonan's testimony, right? I mean, we haven't seen anything else. Oh yeah, I know. I understand. I understand, B crumbs. I get it. I get it. I mean, the guilters on the Reed thing have now turned their sights onto Kelsey, which is just stupid. It's like that same crew. It's like it's all part and parcel. Like anything that the folks that covered Karen Reed that believe that she was factually innocent, any case that they now follow and they believe that that person is factually innocent, that crew of people now immediately takes the opposite position, which is just so disingenuous and stupid. Like, it's just, I pay no mind to any of it. It's all ridiculous. But, I think the drama is stupid too. So, but that's just me. I mean, people love drama. I get that. Like, people are fascinated by it. It's like watching you can't take your eyes off a car wreck. People like to get into other people's business, like see their text messages and all that shit. It's just not my cup of tea, But so if you're ever looking for that kind of content over in my house, it ain't happening. But yeah, it's interesting. So has anybody answered me yet? I don't believe. No, I know what there's truth to that for certain. For certain, people, it's one of the first questions we ask. Just by way of a person being arrested, do you think that person has done something wrong? Most people, if they're being honest, will say, yeah. So yeah, the memory expert thing is interesting to me, because I hear what the judge is saying in terms of, maybe having some foundational issues and creating a nexus as to why it's relevant here. But I think you can probably I would certainly be trying. Because I think that it can move the needle for a judge who might be kind of stuck. And I mean, and we know that Karp is very honest in terms of what he knows and what he doesn't know. Like Allie was pointing it out kind of at length in terms of him not being familiar with certain phrases that were being used with respect to, Noonan's testimony or any cop. If they're using cop lingo and the judge doesn't know what the hell it means, well, that's why Allie was saying it's important for Bradl to flesh that out, because the judge doesn't know what that means. It's like you're not making the point if a term of art is being used that he has no idea what it means. And I think that same concept stretches out to even if it's just generalizations about how the human mind operates, I think there's an argument to be made as to how much we can trust, not just what Noonan's perception of what happened that day, but also Kelsey's, which to me lands squarely in reasonable doubt. Because if neither of the people's memories can be trusted fully, I mean, how's he to reach a decision? Because either thing could have happened reasonably, which means not guilty. I mean, that's where I'm at with it. And I obviously respect the hell out of the judge, but, you know, and I gave her my pushback. You know, I think I'd be giving it the old college try. Now, whether or not that's happening, I have no clue. I just know if Allie and I were trying the case, I'd be pushing hard that we got somebody just to come in and educate the judge. Maybe the judge doesn't know anything about it. I think we'd all find it fascinating. Like I said, DB refreshed my recollection as to that expert's name, and it was Grassi. And, you know, and he was on stand only 20 minutes, but I thought it was fascinating what he was saying. And I never thought of it that way. I never realized that, you know, when you're accessing memories, all you're remembering is the last time you remembered it. So whatever version of the truth that is, that's your jump off point. And so whatever variations come from that, that becomes the next memory when you cope, you know, you're telling the story 3 years down the road and I'm accessing the memory. All I'm accessing is that time 3 years ago that I talked about it, where I was trying to access a memory that happened 10 years ago. And I have 15 iterations of what I think I remembered about it from 10 years ago. So I don't know. Let's see. Has Allie gotten through all the supers? We see some beautiful new human members. Muzzy Bear. Family hug. Welcome, welcome. Patty. Welcome, welcome, welcome. Now, we have a great crew in here today. I have to ask all of you a favor. We're 1,800 strong in chat. Please, please, it's free. Go ahead and just sub to the channel if you're not already. And if you decide one day when you're watching us, you're like, you know what? They swear too much. They're not for me. Then unsub. But for right now, sub. It's free. And it really helps the channel grow. So please like, share, subscribe. You know, those YouTube things. Like, I'm terrible about reminding you guys to do that. Because I think, you know, people will just find a channel, they're going through, they'll hop on it. They don't even think about it. So that's why it's helpful for me to remind you guys to, thank you. Thank you, Scorpio Moon. Appreciate that. Appreciate that. I don't swear as much as Allie. Allie's real potty mouth. She's a real potty mouth. I mean, I swear a bit though. Like I catch some hell over in Tony's chat occasionally. You know, it's usually I find to be boomer aged folks are put off by the foul language. I think it shocks their systems. I mean, they grew up formatively during a period of time in which foul language was not used in the public domain. It certainly wasn't on television, you know, and I mean, the shift has happened, you know, because to me, it's always been, them's just words. And I don't know who decided that the word shit was a bad word, but it's stupid. I mean, it's like the whole concept of foul language is just bizarre to me because it seems arbitrary. And it seems like at some point, some individual decided that that word shan't be heard by human ears. You know, it's like no one's ever getting me off that concept. So, you know, whatever. But yeah, like I'll catch, I'll even see in our replay. Oh, I thought you guys were really great. Then you were swearing so much I had to dip. And I'm like, well, you know, you don't have to announce your departure. You can just leave. You know, I'm good with it. It's yeah. Does your dad? He's not a fan of this. Like either is my father, and it's annoying to me because, you know, he's like, quit saying the F word. I'm like, you say the F word all the time, you hypocrite. I'm like, where do you think I learned it? all those many years ago from you, sir. But yeah, so, I mean, I could tell you definitively, we'll never stop swearing on this channel. We're a swearing channel. That's just, it is what it is. So, what are you going to do? I mean, the F word's my favorite word in the whole world. I love it. It's so flexible. So many uses. I think I looked it up one time, like what word has the most kind of definitions or uses, and I forget what it was, but it wasn't the F word, surprisingly to me. Yeah, cursey words are the best. Oh, Kelsey says, or Kylie says, love my dad. My parents are coming to visit this week. Shout out to all the boomers named Bab from Chicago. That's right. Your pops is a Bob too, right? I think I remember seeing that before. Dead name. All the Roberts are good. They go by Rob or Robbie. No one goes by Bob anymore. I think my generation was like the last generation to use Bob as opposed to Rob. Like, think about it. If you've got a kid in like grade school, middle school, think about like looking at their class and think about how many Bobs you're seeing nowadays. It's not used. I mean, which begs the question, what about Bob? Oh boy. All right, let me check. Yeah, Bob is a dead name. That's what I'm saying. It's done. It's finito. Yeah, there's tons of Bobs my age and older. It was very much a popular name. Now, not so much. All right, let's see where we stand with the. Can't wait to see it. All right, let me peep this poll and see what's really going on. Oh, hanging tight. All right, come on. 652 votes. How many people are in here? Come on. You guys, we should have at least 1,000 votes. That too is free. Just vote. It's anonymous. No one's going to know. 92% not guilty, 8% guilty. There you go. So that does not shock me. But like with this case in particular, I have to be honest about it. I am having a very hard time putting aside the bullshit that this dude pulled. Like I am having a very difficult time forgetting about the fact that I believe that Justin and his mom went in to use this TRO or the RO as a weapon in the custody fight. I'm having a really, really hard time pretending like that doesn't matter, because it does. I mean, he created this situation flat out, not only by going in and getting the ex parte order, which I think, if I had to guess, was at the behest of his mother. And, we know how involved she was. And, we've got, I have many funny voices. I am not a one-trick pony when it comes to voices. I'll do voices. I will do voices. But you know what I mean? It's like, it's really hard for me to put that aside. And then you add in the factor that they allowed this dude who pulled that shit that led them to that house to rip this baby away from her into the house while they're ripping the baby away from her. I mean, that's really hard to put aside. It is. It just is. All right, let me see if all right, good. Got some more votes in. 751 moved up to 93-7. All right, it's a landslide. That, kids, is what they call a landslide. So Do the old man voice. Everybody loves the old man voice. You got a Bob? You got a Bob from Chicago? Yeah. I mean, we love it. We love it. We love it here in Chicago. All the Bobs. All the Bobs. I don't even know how they came up with Bob from Robert. I mean, Rob makes sense. Like, who do they think they are? Changing the R to a B. Like, what? Doesn't make any sense. I think I'm trying to remember, like, my father still calls me Bobby occasionally. And my cousins, my first cousins call me Bobby, you know, but as an adult, like, I think that Bobby for an adult is just weird. It's just weird. It's like any of the names that you can add the Y to, and like full grown men going by that is always weird to me. Yeah, great question. How did Richard become Dick? Same concept. I mean, I could just tell you unequivocally, if I had been named by Richard, I would 100% insist on being called Dick. Like, I just would. Hey, Dick. It's so good. I wouldn't have it any other way. Richard? No, I'm going to go by Dick. Hey, Dick. I mean, it's great. It's just great. Just absolutely great. Yeah, it's my uncle, William DeBill. My uncle, rest in peace. He was same thing. Billiam. That's what I used to call him. Or Ramblin' Willie, one of those two. Those were my nicknames. Billiam or Ramblin' Willie. Those were my nicknames for my uncle. And my nicknames always stick, just so you know. Like, you wouldn't believe how many nicknames I have for people that are private stock. I keep them all private to myself, you know? You know what I mean? All right, so we're getting close. They're late. They're late coming back. And I'm curious as to how many more witnesses you think there's going to be. I mean, to me, it seems like they got to be wrapping. I missed the last two, but it sounds like they were relatively short order, meaning they were not long directs, not long crosses. Let me ask this. When I was gone, did the other attorney do anything for the defense? Or is she still just sitting there? You know, because it's like when I think about that particular situation and bringing her on, when the team brought her on, yeah, Miss Smith, actually, when Allie comes back, she can just pull it up. She can just pull it up, the charge. We can go through it again. It's just one charge, but we'll go through the elements of it because it's important to understand it. It really is. You know, because there's that thing where, you know, one of the reasons I thought a bench was the move in this particular case was because I think the juries a lot of times lose sight of the fact that each and every element of a given crime has to be proven beyond a reasonable doubt. It's not like collectively. It's like each element of a crime has to be proven beyond a reasonable doubt. I think the judge was talking about that yesterday, that exact thing, where she was saying, well, you know, in terms of, was the apprehension of fear there for Noonan? Yes. So there, okay, I'm there beyond a reasonable doubt, you know, and then going through the elements. And then when she got to that element of intent, which is where this case lives,
Kelsey Fitzsimmons matter, docket
at a reasonable doubt.
77 CR 311, all counsel and the defendant are present.
Okay, I think we left off during cross.
Yes. May I resume your?
Yes, please.
Thank you. Lieutenant Detective Bonasoro, you have a copy of your report, right?
I do.
Okay. And there's other documents too. You have worksheets and other items, correct?
Correct.
So if you need anything, just let me know and we can share anything you need. Okay.
Okay.
what's this guy's name? Bonasoro? Bonasoro.
What
Bonasoro.
is meant by chain of custody of an item?
Who has actual custody of that particular piece of evidence? It's moved from one location to another or one person to another.
Okay, that was the
As a
worst.
piece of evidence kind of
description.
goes through the investigative process. Sometimes it can be important to make sure you know who had it, where did it go, as it goes through, right?
Correct.
And in this case, it's fair to say that you don't have personal knowledge of a lot of the chain of custody here.
I have personal knowledge of who I received the firearms from.
Right, okay. And we'll go through that. And I'm not questioning, in terms of chain of custody, you and the state police going forward from when you left the crime scene. I want to ask you some questions about chain of custody at the scene, okay? Who did you get, and again, you can refer to your report here. Item 1-1 is a Glock 47, and we'll just use the last three numbers of the serial number, 269. Who did you get that from?
What was the item number again?
1-1, Your Honor.
Thank you.
Yep. And the last three digits of the serial number are 269.
Thank you.
And so that gun, and again, you can look on your papers, anything you want. Do you know who you got that from?
If I could see my notes, the
Sure.
worksheet notes
Yep.
from the crime scene.
Sure.
Do we catch this guy's name? I'm trying to do a banner here. You guys are really letting the team down, let me tell you. Allie didn't have a banner up for this guy? Wow. Just wow.
Yeah.
Let me see if I got this right. These would be the notes, right? And this is just another copy of that report.
Yes.
Thank you, guys.
So 1-1, take all the time you need. Who did you get that from?
It was received from Detective Lieutenant Michael Davis.
Okay, and who's he?
He works for North Andover.
All right. And do you know whose gun that is identified to from the incident?
Based on the serial number, I was told it was Officer Noonan's weapon.
Okay. And are there some notes in that packet you have there from you that indicate that Chief Gray had that gun for a while?
Yes.
And what are the indications that, how did Chief Gray come to get Noonan's gun?
I was told that he had custody of the weapon and he unloaded the weapon at some point, and he put the live cartridge that was in the chamber back into the magazine.
Okay, so Chief Gray is manipulating Noonan's firearm, and I mean the word manipulating in the physical sense.
Yes, this is what I was told.
And then it goes to who? Lieutenant Reardon, was it?
Detective Lieutenant Michael Davis.
Davis, sorry. And then Davis gives it to you?
Yes.
And that's just what you have documented, right? You don't have any knowledge of any other people having it, right?
Correct.
Presumably Noonan had it since it was his firearm at some point.
Presumably.
And all right, so that's 1-1. And item 1-2 is a box magazine from item 1-1, correct?
Yes.
And it's got 16 cartridges in it, and the capacity is 17, right?
Yes.
And so you say right in your report from item 1-1. So it's the magazine from Noonan's gun, right?
Yes.
Okay. Then 1-3 is a little different, isn't it?
Yes.
You write there, one removable box magazine from, but then you didn't fill in who it's from, right?
Yes, that was an error on the administrative portion.
Error.
Report.
Error.
And just so we're clear, this is your report.
Correct. Yes.
Okay. So it was never noted
Oh, he's MSP.
where the
Should have figured.
1-3 is from, correct? In terms of the gun.
It was noted that it was received from Officer Michael Logan,
Right.
1-3.
So he's the chain of custody guy, but unlike 1-1 and 1-2, where you match them up, that the magazine is from 1-1.
Exactly.
Here, it doesn't say where that magazine is from, right?
Well, these were recovered at a later time.
Mhm.
I was initially given the firearm with the magazine, and then later on, these additional
Bonus.
magazines that were recovered from, I believe, the either the duty belt or vest carrier, whatever the officer had.
And you know, I'm just asking you about what it says. I'm not trying to suggest there's fault, and I just want to go through it with you in terms of what's identified and what's known to be from somewhere and what's not. Okay, so I'm not trying to find fault. I just want to factually have us go through the report. So we don't know where 1-3, the box magazine, is from, what device it's from, right?
I was told it was from either the vest carrier or the duty belt of Officer Noonan.
Okay, but that's not in the report, is it?
It is not.
And then same with 1-4, one removable box style magazine from, and then from is not identified, right?
Correct.
Okay, and that's the same thing. You got a magazine, and that's from Officer Logan as well. The chain of custody reference is from Logan, right?
Yes.
Okay. And again, it's not identified in the document where it comes from. Yes?
Correct. Correct.
Then 1-5 is another Glock 47. So it's just to cut to the chase. All three guns you have are Glock 47s, right?
Yes.
Okay. And that's a semi-automatic firearm that was, to your understanding, issued to the North Andover Police.
Yes.
And each one obviously has its own serial number,
Correct.
but otherwise they look the same.
Yes.
Going to 1-7, you have two removable box style magazines that you received, and the chain of custody guy is Michael Logan, but it doesn't say what firearm they were in the vicinity of or near, correct?
So as I entered the evidence, it was associated with the firearm. So as I went to the next firearm, whatever is below that firearm is associated with that firearm. So all evidence below it will be associated with the firearm until I mention another firearm.
Okay, so that's your procedure, right?
Yes.
Well, it's fair to say, though, that sometimes you do say what it's from and sometimes you omit it, right?
Yes.
And that's by mistake, right?
Yes.
And then you have 1-9, which is another Glock 47. Last three serial number is 315, right?
Correct.
And that is associated with who?
Is Officer Kelsey
Miss Officer Fitzsimmons?
Fitzsimmons? Yes.
And then you have a box magazine 1-10, right?
Correct.
And you do write from that item in this particular instance, from 1-9, from Miss Fitzsimmons' firearm, right?
Yes.
And then you do two removable box style magazines from a vest carrier on the first floor.
Yes.
And it's fair to say that after item 1.8 from Michael Logan, that's the last reference to the chain of custody person you received items from, right?
Correct.
So from 1-9 to 115, you don't reference who you got the items from, right?
Well, I physically recovered that evidence.
Okay, so you had it
Yes.
from the scene, like from the floor or the bed or wherever?
Correct.
Okay. So these are things that you recovered?
Yes.
Okay. Then we get to some discharge cartridges and a live cartridge, 1-12, 13, and 14, right?
Correct.
And they're all, as we went over, they're all head stamped the same, right?
Yes.
And then you have 115, the last item, is a spent projectile. So like a bullet, a spent bullet from above the air conditioner.
Correct.
And you recovered that yourself.
Yes.
Okay. Now, with respect to the live cartridge, the discharge cartridge at 113 and the discharge cartridge at 114, it's fair to say that you applied science. I'm going to just keep it vague for a second. That you applied some science to the two discharge cartridge casings, right?
I was looking for agreement of individual markings. Yes.
Right. So you used some science.
Yes.
Just to start real basic here. And you were able to identify those two discharge casings to item 1-1, right?
Correct.
And 1-1, you know to be Noonan's Glock, right?
Yes.
Now, it's fair to say that with respect to the live round recovered from the hallway safe, it's fair to say that you didn't apply any science to that item, correct?
Correct.
So there's no science, unlike the other two, unlike the discharge casing in 114, the discharge casing in 113. Unlike those, the live cartridge, there's no scientific basis for you to say what gun that came from, right?
Correct.
And it's fair to say that there were, and again, I'm not trying to find fault. Nobody asked you to apply any science to that item, right?
Correct.
So there were some various scientific methods that you could use to determine where that came from, right?
There would be some markings if it was actually cycles with that weapon.
Right. One step ahead of me. That was my next question. If that was cycled through a weapon, you would have what? Breech face markings?
No, you would have what's called extractor markings, possibly ejector markings, as well as you may have magazine marks.
Okay. And just to kind of bottom line it, that means that if someone had, if that cartridge was in the chamber of Ms. Fitzsimmons' weapon, and it was made safe by cycling it out, right?
Correct.
Breech face markings or ejector markings or extractor markings would be deposited on that cartridge, right?
Possibly, but not breech face. Breech face markings is part of the firing process.
Okay, so what processes were available to figure that out?
So you could have the extractor mark, which is holding that live cartridge in place. You'd have a magazine mark if it came from the magazine, if it was loaded in the magazine, and you'd have possibly an ejector mark. But a lot of times these cycling marks don't show up due to the fact that there isn't an explosion that happened. So it's not a exact way of looking at these markings. So you're looking at a piece of ammunition that could have been cycled, but there's no definitive amount of markings there to determine that, unless there was some type of defect or whatnot.
And to figure that out, you got to look at it.
Correct.
And that didn't happen here, right?
Correct.
Nothing further.
Okay. Read back? Okay.
All right, you may. sit down.
Tracy,
Thank you.
keep it down. Keep it down.
And, come up and call your next witness.
Shame. 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 Hello, Newman. That's right. Caddyshack. Noonan. Noonan. Is it? I cranked it down. I'll crank it down a bit more. Let's see. Oh, it keeps going up to 140. It's insane. How's it now? Is that good? Testing. Yeah, bench trials are interesting. It's different. Yeah, I missed the direct here. So maybe some of the relevance here as to that last witness is being lost on me.
You solemnly swear that the testimony you're about to give in this cause now hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Watch your step right there. If you could try to speak up nice and loud right directly into this microphone so the judge can hear you.
Yeah. Good afternoon. Good afternoon.
Sir, in a loud, clear voice, can you please introduce yourself? Spell your first name and your last name.
Officer Timothy Houston, Timothy.
Oh, Houston.
And sir, what do you do for a living?
Patrol officer with North Andover Police Department.
How long have you been doing that?
A little over 5 years. Okay.
Sir, where'd you grow up?
I grew up in North Andover.
Did you go through the North Andover school system?
Up until high school.
And where'd you go?
I went to Central Catholic.
After Central Catholic, what did you do?
Oh God,
I
who
went
gives
to
a shit?
Norwich University and got a bachelor's in criminal justice.
Objection, who gives a shit?
After you graduated there, what did you do?
I went to the Army. I was in the Army for 4.5 years.
What'd you do? You're muted. First of all, you're muted.
Why don't you take over the feed? So if you want to pause and talk.
Why? What are you doing?
All right. I'm dealing with something, but I'm kind of here in the background, so it's all right.
Oh, yeah. Oh, yeah.
Reached the rank of sergeant and then came home, joined the North Andover Police Department.
Okay. And so when was that you joined the PD?
I started the academy in November of 2020.
And your rank now, you're patrol officer?
Patrol officer.
Okay. Can you tell us a little bit about your duties as a patrol officer?
I worked a 4 to 12 shift. I started on midnights. I've been on 4 to 12. I think it's my 3rd year. It's basically if you're not answering calls, you're on the road, watching traffic, things of that nature.
I'm going to jump back for a second and just talk about your military service. You were in the Army, you said?
That's correct.
Okay. And what did you do there?
I was a cavalry scout.
And what did that entail?
I mean, I had different positions. The job itself, you mainly focus on reconnaissance. But while I was there, I started as a dismount. Then I moved up to a gunner, and then I was a dismount team leader, and then I was a gunner for the lieutenants in the platoon. That's pretty much it.
Where were you stationed?
I was at Fort Lewis, Washington.
Now we're going to jump back to the PD. Okay. Do you know a person by the name of Kelsey Fitzsimmons?
I do.
Oh, yeah.
How do you know her?
We
Update
worked
the banner.
together briefly.
Yeah.
She was in the academy. I can't remember how long.
Wow. bossy much?
She was out of the academy, but she was FTOing for a while, and she was FTOing on my shift. And then she finished FTO, and she worked on our shift for a brief period of time.
Okay. FTO, what do you mean by that?
So she was under a field training officer. So she was riding around with somebody while she got used to the job, learned.
Did she ever ride around with you?
No, she did not.
Okay. Did you know her socially at all?
Yeah. I was invited to her wedding. We kept in touch when she went on leave. Tried to keep her in the loop. Spoke with her, kind of, trying to get everybody together before her wedding. Her wedding was a decent amount of time away, and while she was out of work, we obviously didn't see her as much. So we had been working on planning something with some of the guys from work, people bringing their spouses, their dogs, and trying to figure out something, but it never happened.
Okay. Did you know her fiance?
I met him at the engagement party. Other than that, I'd see him, on calls if we had the FD, but I don't know him that well.
Okay. So I'm going to turn your attention to June 30th of last year. We were working that day.
Yes.
Okay. And at some point, did you get in touch by Lieutenant Daly?
Yes.
Okay. And what was the nature of that communication?
He called me and said, Justin filed an RO against Kelsey. He wanted me and Officer Noonan to go to the house and serve the RO, which required Justin picking up their baby and confiscating her firearms.
Okay. How did he get in touch with you? Do you remember?
By cell phone.
Okay. Did he ask you to do anything in particular about Officer Noonan?
Initially, he told me to drive past Kelsey's house and see if she was home.
Okay. Did you do that?
I did.
And you knew where she lived?
Yes.
Did she park in a particular place usually?
So normally, yes, she would park in front of her house if she was home. I found her car 50 to 100 yards down the road, kind of in the school lot, kind of tucked away.
Okay. Did you relay that information to Lieutenant Daly at that point?
I did.
Okay. And
what are they implying?
At the point that you saw her car, had you already talked to Officer Noonan?
After I called Lieutenant Daly and told him about her car being out of, parked in a strange way, I called Officer Noonan.
Okay. And what did you tell him?
I said, hey, what's going on? He hadn't talked to Lieutenant Daly yet, so he had no idea what was going on. So I told him to meet me in the parking lot, and I'd go over it with him.
And did he do that?
He did.
Did he get there before Lieutenant Daly did, if you remember?
Yes, he did.
Did you inform him of what was going on?
I did.
At some point, did Lieutenant Daly also meet up with you in that particular spot?
Yes.
Okay. Did you talk about a plan as to how you were going to handle serving the order?
My only memory is what I updated Officer Noonan with, just the circumstances of why we're going there and concerns that we had, but I don't remember what the exact plan was. I think it was assumed that Lieutenant Daly would do most of the talking.
Okay. And
Dude,
you said your
quit hitting the
concerns. What
witness
were your
box with
concerns?
your hand. It's
We were aware that she had been sectioned before, so
Babe, take over the
obviously it's
feed.
a tough
Why?
position for her, finding out, there's an order.
All right.
You can pause and talk.
Okay.
'Cause
I mean,
you
that
talked
wasn't,
over it.
that wasn't pause word. Okay.
Just
Let me see. I got to get current. All right. Okay. I think this is right about where we're at. Pull your shit down, babe.
Kind of, trying to get everybody together before her wedding. Her wedding was a decent amount of time away, and while she was out of work, we obviously didn't see her as much. So we had been working on planning something with like, you know, some of the guys from work, people bringing their spouses, their dogs, and trying to figure out something, but it never happened.
Okay. Did you know her fiance?
Just, I met him at the engagement party. Other than that, I'd see him, you know, on calls if we had the FD, but I don't know him that well.
So I'm going to turn your attention to June 30th of last year.
Oh, we heard
You're
this?
working that day.
Justin picking up their baby and confiscating our firearms.
Okay. How did he get in touch with you? Do you remember?
Kind of tucked away.
Okay. Did you relay that information to Lieutenant Daly at that point?
I did.
Okay. Had you,
Lieutenant going on. He hadn't talked to Lieutenant Daly yet, so he had no idea what was going on. So I told him to meet me in the parking lot and I'd go over it with him.
and did he do that?
He did.
Did he get there before Lieutenant Daly did, if you remember?
Yes, he did.
Did you inform him of what was going on?
I did.
At some point, did Lieutenant Daly also meet up with you in that particular spot?
Yes.
Okay. Did you talk about a plan as to how you were going to handle serving the order?
I mean, my only memory is what I updated Officer Noonan with, just the circumstances of why we're going there and concerns that we had, but I don't remember what the exact plan was. It was, I think it was assumed that Lieutenant Daly would do most of the talking.
Okay. And you said your concerns. What were your concerns?
We were aware that she had been sectioned before, so, I mean, obviously it's a tough position for her, finding out, you know, there's an order in place, we're taking her firearms, we got to take the baby, give them to Justin, so we thought with her past being sectioned, she might not take that news very well, and, you know, we weren't sure what was going to happen.
Okay. Had you served restraining orders yourself before?
Yes.
Now, at some point, did you go over to 125 Phillips Brook Road?
Yes, we did.
And the three of you?
Yes.
Did you go in together?
Yes.
All right. Can you tell us what happened as you approached the house? And take us from there.
So we parked off to the side of the house, out of view of the house itself. We walked around, knocked on the front door, or the side porch door, whatever.
Had you ever been in that home before?
I don't think I'd ever been in the home, no.
Did when you knocked or rang, I'm sorry, I forget what you said.
I don't remember.
Okay. Did someone answer?
Yes, Kelsey answered.
Okay. Did she have the baby with her?
She did.
Okay. So what happened then?
She wasn't sure why we were there. Lieutenant Daly kind of had the paperwork in his hand. She invited us in, and Lieutenant Daly just started explaining why we were there and what was going on.
Okay. Where in the house did you go?
So we went into the living room.
Okay. Did you remain standing? Was she seated? What happened with the baby? Can you describe what happened there?
So Lieutenant Daly asked her to take a seat on one of the couches. Had her put the baby in like a rocker on the floor, and I stood kind of away from them by another couch.
Okay. Could you hear what they were saying?
Yeah, I couldn't remember exactly what was said, but
What was the gist?
You know, Justin filed this order. She was shocked by it. Lieutenant Daly was doing his best to, you know, mediate and tell her, you know, it's, you know, this is what has to happen now, but you're going to have your day in court. Like nothing's, you know, we're going to figure this out.
Did you look around the living room at all? At that
Yes,
point?
I did.
And did you notice something?
Yes. So on the couch I was near, there was clothes everywhere. And I could see a handgun case sticking out. And before that, Lieutenant Daly had asked Kelsey where her firearms were. She said they're in the basement. And while they were having that discussion, I saw the handgun case, picked it up, opened it. It was empty. And Kelsey reassured me that they were in the basement.
Okay. So that was the second time she said they were in the basement.
Yes.
How soon after you got in there was that question asked about where the guns were, if you remember?
It was almost immediately.
Okay. That was one of the first questions?
Yes.
Okay. So what happened next?
So we told her that, or Lieutenant Daly told her that Justin's going to come and pick up the baby. So she said, you know, how long is he going to have him? I need to pack for him. So me and Lieutenant Daly began following Kelsey as she packed for the baby.
Okay. And did she do anything with the baby when you guys were following her around, if you remember?
I believe at that time, Officer Noonan was holding the baby.
Now, you said you were following her around the house,
That's correct.
was it? Why was that?
It was still, we were still a little bit on edge. She had to go to the kitchen. I remember when me and Lieutenant Daly followed her in the kitchen, I was concerned because there was butcher knives all along the kitchen. That was just something that stood out to me.
Okay. Was it your intention for you or another officer to be with her the entire time?
That's correct.
Is that standard practice when you're have similar concerns?
Correct.
After you went into the kitchen, do you remember where you went?
I believe we went upstairs. Me, Kelsey, Lieutenant Daly, briefly came back downstairs, and then we went into the other side room. I think it's like an exercise room.
At any point, if you remember, did the defendant make a call?
Yes, at some point she called her mother.
So after you came downstairs, at some point, did you take possession of the baby?
That's correct.
What happened while you were holding the baby? Anything?
Yeah, so I took the baby from Officer Noonan, which Kelsey asked me to do, which I did. Kelsey told me, why don't you take him for a walk? He likes to look at the cars. I told her, I said I'd take the baby, but I wasn't going to leave. So I took the baby out on the porch, and the baby was crying, so I was doing my best with the baby. And at that point, her mom showed up.
Through that same door you guys had come in?
Correct.
Okay. And so what did you do when she came?
I peeked in. I told Lieutenant Daly, like, the mom's here. Why don't we give her the baby? And we invited the mom in.
After the mom came in and you handed the baby to her, did you stay in the immediate area or did you go somewhere?
So once the mom came in, she was pretty upset with us, but Lieutenant Daly explained the situation to her. So at that point, me and Officer Noonan followed Kelsey upstairs so she could pack more things.
Describe upstairs, if you would.
There's a landing. It's a T hallway.
Hold on a second.
Yeah.
Okay.
You go up the stairs. There's a landing, and there's a room off to the left and a room off to the right.
And could you describe the room off to the left?
It's got I believe it's the baby's room. Has a crib in it.
And how about the room to the right?
That would be Kelsey's bedroom.
Now, you said you followed her up there. Did she go in any one particular room?
She moved between both the rooms.
While you were up there?
Correct.
And what was she doing?
She was packing. At some point, she mentioned that Justin doesn't have a car seat. So she handed me a car seat. I was holding it, started putting more and more stuff in there. And at some point I put it down.
Why'd you put it down?
I didn't want to have my hands tied up.
And did that continue for some bit?
Briefly, at some point, she heard a female's voice downstairs, and she made a comment to me. She said, "Who's downstairs, my baby?" I said, "I believe it's your mom. I mean, we were just there." And she said, "That's not my mom's voice." And I got the sense that she wanted me to go downstairs and check, but I just kind of dismissed it at the time.
And so you stayed up there.
I stayed up
Do you
there.
remember which room that was in when you were having that conversation?
That was right at the landing. So she had moved, I think she had moved back to her bedroom, and as she was coming across, she had mentioned it. And at some point up there, I'd found another handgun case.
Okay.
And
Where was that?
I honestly couldn't tell you which room it was in.
Okay. And did you look into it?
I opened it and she saw me open it and she said, I already told you they're in the basement.
Was there anything in it?
There was nothing in it.
At some point, was your attention drawn downstairs again?
Correct.
Okay, can you tell us about that?
Yeah. So at some point, Justin came. Kelsey heard his voice and she said, I don't want him in the house. And at that point, I thought the only thing that was going to escalate the situation is them two in the house together at the same point. So I wanted to help Kelsey out. So I told her I'd go tell Justin to leave.
Okay. Where were you when this conversation happened?
Between me and Kelsey, we were still upstairs.
Okay. And was Officer Noonan also with you?
Yeah.
So did you go downstairs?
I did.
Okay. Officer Noonan stay up with Kelsey?
Correct.
Where is she at this point, if you remember?
She was either in her room or at the landing, but I couldn't be certain. But when we had that conversation, we were at the landing.
Okay. You went downstairs?
Correct.
And what did you do when you went downstairs?
So when I went downstairs, I only saw Lieutenant Daly, the mom, and I told him, Kelsey doesn't want Justin in the house. And he said, all right, Justin's, I don't know if he said he's in the basement or he's coming up from the basement. He said, just go to the basement and tell him just to wait outside.
Okay. So where'd you go?
I walked past Lieutenant Daly and Kelsey's mom through the kitchen where the basement, the top of the stairs is, and I opened that door.
Could you see down?
So it was, the lights were off. I flicked the light to turn the lights on. The lights didn't turn on. So
could you hear anything downstairs?
I couldn't hear anything. And I remember after I flicked the lights on, they didn't go on. And I'm looking at a pitch black basement. I thought there was a chance I misheard Lieutenant Daly. And I just kind of stood there. I was like, I really don't want to walk down there if he's not down there, but I don't know how I was just kind of having like a moment where I wasn't sure whether or not to check with Lieutenant Daly.
Okay. Did something happen at that point?
Yeah. So at that point, I heard Officer Noonan yell, Kelsey, and then I heard 2 gunshots.
What did you do?
I ran back the way I came. At that point, it was only Kelsey's mom. She was still in the living room. Lieutenant Daly was gone. He'd already gone upstairs, and I started making my way upstairs.
Okay. When you were making your way upstairs, could you see anybody at the top of the landing?
I could see Officer Noonan.
And what happened as you went up?
So, I mean, I knew it was gunshots. I came over the air and I said, start medics. I don't know if that got caught or someone else was calling at the same time, but I had my pistol out and I was going up the stairs. I saw Noonan and I said, like, you good up there? What was that? And I can't remember exactly what he said at that point.
Can you give us the gist of what he said?
At that point, he said, yeah, he looked like he was still in shock. He said, yeah. So I kept moving up towards him. And as I got closer to him, I was like, what just happened? He said, she pulled a gun on me. And we talked about it later, but at that point, that's what he said.
That's fine right there, actually. Okay. I just didn't want anything further. Okay. Thank you.
Do you remember the exact words he used?
So the exact words he used would be after the FD and we had gone into the other room and spoken. But at that exact moment, that I don't even.
What's the basis?
So I'm not, I guess it's a vague question because I don't know what he's referring to in terms of what conversation, how long is it after the incident, what's the demeanor, what's the purpose of it being offered for. There's a lot to unpack here.
All right, well, what the answer was didn't include hearsay. It just was that I think it was something to the effect that later on they went in the kitchen, maybe he and Noonan and had a discussion, something to that effect, but the objection is overruled.
So the fact of the discussion, I don't object to, but just any further, I'm trying to stop it from coming out. Thank you.
Would the exact words that he used when you first ran up the stairs, would it help you to remember if you looked at a report?
I know he did say she pointed the gun at me, pulled the trigger, and racked the slide. Whether it was right when I was moving up the stairs or once everything got situated, it was
Wow.
time frame, but I can't remember if it was exactly when I got to the top of the stairs or.
Okay, would looking at a report help you remember that?
Have you been watching Captain Miserable up here?
No, I just saw this.
I'd be like, dude, hello, sir, do you hate life? Sir, you rude being here? He's a miserable looking dude.
I don't know what conversation he's talking about. It's hearsay and frankly news to the defense.
Okay, so first things first, on the hearsay issue, Mr. Gubitosi.
I'm trying to establish that it happened seconds after.
Oh, tell him. Why don't you tell the witness what you want?
Truth of the matter or state of mind? Both. Okay. And so, to the extent that you're seeking to offer for the truth of the matter, it's hearsay.
Right.
And I think, didn't we already litigate the spontaneous utterance?
Yep.
No, that was a different time frame.
Oh, that was a different, all right. So are you arguing that this should be admitted as a spontaneous utterance?
Yes.
Oh, he said it twice now.
And then the rest of your objections that is within there, let's just take them a step at a time. Let's get through the spontaneous utterance. So, Mr. Bradl, what do you say on the spontaneous utterance?
So I think there's certainly a lack of foundation, Judge, where there's been two different overlapping statements that are referenced here. I don't know where they're going back to here. It needs to be clarified foundationally what happened before the statement, how long after the shots it was, what were the circumstances of that particular first statement they want to try to use. So that's what I asked for.
I agree with Mr. Bradl that it's the foundation right now, and it's not the witnesses, it's no one's fault. The foundation right now, to me, is confusing because he's having trouble remembering which conversation.
I do understand that. That's why I'm looking to approach with the report.
Okay.
To refresh his memory, yes.
All right, well, why don't you do that and we'll take it a step at a time.
They're trying to say he said this twice now. Once the 5 minutes after and once immediately after.
Just so you know, for right now,
Right.
I'm not going to strike the testimony because it can come in for state of mind. The issue is whether it comes in for the truth.
Thank you.
Wow, what a bunch of liars.
Liar, liar.
And did he say his memory was exhausted? I don't remember him saying that. Did I miss that? You guys, did he say his memory is exhausted? Because I haven't been listening right now.
Does that help you remember the timing of that statement?
I think he said, I don't recall.
That's correct.
Okay, when did that statement happen?
So that statement happened when I got to the top of the stairs.
Right.
I don't know what statement it is because he's
Sure, I'll ask him.
He's recited two different statements. Again, I'm not casting aspersions, but it was she pulled the gun on me or she pointed a gun, racked trigger, etc. So
thank you, Judge.
Sure.
Some bullshit.
What statement did you hear when you ran up the stairs the first time?
So she pointed a gun at me. I'm speaking from Officer Noonan's perspective. Pointed the gun.
I can't hear you.
She pointed the gun at Officer Noonan, pulled the trigger. and
Fucking
then racked the
Captain
slide.
Miserable.
No, I said all of it in the one statement.
All right, and there's an objection to that coming in for truth of the matter?
Yes.
Should take your time.
Did you see the build up to this, Judge? Because I missed it.
Yeah, I was listening, but I mean, what a mess. And I think
Pause it, babe.
I think it's one thing, you know, for a judge to try to clarify. It's another thing to tell the prosecutor how to get it in. Oh, are you doing it for state of mind or an excited utterance? Prosecutor, in my view, has no clue how he's getting that in. He just wants to get it in, you know, and I understand it's a bench trial, But it's just like, just to clarify, are you getting that in by state of mind? You know, I have, you know, have an issue with that. You know, you're not supposed to be very, very clear. I said in case law, you're not supposed to appear to be helping either the prosecution or defense. You're supposed to only clarify. But when you get into evidence and try to clarify it, then it becomes an issue. So we'll see what happens.
Bloop it back 10 secs, babe.
Okay. Oh, look at him. Captain Miserable. Wah, wah. Oh, I hate being here. I hate all this.
Judge, there's still a lack of foundation here, Your Honor. Now he's saying something different than what he said 2 answers ago about what the statement was. So
Yep.
this is, in terms of any sort of reliability, preliminary finding of any of this, it's all over the place. He just said something completely different than what he said before.
He's now clarified it, so we're beyond that. And so he's now has identified the statement, identified where it was made, when it was made. There was some mention before about the declarant state of mind. So I guess what I'm politely saying is you need to move beyond that. So now the issue for me is, does that statement come in for the truth of the matter? And
Judge, I think that I'll reiterate.
Wait, if it wasn't an excited utterance when Noonan was on the stand, why would
Babe,
it now?
He changed the time frame. Noonan said it happened 5 minutes after. So, you know, now he's claiming that this happened right at the top of the stairs, which, you know, and he's changing the story. But the question is still that this is what Bradl needs to do. He knows that this judge found before that he could not find by a preponderance of the evidence that statement was made without the ability to have reflective thought. And that's what Bradl needs to drill home right now, that, Your Honor, lack of foundation because the state cannot establish by a preponderance of the evidence that this statement was made without the ability to have reflective thought. So it should be excluded.
Well, and if he's going to give more weight to this guy than to the guy who said it, what does that say about his weight that he's giving to any of Noonan's?
Oh, it wasn't when Noonan said it. Sorry. It was when Davis, whatever the other, I don't know, Davis, I forget the guy's name, but it wasn't Noonan. It was the other guy.
Wait, who?
The sergeant. I forget his name now. I'm drawing a blank.
I mean, that guy wasn't in the room.
Well, but he's the one that tried to get it in and said it was 5 minutes ago. And the judge said that although a lot of the factors lean towards excited utterance, I cannot find by a preponderance of the evidence that this statement
Daily, they're saying.
Daily. Yep.
Either way, if they didn't find it was an excited utterance, I don't care if he changed the time frame.
And the statement, though. He's now changed the statement as well. So he's making it, the state is trying to present this as a completely different statement at a completely different time.
It proves my point even more.
That they're a bunch of liars.
Yeah, right. Yeah. I mean, well, it's just it's unreliable. Like the inherent reliability of an excited utterance that's the entire point. You don't have time to come up with some shit.
Yeah.
So you're spitting it out contemporaneous to the thing or right immediately thereafter.
That's right. That's what gives it credibility if it's an excited utterance. But the whole thing about, with the judge saying is the state of mind. I mean, even if you accept it as that, you can't accept it as truth. So you can't weigh it for the truth of it. So, what's the point, if you're going to allow it in? I'll allow it in as excited utterance. I'll allow it in not for the truth. I just don't get that. It's like state of mind is what I think is he talking about state of mind, the judge?
Yeah, he said he would let it under state of mind. And now the question before him is, should he let it in as an excited utterance where it would go in as an exception and therefore for the truth of the matter?
Right. And it's hard to put a lot of reliability on that, is calling it an excited utterance when someone said something different earlier. So we'll see, but what a mess. And I think, it's good that the defense is really kind of pounding away on this. But I do think the judge is confused because they're making it confusing.
Yep.
So, well, we'll hear and then.
Yeah, let's go, babe. Back up 10 seconds.
State, you need to move beyond that. So now the issue for me is, does that statement come in for the truth of the matter? And
Judge, I think that I'll reiterate my arguments from the earlier discussion about the other excited utterance statement, Your Honor, that this isn't like a domestic violence situation where someone is, you know, a battered woman or something, where the time frame is much more flexible. And in this situation, you have an officer-involved shooting that happens.
There was time for reflective
Another
thought.
fellow investigating officer comes right up
Say it.
Yeah, pretty quick.
Wait, did it just jump,
And
babe?
you said
Did
that.
the auto
Mr.
skip.
Simmons.
It did the auto skip.
assertion that it qualifies as a spontaneous.
Oh, Scoop, it sounds like
Really
he's finding it.
happened, the government would have given me discovery on it. It didn't happen.
Keep going.
Back?
That testimony
Right there, I think.
being under the influence of the event.
Oh,
that
keep
you're
going
not-
a little more.
Yeah.
And in this
Come in for the
There we
truth
go.
of the matter.
Put it right back there. It's
And
fine.
Judge, I think that I'll reiterate my arguments from the earlier discussion about the other
Yeah.
excited utterance.
Reiterate.
That this isn't like a domestic violence situation where someone is, you know, a battered woman or something, where the time frame is much more flexible. And in this situation, you have an officer-involved shooting that happens. Another fellow investigating officer comes right up there, and there's a huge motive to fabricate immediately, Your Honor, that something happened that covers the officer, covers the shooting officer, versus being under the influence of the event so that you're not fabricating. There's an immediate impulse here that this officer has to cover his future. He has to cover his conduct right away. There doesn't need to be much time to realize that from an officer who jumps the gun, from an officer who panics and shoots someone in the wrong circumstances. That's something that would immediately happen. And particularly where there's no surrounding corroboration, where there's no attempt by the government or no testimony from Noonan that this happened. This is something completely different that the statement happened, that this interaction with Houston happened. There's extremely unreliable circumstances. If that really happened, Noonan would have testified to it. If that really happened, the government would have given me discovery on it. If that really happened, it would have been corroborated. So.
The discovery, the lack of discovery or argument is a different matter. Anything else on, again, on just the Commonwealth's assertion that it qualifies as a spontaneous utterance?
No, Your Honor, just the notion that it's not a domestic violence situation. It's a situation where the motive to fabricate immediately arises. Thank you.
Okay, Mr. Gubitosi, anything further on that?
This is exactly what the exception is for. It couldn't have been more immediate unless Officer Houston was standing next to Officer Noonan when it happened. He immediately heard the shots, immediately heard the yell, and ran up the flight of stairs that you've seen pictures of, and asked what happened, and got that response. So that's my answer to that. And as far as, I think I have to, since we're on the record, talk about a discovery violation. We're not there yet.
We're not there yet.
Okay.
Okay, let's just take it a step at a time. Anything else?
No, thank you.
All right. So I'm going to sustain the objection, but for reasons different than Mr. Bradl articulated, and essentially for the same reasons that I stated yesterday to Attorney Moriarty, and
Thank
that is
goodness.
that when I weigh the factors under Baldwin, I come out that it militates towards excluding it for the truth of the matter. It will come in for state of mind. We don't need to get to alleged discovery violations or any other reasons because I've sustained the objection. Unless you want to
I just like to
make
put
a
on the
record.
it was part of his recorded interview that they've had since the beginning. So.
All right.
Now,
So-
sir, after you heard Officer Noonan tell you that she pulled out a pistol, pulled the trigger, and racked around, where did you go?
At that point, I was at the landing. I looked in and I saw Kelsey on the ground and I saw Lieutenant Daly over her.
What was he doing? Anything?
It looked like he was kind of evaluating her. I moved towards them. I asked either Noonan or Lieutenant, I said, where's the gun? I believe I asked Noonan, and he motioned away from Kelsey, so that stopped being my concern. I moved close to Lieutenant Daly just to see what level of consciousness Kelsey was. I could see she was breathing, she was alert. So I told Lieutenant Daly I was going to go get a med bag.
Was she saying anything?
She kept saying, I'm sorry, I'm sorry, I'm sorry.
And so where did you go?
I ran down to get the medical bag out of my cruiser.
Okay. Did you get it?
I did.
Did you come back?
I did.
And what did you do when you came back?
I threw the medical bag on the bed and I started taking stuff out. I took out the AED, I took out gauze, wraps, stuff like that, handed it to Lieutenant Daly.
Okay. Sure.
Side note.
So, Your Honor, would you, hey, babe, I don't know, I was echoing, but now I'm not. When we get to, assuming this is like the last witness, when we get to a directed verdict motion, is it fair to say without her testimony yet, he'd have to deny it?
I do think he would deny it, because of course it's the Lattimore standard in light of the evidence most favorable
Right.
favorable to the
Prosecution.
prosecution, right, Lattimore. But I think it would be likely he would deny it. I'd rather have him find her not guilty, because when you do a directed verdict and you make a finding in favor of the defendant, the Commonwealth can still appeal the directed verdict, but you can't appeal a not guilty finding. So,
Perfect. Great. All right, let's go, babe.
I'm going to jump back just a minute. When you went up the stairs and you saw Officer Noonan, did he have his gun out?
The med bag or before that?
First time.
First time, he had it out.
And how was he holding it?
He had it at the low ready, so he had it kind of down towards the ground.
Pointing to the ground?
Yes.
Do you see Kelsey Fitzsimmons in the courtroom here today?
I do.
Can you
they're
point
wrapping
to her and
up.
describe an article of clothing she's wearing?
She's wearing like a beige sweater.
May the record reflect she's identified the defendant?
It may.
Thank you. I have nothing else.
This has got to be their last witness.
Good afternoon, sir.
Good afternoon.
You said that Ms. Fitzsimmons initially exhibited a lack of certainty, or that she was unsure why you were there, correct?
Correct.
And how was that manifested?
She just looked surprised. Her eyes were wide. She didn't, I guess it's the best way I could describe it.
Then why do you all keep talking about why or where her car was parked? Because you seem to implying that she knew and she was trying to dodge service.
Or preparing
Now,
to do something that she was had intent ahead of time.
Is that what they're thinking? Because I literally, having watched this for 2 days now, see zero relevance, maybe less than zero relevance that the car was parked over by the school, because there could be a million reasons. And I just want to actually correct something I just said, because even though directed verdicts are appealable in other states, Massachusetts changed the rule a while ago that it qualifies as a not guilty, as an acquittal, and is not appealable. I'll check that, but I'm pretty sure that rule change in Massachusetts is not true in every state, I believe, but in Massachusetts, I believe it. So, directed verdict that would be really great in this case. I just don't think he'll do it.
Nah, he won't do it. He won't do it. But it would be great. Now that we know that they can't appeal it. Plus, he could avoid the whole, like getting into the, well, I think the cop's a bit of a liar type thing, worrying about liability.
But I think that
his lawsuit down the road.
On the evidence they have in front of them, without her there to challenge it, I think when you look at it in the light most favorable to the prosecution, the non-moving party, the judge would have to deny it. But that's why I asked Judge Carol what she thought.
Well, I think one of the things, that I think, Bob, you've said over the past couple of days is, let's say he looked at it as all things being equal, like her explanation could be just as equal as his, even though that hasn't come in. There certainly has been evidence that she was trying to get people out of the room and all of that. If all things are equal, then, he'd have to, I think he'd have to allow it, but I don't think he will. It's so rare to allow a directed verdict because the Commonwealth has put Noonan on, and I think the defense is going to have to maybe do more to sort of undercut that testimony.
And just for any of you out there who are wondering what the judge just pointed out is that because the defense put in evidence that she was trying to keep him away from her, she was trying to send him downstairs, she was trying to get him out of the room. She did say things like, I wanted to be unalived, that those kind of things call into question and that she gave him the baby, that she trusted him, like that those kind of things call into doubt her intent, and that there might be enough there to make a directed finding, although you don't think that he would in this case. Did I say that fairly?
Yeah, I think that's very accurate. So I think it's I don't know. I think all things being equal, but yeah, I think I think ultimately, I mean, if I were hearing it, I would consider that evidence very powerful, because she worked pretty hard to get him out of that room.
Yeah.
And he was the one that, she was going to kill him. Would you say, hold my baby?
Right.
Would you say, feed my baby?
Right.
Would you
I
say,
mean, it just shows she had no animus towards him in particular. You know what I mean?
Exactly.
Yeah.
Exactly. But I think that what's really, strong in my head about this is, one, she had no animus towards him. They had worked together in the past. And of course, she tried to get him out of the room. She has him feeding the baby, all of that, so why him?
Right.
Why are we going to take out a gun and kill him?
Right.
So, because it seems when you're balancing it, all of that information seems to tend more in favor of the fact that she was going to harm herself. And the other thing that we didn't mention that I think is important to mention is, when did she start shaking and become really upset and possibly form the intent to kill herself? According to this witness, because I hadn't heard this before, that's when she heard that Justin was in the house. I don't want him here. I don't want him in the house. He's the one that filed the restraining order. To me, the timing of this is highly relevant.
Yeah.
Highly relevant.
Yeah.
Because when you look at it in terms of what was unfolding, it can fall apart, and you can start looking at these things in a different time factor. But for me, when he testified, well, she was asking me about Justin. She wanted him out of the house, get him out of the house. I'm talking to the lieutenant. I'm saying, get him out of the house. He's in the basement. She knows he's in the basement. And then according to Noonan's testimony, what happens is her whole demeanor changed. She's shaking and getting nervous, and all of a sudden a gun comes out. To me, you know, if I were hearing this as a judge, I would say, boy, you know, that's really relevant to me, that that's when she took the gun out, you know, after trying to get him out of the room. And I hadn't looked at it that way before, because I'm just listening to this guy's testimony now saying this is when all this stuff with the gun started happening all around Justin.
I had said that before you came on, that exact point. Like in my estimation, it was when she learned of Justin in the house is when everything changed.
That's right.
Like everything. All right, let's keep rolling.
Yeah,
definitely. Eyes were wide. She didn't. I mean, I guess it's the best way I could describe it.
Now, you were with her for a good amount of time during this interaction, right?
Correct.
And it's true that she tried to kind of get you away from her a couple of times?
That's what I believe, yes.
She gave you the baby and said maybe go out on the porch and or take him for a walk?
Correct.
And then she also put some, tried to put some things in your hands and asked you to take him downstairs?
She didn't ask me to take him downstairs. She just put them in my hand.
And where did that occur?
On the landing.
Upstairs?
Upstairs.
Which is in essence saying,
heard Officer Noonan yell Kelsey,
Correct.
and that's all?
That's all.
One time?
One time.
And how about after the, after you said Kelsey, how long of a time elapsed until the gunshots?
I couldn't put an exact time. It wasn't instant, but it was relatively quick.
Relatively quick. How about the gunshots themselves? There was 2 gunshots, right?
2 gunshots.
Were they in quick succession?
Relative, yeah, pretty quick.
And you said that Ms. Fitzsimmons said, I'm sorry, I'm sorry.
Correct.
Did she say, I'm sorry, I tried to kill myself?
She did not say that.
Just, I'm sorry.
I'm sorry. 3 times.
it's not the other guy said I
Now,
wanted.
was there a plan before this to section Kelsey?
No.
You mentioned that you had known that she was sectioned before, right?
Correct.
And that was several months prior, wasn't it?
I don't know exactly when it was.
Okay, so it's fair to say that you don't really have any grasp of the details of that incident, do you?
I do not.
And you don't know whether it had anything to do with the police or not, do you?
I know there was police there, but I don't know the circumstances of what happened.
Okay, so you don't know how long it was?
No.
And you don't even know whether she was in fact accepted as a Section 12 commitment, do you?
No.
That's what the judge has been waiting for.
Do you know the difference between having forms filled out to be looked at under Section 12 versus being accepted and committed under Section 12?
Yeah, so I didn't want to, like I said, I was invited to her wedding. I was friends with Kelsey.
No, that's not my question. I asked you some stuff about Section 12.
I know if you get sectioned, you're going to be there for probably 72 hours. And
Wrong.
You can't leave.
And do you have any idea whether that happened in March?
I have no idea.
So it's fair to say that other than kind of the notion floating around in your department that she was sectioned, you really have no information whatsoever about it. Isn't that right?
No, I didn't want to know.
He's completely wrong on the law.
And then you said something about
witness.
knives in Ms. Fitzsimmons' kitchen.
Correct.
What's the status of the knives in Ms. Fitzsimmons' kitchen?
Just at that point, I wasn't sure what was going to happen. So I didn't want her to reach for a knife. It's nothing against her. It's just, it's a lot of information to take in. I didn't know how she was going to react.
Okay, so was there something strange about the knives that were in her kitchen?
No, it's just a weapon in the kitchen.
So when you're serving one of these things, anything can be a weapon, right? Any normal household product item can be a weapon, right?
I wouldn't say anything.
A lot of things. How about that?
Yeah, let's go with that.
And in this case, there were knives in her kitchen. Is there anything more to it than that?
No, that's it.
One moment, please, Your
Yes. I need to go to the bathroom.
Bob.
Somebody requested it. I had to do it.
Oh.
So while they're doing that, good questions, because he's saying you sectioned him. Police have the opportunity, all police can do what they call a pink slip, which means if they think there's a mental health crisis, they can section someone to the hospital, but the person has to be seen within 2 hours, although it rarely happens because there's so many people in the emergency room. But they have to be seen, and then there's a decision to make whether they're going to commit them for a period of 72 hours at least, and that means that they would have to be hospitalized. The witness is confusing those things. I think what Bradl was getting at, she's probably discharged.
Pause it, Bay.
Oh, sorry.
Leave someone alone, right?
I was waiting to see if that guy was going to rust. We rust.
Yeah, I mean, I think the defense is headed in the right direction, because what they're saying to the police is, you don't even know what happened. The only, and the judge knows this, the only authority the police have is to take someone to the hospital and drop them off. They have zero idea what happens after that, unless they stay there because the person's under arrest and hasn't been arraigned, which wasn't, the case when they went in and they're talking about, we're going to have to section her. Section her just means dropping her off at the hospital. But then you have to be seen by a psychiatrist or a psychiatric nurse practitioner within a few hours, and then you just generally discharged. And it's rare that anyone's going to be then admitted to a hospital for 72, 3 to 4 days or 3 days. And after that, then there's going to be a hearing to commit. Well, she was never committed, which means she was probably discharged from the ER. And so, it's interesting. It's like, well, we're relying on the fact that we made the decision to send her to the hospital, but they have zero evidence of whether or not she was even held for the 72-hour period. And whether it was even if she was in there for 72 hours, she could sign a voluntary and sign herself up. I mean, so just it's just frustrating to hear. It's like, no, we knew that we had done, that we had pink slipped her before. It means nothing unless something happened to show that she was a danger to herself or others. And I don't think that happened. So I think they're going to have to get that in. But I will say the judge understands that. But, what bothers me is that police officers are doing these pink slips and they have no idea what it means or what happens afterwards. That is just unacceptable to me.
Yeah, and scary.
Scary.
And any redirect?
Yeah, just briefly. A
Okay.
lot of things could be weapons, correct?
Correct.
So that's why you don't leave someone alone, right? That's why you keep eyes on them the whole time.
Correct.
That's why you use a term in their pocket while they're walking around, correct?
Correct.
Thank you.
Any recross?
Nothing further.
Okay, all right, you may step down. And Commonwealth, you can call your next witness.
Here he goes, Captain Miserable.
They've got another one. I can't believe it.
Oh. Whoa. Gallery shot there, huh? Talking about man spreading. That guy was.
Bloop, bloop.
Look at that man spreading happening right there in the purple shirt.
Thanks for pointing that out, babe.
I mean, it was impossible to miss.
I'll update the ticker.
Could you raise your right hand? Do you solemnly swear that the testimony you're about to give in this cause now and hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Guy really puts his hand up in the air, doesn't he, Judge?
Yeah, I know.
Good afternoon, how are you?
Could you please state your name, spell your first name and your last name?
Yes, my name is Michelle Mitchell. Michelle is Michelle. Last name Mitchell, Mitchell.
And what town do you live in?
I live in Ipswich, Massachusetts.
What do you do for a living?
I'm a correctional officer.
Um,
I'm a correctional officer.
And how long have you been doing that?
8 years.
In Middleton?
Yes,
Do you know Kelsey Fitzsimmons?
I do.
How do you know her?
We were coworkers and we eventually became friends.
Now I'm going to jump ahead in your relationship. Well, when did you meet her? Do you remember?
The end of 2021.
At some point, you knew she was getting married.
Yes.
Were you going to be part of that?
Yes, I was a bridesmaid in their wedding.
I'm going to turn your attention to June 30th of 2025. Do you recall that day?
I do.
At some point, did you have a conversation with her?
I did.
And was that over the phone?
Yes.
And can you tell us about that?
Yes, we talked on the phone and she was driving around North Andover and she was crying and I heard her baby crying in the back seat.
Did she tell you why she was crying?
She said that she needed Justin.
Any more than that, or was that the gist of it?
That was the gist of the conversation. And then she said she had to pull over to feed the baby.
Now, where were you when you had that conversation? Do you remember?
I was in North Andover driving around trying to meet up with her.
Did you ever meet up with her that day?
I did not until I saw her later in the hospital.
You, where did you go? Did you stay in North Andover?
I did up until I went to the hospital after she was shot.
Okay. Where did you go in North Andover? Anybody's house in particular?
I went to Hunter's house.
Okay. And who is Hunter?
He is a friend of Justin's.
And Justin Alayan?
Yes.
And who do you know him to be with regards to Kelsey?
He is a coworker of Justin's and also a friend of his.
Oh, I'm sorry, Hunter. I meant of the defendant. Who is Justin in relation to the defendant?
Oh,
sorry
Justin.
if that was unclear.
That's okay. Justin was Kelsey's fiance.
Was anybody else over Hunter's house?
Yes.
Who was that?
It would be me, Justin, Katrina, myself, and Justin's sister, Courtney.
And who is Katrina?
A friend of Kelsey Fitzsimmons.
Was she also in the wedding, if you know?
Yes.
And without getting into the conversation that was being had between the half dozen of you or so, do you know if Justin made a decision to do something?
Yes.
What was that?
He was going to go to the Lawrence courthouse to file a restraining order 209A and also get temporary custody of the child.
Okay. And at any point, did you see the defendant in the area of Hunter's house?
Yes.
Can you tell us about that?
Yes. I witnessed her drive by Hunter's house.
Okay. Thank you. I have nothing else.
Oh my God.
Wow.
Yes. Good afternoon, Ms. Mitchell.
Good afternoon.
Just a couple of questions. You said that you spoke with Kelsey on 6/30/25,
That is correct.
and she told you that she was driving around. She said that she was meeting Justin, right?
No, she was not meeting Justin.
Did you say needing Justin?
I thought you said meeting.
I did. Wasn't she going to meet Justin?
That was what I understood from Justin, but she didn't tell me that on the phone.
Okay, she said that she needed Justin.
Meeting or needing? You need to clarify that for me.
I think I said needed. She said she needed Justin.
Needed Justin, that is correct.
Okay, so just let's put that over here. And she had also told you that day that she was meeting Justin, right?
Yes, thank you for clarifying.
So she couldn't meet with you because she was meeting Justin, right?
That is what she said.
And you said there was some sort of gathering at Hunter's house,
Yes,
and that was a social gathering with swimming and drinking, right?
that is incorrect.
Was there swimming?
No, Mr. Bradl.
Was there drinking?
Also no.
And it was you, Katrina, and Justin and his sister and Hunter.
What is up with her attitude? Why is she so antagonistic? Like, what is her vested interest to be such a shitbag?
Yeah, her vested interest seems to be, she's like on Team Justin.
Yeah, is she maybe in Team
She doesn't want
Justin's
anybody
pants?
challenging it. But don't you find it odd that she, first of all, Kelsey's saying, look, I'm needing Justin, meaning I'm needing to see him if that's what he said, but what difference does it make? And I'm meeting him. I mean, aside from the fact that her testimony is a big nothing burger, what bothered me as a judge listening to it is I would say, why are all these people gathering together and planning and talking about getting a restraining order and getting custody of the baby?
Yes.
What? Because all that tells me is just what I've been saying all along. There was this ongoing sort of manipulation, possibly by Justin and his sister. The sister's there, Justin's there, the fire truck people, the fire department people are there, and she's there. And they're all talking about getting a restraining order. This is the conversation. Well, like, what was it like, like, let's have a party and talk about it. Just seems to me that there's some kind of planning going on here. And, I have been saying this all along that, someone earlier on the chat said, I don't think there was a conspiracy with Justin. I just think, he was doing what his mother said. And I'm not saying there's a conspiracy either. I agree with that person. What I've said all along is there was a manipulation. There were calls from the fire department. They all work closely, each other with the police department. And there were calls. As you know, before this, there were calls, which I don't know if that's going to come in leading up to this, where there was this back and forth between he and Kelsey, which, had these sort of, I don't know, these sort of maybe passive aggressive comments or whatever. But I not only as a judge listening to this, would I think it helps the prosecution's case? I think it would hurt the prosecution's case, and I think it would help the defendant's case, because once again, it seems like there was a lot of stuff going on and talking about Kelsey and sort of planning something and telling people, hey, I think she's dangerous. I'm getting a restraining order and I'm getting custody. That
I'm with you, Judge, 100%. Like, if I'm the judge who is absolutely watching her demeanor, like just like any trier of fact, and he's got to be wondering the same thing. Like what is with the dude?
Yeah,
and it's like the lady doth protest too much a little bit,
Yep.
and it does give that Team Justin vibe. It
Yep.
really does.
Yep.
And for the record, Justin and his mom can absolutely be. It just takes two to tango for a conspiracy. So, I just think mom was driving this. I think mom was the one planting the seed. I think she wanted that grandbaby.
And we know from the recorded phone calls that him and his sister were literally scheming because they didn't want Kelsey to take the baby to go see her family out of state.
Yeah, and when they landed on the
making it sound like she was fleeing the state. She's taking the baby and fleeing the state. She was going to a 4th of July party to her mother's home in New Hampshire. And then the sister gets on the phone, right, according to the phone calls, and says, and he's asking, well, what rights do I have as a father? And, I think the sister mentioned the word custody at some point. I'd have to go back and listen to it. But this whole thing, that is, piece by piece by piece, leading up to what became a very violent restraining order with a person, he and his sister having a big meeting with all these people and talking about a restraining order and making a plan. And one of the interesting pieces about that is before that, when they were making the phone calls, a day or two before that, and they weren't getting help from the police, and the police saying, hey, she's the parent, she has custody, she can do what she wants. None of that was working for them. And then all of a sudden there's this big meeting and, hey, we're going to get a restraining order and we're going to get custody and sort of this, whatever you want to call it, these actions start taking place and escalating it. And then the police become escalated. And then there's heightened concern and it results in a shooting. No one should be surprised. But I have to tell you, I went into this, especially listening to Officer Noonan, thinking, I might find her guilty, because a gun appears and, a gun should never appear. You weren't here earlier, Bob, when I was talking about that the standard is very, very different for clearing an officer, because that's a constitutional standard under Graham and under the very recent case of Barnes. And so under those standards, he should be cleared. But I've also been clear that doesn't mean that Kelsey is not, cannot be found not guilty. And so I'm just listening to this, and it's really disturbing.
Here's where I'm at with this gal in particular, because when you're going in ex parte and you've prepared your petition, and if it's you and maybe your mom and maybe your sister, that's one thing. When you start throwing in either affidavits from two people who are purportedly Kelsey's friends, namely this gal, that gives an awful lot of weight to what they're saying, because these people, at least in theory, don't have a vested interest.
And they knew that. They wanted to get somebody that was
that's my
third,
point.
Right. No, I hear you. I know that's your point.
It is. It's the right point. It's like, and by the way, Judge, it's not just me, my mother, and my sister. This person is her bridesmaid, and this person's one of her best friends. And even she thinks, after we had this meeting and all discussed it, she also thinks, I mean, I will say this and then you can get back to it. But the way this case prior to the trial has been manipulated, first of all, with the sua sponte creation of a revocation hearing out of a motion to modify that put Kelsey in jail from a judge who wasn't assigned to that courtroom, and a judge who actually went and met with the probation officer to try to get the probation officer to take the position of revocation. The way Kelsey Fitzsimmons has been treated in the system is just like, it's stunning for how this has happened. I mean, that whole, the motion to recuse is like shockingly powerful. And, we talked about that a bit yesterday, and I've talked about it on other podcasts, but I'm just, it's really disappointing for me, having been in the system and having been a judge and trying to do things the right way every day, done thousands of, revocation hearings and stuff. It's really just so frustrating to hear that you have this whole system that seemed to work against her in a way that was really unfair, bail hearings where he's stopping, visits with the child, so I went on.
And it begs the question, why?
Why?
Right. It's like, and I threw it out there because I've seen it somewhere. Was there some kind of potential lawsuit pending from Kelsey towards the department? Like, I had heard something that there was that a lot of cops at North Andover did not want her coming back to work.
Mm-hmm.
I think it was about what at least I've heard about that is it's something to do with the way that women were being treated and her complaining about that. Right.
That's
maybe
what I'm
filing a
asking.
complaint.
Like, does that exist in the world?
You did notice that there wasn't one woman police officer who was asked to participate in the domestic violence in the actual service of the restraining order, if there
Which
was,
of course would have made the most sense.
and of course the social worker or the liaison that they have on staff. If you look on North Andover's police department, you'll see that they had someone, and they didn't call DCF, which is really interesting to me, that they said, we're going to be removing this baby, we have an order, but, there are serious allegations here, no. And I used to call situations like that, the race to the courthouse, where people would race to get a guardianship or custody in the probate court so that DCF couldn't take custody, even though DCF would still intervene. But, we can talk about that later. I'm dying to hear the rest of her.
Yeah, and real quick, CPT Jaxie had an interesting question, and I think it's a good question. How is any of this woman's testimony relevant to the case if Kelsey did not know about it?
Well, that's why they had her say she saw Kelsey drive by. This whole point of this, I think, was just to establish that Kelsey knew all those people were together at Hunter's house. I still don't know why that's important, but that's what they're trying to establish.
Yeah. And so what if she drove by? She knew she was going to meet him. So, and I think, in the conversations, it might have been that he was going to meet friends. He was going to meet Hunter. So she probably thought he was there and drove by, and it's like, okay, he's there, which is interesting because according to him, he had no gas and couldn't go anywhere. And so, so you can't blame her for driving by and say, look, he's lying straight out to me. Obviously, he's driving and he has gas. I mean, there are a million explanations.
Right.
Her testimony is not only worthless in terms of relevance, but, her attitude, reeks of some kind of planning in my mind,
Axe to grind.
Together. It's not helpful. I don't know why they called her. We'll see what else she says. But.
All right, let's go.
Right.
So no, that is incorrect.
Was there swimming?
No, Mr. Bradl.
Was there drinking?
Also no.
And it was you, Katrina, and Justin and his sister and Hunter, right?
Correct.
What a crew.
Yeah. Why were you there?
Now, you said that you saw her drive by the house.
Yes.
And so it's fair to say that she would have been able to recognize some or all of the vehicles, right?
Yes.
And going by the house is a route that would take her to the North Andover Common, right?
Yes, it's near there. Correct.
Nothing further.
So there's a perfectly good reason for her driving by, which is what you just.
Thank you.
I have no idea why they called her.
A waste of time.
And for the record, the movie line with friends like you who needs friends, not enemies, who needs friends is from Rushmore.
Yeah.
Bill Murray and young Dirk asking him that.
Yeah. I tell you, as a judge, how it would relate, I don't know, but I would view it very negatively for the prosecution.
Me too. It didn't help him.
How it goes to intent, maybe, I think it probably isn't relevant, but I'd have a problem. I mean, I would view it as, worry, planning.
Oh, they must have arrested.
They must have arrested. And I think this judge is going to be wise enough to know that.
Bradl, we were discussing, why don't you give me an update on the potential
Those
for
spoilers.
Yes, Your Honor, thank you.
Oh, the potential of view.
Some kind assent from the folks that live there, and it's something that we can do. And I would say that, in a bench trial situation, we're speaking directly to the fact finder, and we have moved for the view. In the final analysis, I rely on the court's discretion and Your Honor's discretion as to whether a view
would be helpful
in the final kind of look at things is helpful to the fact finder. So that's our position on that, and we think that judge will be in a position to end the defense case probably by the end of the day tomorrow or in the afternoon tomorrow.
Okay.
There you go.
All right. And as for, so would the view occur tomorrow?
I think so, Your Honor, that if that's the case, we could do it tomorrow, or we could do it after the defense case.
Okay. And Commonwealth, what do you say? Well, here's the thing. You take no position, but as I kidded with you earlier, we're gonna need your resources.
Sure.
Okay.
up to you whether you think you need one. We would absolutely assist in any way we can.
Okay, so here's the thing. I'm not going to take a position on whether I need one or not. What I'm going to do is allow the motion. You've requested it.
It's the right.
Go there with an open mind, and
Thank you.
we'll treat it like a view with the jury. You folks can point out things to me that you'd like me to remember. It will become part of the evidence like it is in a jury trial, my observations, and the issue. I just need, I'd like to take a short break to just meet with the court staff, Mr. Wayne, and our court officers just on the procedures that we'll use. As I told you at Sidebar, I've never done a view in a bench trial. It's not something that we typically do, but I'm all for it. I want to talk with my staff for a few, not my staff, the staff, for a few moments, so that I can come back and we can perhaps get some planning done as well. Okay, so let's just take even a 5-minute break, and Mr. Wayne and our chief and our assistant chief, if I can talk with you for a moment.
So have they rested? Or
I don't know. Go back, make sure we didn't miss anything.
Yeah, that's what I want. You're going to tell me that was their last witness? I mean,
that is ending with a thud.
You're supposed to end, with a explosion.
Yeah. That is definitely ending on a thud, not a high note.
On a low note.
Go there with an open mind, and
Thank you.
We'll treat it at. Here's the thing, Commonwealth.
After the case.
And
we'll kind of for them.
Is he still talking about the? All right. So this.
We were discussing. Why don't you give me an update on the potential for a view?
So we don't know. They did not rest out loud.
Right.
That's our.
So
a lot of people in the chat saying the state rested, but we didn't hear that.
Yeah, can you go back to just when the last witness got off the witness stand?
Tomorrow, look at going by the house is the north end.
Nothing.
All right, you may step down.
Thank you.
May we approach?
Yes.
Ask for the approach.
Well, you can start walking over.
Quiet, please. We are still on the record.
Did I just hear Commonwealth rests?
I don't think so.
I just heard something, so let's try. I don't know.
Thank you.
May we approach?
Yes. Just give me one moment. Well, you can start walking over.
Quiet, please. We are still on the record.
Right there. Just that statement right there. I don't know.
I didn't hear it. Are you guys hearing it? I'm not hearing it. Let's see. You mean you're not saying the bailiff, right? I mean, the bailiff's like keep.
All right, you may step down.
Thank you.
May we approach?
Yes. Just give me one moment. Well, you can start walking over.
Quiet, please. We are still on the record.
Yeah, I'm not sure.
Nothing.
That was quiet, please. We are still on the record.
And if they had said the Commonwealth rests, then wouldn't the judge be saying, Bradl will
Do you have an argument?
say, I want to be heard on a directed verdict.
Yep.
Instead they're going to, but they're at the same time, they're moving to the defense case, with a view. I think the view is a good idea. I don't know what you think, even though it's a bench trial, because it's one thing to see stuff in pictures.
Yeah.
But when you're in that tiny room, that's going to look a lot different, I think, to the judge, when they're in that room, because, Noonan's testifying, well, no, she wasn't arm's length, she was 15 feet away. I mean, the room's not going to look like it did then because someone else is living there. But I think, you know, when you see the size of the room, I mean, I think as a lawyer, I was in a case where the judge wanted a view. It was in a child abuse case. And it had something to do with the structure inside the room about whether the child fell and fractured their skull or whether. But so I remember that we did a view. I also remember walking in there and there were cockroaches everywhere.
Oh,
La
Lord.
cucaracha.
That one stands in my mind because I was thinking, oh my gosh. But it was really important to do it, you know, because I was representing the child in that case, not the parent. But there really was a question about whether or not it was abuse or whether, you know, whether there had been some structure that kind of let go, causing the child to fall, that caused the fractured skull. So I do think a view, you know, in a situation like this can be really helpful. And
Judge, I'm going to block your face for 1 second. Joey Perry Golson had asked, Judge, do judges normally take attitudes like her referring to the last witness into account?
You know, it's the same as a jury. You have the right to make a determination about a witness based on their appearance, based on, like if it's the defendant, based on the emotion in their face, based on how they appear, and based on how they come across. So yes, you can consider it because you know, in your mind, you know, you're saying, okay, you know, this, you know, it's a combative attitude is what I would call it oftentimes, although it was mildly combative here. So when you look at the testimony of witnesses, there are things that you look at that are concerning, like, are they evasive? You know, like Justin was evasive, you know, like they would say, you know, why are you suspended? Well, they're reviewing the allegations and, you know, whatever decision. Well, that was evasive. You know, he was evasive. He just wouldn't say, you know, that it was a drug issue. So evasiveness is one concern because it affects the credibility of the witness and how the person is responding, because you saw that with Noonan a couple of times, you know, where he was, again, sort of becoming mildly combative. And this last witness, I mean, yes, and no, there wasn't swimming, and no to that question. You know, I mean, I call that a combative witness, you know, so I can give it whatever weight I want and say, you know, how credible do I think she is as soon as she was under cross-examination, she became combative.
Totally, you know? Demeanor changing, you know, as soon as that happened. And it's like with almost all the witnesses today, you saw that kind of switch. Like I thought Noonan was fairly combative with Bradl. You know, I mean, there were a couple, maybe not for the bulk of it, but there were certainly portions where he became combative. And when you have a judge that is really trying to weigh the credibility of people, and when they're trying to do those things that you were talking about yesterday, Judge, where they're trying to slip things in where if it had happened in front of a jury, we'd be up there on a motion for a mistrial. Just the thing, like it reeks of desperation. Like just the little things that they would say, you know, like how Noonan kept saying, yeah, and she was trying to kill me.
She
like
was, yeah, multiple times. And then, well, you know, maybe, you know, her anger, maybe she, you know, I thought maybe she was trying to kill Justin. Again, here you have a witness, you know, who's probably testified multiple times and should know how to testify. You know, if there's anything, you know, I would say, because I've heard countless police officers testify, some of them are really good, you know, no matter what they ask, you know, what the cross-examination, it's like, yes, sir, or no, sir, they don't deny it. And then you have others who do like what, you know, Officer Noonan did. You know, well, maybe she was trying to kill Justin. That, you know, that all that does is affect the credibility of the witness. And what is this judge going to decide? He has to make decisions about credibility. That's what has to be decided.
100%. 100%. All right, let's see what plays out here.
And Mr. Wayne, so let me just specify.
Matter all counsel and the defendant in person.
Okay, all right, so formally the motion for review is allowed. And I've met with our court officers and Mr. Wayne. So let me just specify who's going to be present. I'm going to assume that the three groups, the Commonwealth, the defense, and the court staff will go there in separate vehicles. So we need to just work out a time, and also, frankly, we have to work out. So let me back up. As for who goes inside the house to do the view, I'm sorry, all the folks in the back row, but perhaps it can be the four of you folks that Ms. Fitzsimmons, counsel, the trial counsel that have been here, Attorney Coakley, Attorney Bradl, and your paralegal. And I'm sorry, he said your Mr. Bradl has told me your name 6 times, and I just keep forgetting. But I don't mean any disrespect to the other attorneys, but I can already tell from the photographs it's a small house, and then on the court side, it will be myself, Mr. Wayne, our court monitor, if you'll be available, and some court officers. We'll take our own vehicle. I would ask that there be some kind of police escort for us so that we can do this quickly. And I'll also tell the media and our audience that this is not something that you folks will be this is not going, you will not, no one else will be inside that house or really within some yardage or footage of the house. I need to figure out what that would be, other than the folks that I've mentioned. Defense counsel, Ms. Fitzsimmons, the court staff, and the prosecutors. So I'd ask that the North Andover police, I'll give you some kind of a distance. I need to think about it, but that the North Andover police do what is you, or the state police do what they usually do during a view, which is typically shutting down the street or area to make sure that we can accommodate quick movement through there. All right, so that's where we're at. So I would just ask you folks to just work out a time. Let our either chief court officer, assistant chief court officer, Mr. Wayne know what the time that you want to go. And then what we'll do is, if we're in the middle of a witness's testimony, we'll just break, go on the view and come back. And again, the expectations at the view will be just like we do during a jury trial. The attorneys it will be on the record in the sense of it will be recorded. Is that not live, but recorded? What? It's a handout, right? So it won't be live, but it will be recorded. So there's a record of it. And the attorneys, like in a jury view, will just point out locations inside the home that you'd like me to, and even outside the home that you'd like me to make note of. All right. And we will go from there. Anything else?
We spoke, we anticipate Thursday morning. Just to give you a heads up, we need a little time to.
Oh, okay. All right. That makes sense. You anticipate Thursday morning. Okay. That's fine.
They anticipate resting tomorrow.
Okay. All right. And does that work for you folks? Okay. All right. Okay. That makes sense. So tomorrow, the Commonwealth may or may not have a witness. The defense, if the Commonwealth rests, I guess you could rest because it is the defense's motion for the view. So technically you could rest. If the Commonwealth rests in the morning, you'll be ready to proceed with your case.
Yes.
Okay. All right. All right. Excellent. And then we won't obviously get to closings until after the view. So if we're on target, end the evidence tomorrow, we can that can happen on Thursday. All right. All right. And one other thing. I've only done this once, this trial. I always have these false alarms when I'm ready to leave. And that is that, as I said, I'd like to get some agreement on the law that you want me to apply. All right, so, or at least maybe not agreement, consensus. All right, so you can do that in the way of proposed jury instructions, just a memo, whatever you want to do is fine. Okay, all right, thank you. We'll stand recess.
All right.
All right, so looks like we were getting a little bad intel here in chat. The Commonwealth has not rested officially.
Well, not everybody,
So-
I think, realized that afterwards. Yeah.
Well, I mean, but like, where are they getting that bad intel, and why are you spreading it? Like, let's wait for facts. Sounds like somebody pulled out their jump to conclusion map, and like, oh, let me jump on. So yeah.
There was a statement there you could hear in the background. It sounded, but when you watched it, you knew that it wasn't, because you have to stand up for the record. You know, you can't just go up to the bench and say we're resting. No, you have to be a counsel table. You have to say, you know, we're resting. And then that you know, brings about a whole bunch of other things. Someone asked a question there, asking and saying, can you please answer this? If evidence has been excluded prior, you know, like motions in limine, you know, if you've already excluded information before the trial and then you're doing a bench trial, do you consider the information that was previously excluded? Interesting, in this case, a lot of the stuff that was excluded, I think, was done by the other judge, right? I mean, a lot of the motions in limine. And then if you're the judge hearing the bench trial, you have to live with that. You know, it's like, you can't change it. You can't say, well, I would have decided that motion differently. And you can't consider evidence that's been excluded, because obviously that's not fair to the person who sought to exclude it. And in particular, the defendant, who has a Sixth Amendment right. Once that decision's been made by a judge and it hasn't been appealed, and that's where it stands, if evidence has been excluded, the judge is not going to consider it, you know, because it's simply not fair. It's already been argued.
Judge, let me ask you a question, and it's a difficult question to answer, but it's a question that I often ponder. When you're in a situation like that, when you've had pretrial rulings and you've excluded a piece of evidence, and say it does go to bench trial,
yeah,
you know that this piece of evidence is a human being. Put aside your duties as a jurist, as a judge. How hard is it for you to not only not take it into consideration, because I think that that's probably easier, but are you able to control subconsciously what you might be thinking about that particular piece of evidence that might be floating around in that brain of yours?
It's excluded, so you're not going to consider it, you know, because in the end, in cases that I had to make written findings of why I decided things and what evidence I relied on. So you couldn't actually say, hey, I relied on this. But if you're asking me, did I think about it? You know, I mean, generally, no. You know, in my world, oftentimes, you know, I would have had someone who made decisions on the temporary custody hearing and made certain findings, and then I'm doing the trial, or I did the pretrial and someone else is doing the trial. I mean, that did happen. And so a lot of times you were just sort of bound by whatever the motion in limine decisions were, unless someone asked you to, you know, formally went on the record and say, I'm asking you to reconsider, you know, file a motion for reconsideration. That's the only way you can do it. Someone files a motion for reconsideration and you make a different decision. But, you know, you know, if the evidence is out, the evidence is out, you know, and generally there's enough to consider without having to worry about what's already been out. And oftentimes, if the evidence is out, it's out because, you know, they want to bring something in that's a clear violation of the hearsay rule. It didn't fit into any exception. And so, you know, they would say, you know, we want to eliminate the testimony of the court investigator about this particular thing. Well, some of those things could be eliminated and some of them couldn't. And so, you know, after you're on the bench for a while, you kind of know, you know, like what can be, what's, you know, what a good decision is for eliminating things and and what's not, but you know, because if you heard the terrible motion, with the other judge where she turned it into a bail hearing, and it was a revocation. She turned it into a revocation
Unbelievable.
hearing. And then after turning it into a revocation hearing, what did she say about the email that they wanted to get in? They wanted to get the email from the probation officer that said, I watched her do the test and she, couldn't blow into it. It was clearly painful for her. And I find, my recommendation is that there's been no violation. And what did she say? I'm not letting that email in. It's hearsay. But in a revocation hearing, in Massachusetts, as long as the hearsay is reliable, and you can find how much more reliable can you get than a probation officer?
Right.
Hearsay is admissible, and so especially this was like a dangerousness hearing, revocation. In the initial dangerousness hearing, all hearsay is admissible. So then she's telling them, oh, that email, that's hearsay, she said, and then she looks to the prosecutor for help. She goes, do you want that email in? What do you say? And he's like, I'm not going to say, he wasn't going to say it's not admissible because he knows it was admissible, at least in a revocation hearing, even if you wanted to say not on the modification. And so what did he say? Well, Judge, the probation officer's right here in the courtroom. And so then he kind of backed her into a corner. And so she said, okay, do you have something to say? And then he gives this glowing report in favor of Kelsey Fitzsimmons. And what happens? She ends up blocking. She doesn't find his testimony credible. I mean, it's so shocking, which is, one of the reasons I decided to speak out on this case. I mean, I'm not doing a ton of trial analysis because I'm very obviously caught up in the child welfare, advocacy and things that I'm doing in that field. But I decided to speak up on this one again, because there's a sort of a sense of unfairness.
Yeah.
And that's what I saw in that. And I don't know if you were listening yesterday. She was so angry about the probation officer. She filed a complaint against the probation officer.
Unbelievable.
Formal complaint against him. He had to hire an attorney. This is all in the motion, was all in the motion to recuse. So, there's this whole sense of unfairness. And while I think this trial judge has been fair in so many ways, and that's, a good thing to say, the sense of unfairness comes out, as we have talked about all along, in how this was handled, how people allow civilians to show up at a, serving a lawful order. Not only show up, they didn't have to stay in the cars. You can come in the house, and it's interesting because, police know that probably one of the most dangerous things that can happen to a police officer is when you're serving a lawful order, particularly a restraining order, and I've said this, many times here, the notion that these civilians were not only allowed and not only be allowed into the house, there's a huge sense of unfairness because they already knew what he was saying about her. They already knew she was angry at him and concerned about him, and yet they did it. So, for me, a lot of this case is about the sense of unfairness that was taking place at the time of service, that has taken place in pretrial hearings and in a dangerousness hearing, how that will impact the judge. He's got to look straight at the elements, so it'll be interesting to hear who they're calling as a witness. But, I mean,
to go back to the point we made right when that witness got off the stand, I mean, if that is their last witness, what? That is not how you end a trial.
Right. We're all lawyers. I've been a lawyer. You've been a lawyer. You never end on a low note. I mean, ever. You never end on a low note. And so you want to make the most powerful thing, for people to remember when they walk up the stand. And I don't care if it's a judge or a jury, But, if that's like, I guess you could say to yourself, if that was their strongest, strongest witness for this case, then, it kind of says something about what the strength of the case is in terms of reasonable doubt. 'Cause that witness not only did nothing, as we said, but I thought that witness really hurt the prosecution. And, I think they did a good job on defense, oh, you're all there in the house, like, it's just unbelievable.
Frankly, after Noonan, I didn't see the relevance of anybody. The whole chain of custody thing, and like, I just didn't see what it was bringing to the table for a judge that's doing
Yeah.
a trial. It's like, frankly, they could have rested after Noonan because that's their case essentially.
Yeah, I think so. They have to have the ballistics expert that's required, because anytime you're having testimony about firearms, there are very basic things, that have to come in. So I did lots of firearms cases. We didn't necessarily always have a ballistics person in there because there's a firearms certification in Massachusetts that the gun is operable, operational. So, and he testified to that. So I suspect, they had to bring him in because maybe the defense said, no, we're not going to agree, to the certification. And so once you bring him in, you have to go through, every single aspect of it. And he's a Superior Court judge, so I'm sure he's heard testimony. I heard testimony about guns. I was saying to Ali earlier, I knew nothing about guns really when I got on the bench. And so, they would be talking about magazines and high capacity firearms, which is in a separate category. And I'm like, what?
Yeah, we're with you, Judge. We always have to ask Ian because he knows so much about it. Like, I'm not a gun guy, so I don't know much about him.
So, Judge, do you think it would be helpful to the judge in this bench trial for the defense to put on some kind of expert to explain that the gun should not be ending up under her left leg if she was holding it in the manner that Noonan described?
Yeah, I think that's sort of still open for, for some type of evidence, although I don't know what they're going to do. But, I think the placement of the gun and when people got in there, seems to be a relatively important factor, right? Where was it, and it was close to her. That tells you, of course, that she did have a gun, which is, again, why Officer Noonan was cleared and should be under the constitutional perspective of the way you have to look at it, because you can't look at it in hindsight. And, you have to consider all the factors. So I think that's reasonable. But as I've said countless times here, that doesn't mean that doesn't mean you can't find her not guilty. I absolutely think she could be found not guilty, depending on how the judge views the intent. But yeah, I think you raise a really important point. I'll be interested. Did you get the impression that did they say they were calling witnesses?
So the defense didn't. There was no mention, although in opening they made mention of what the judge would hear from Kelsey. So they at least made it seem as though they were calling Kelsey. And we heard the judge just now say, well, if the defense decides to rest, you still have your view because that's already been approved, even though that's the defense's case. So it sounds like he thinks it's open that maybe they could just rest, but I don't think there's been any specific, one way or the other for sure. But if and we did hear that it's expected to, the judge at least expects evidence to end tomorrow and closings to be on Thursday. But if you were sitting on the bench in this case, what would you be, or maybe not if you were sitting on the bench, but as a judge who has sat on bench trials, what are you hoping to hear from the defense's case, assuming that they're putting one on?
Well, I would be wondering whether or not they were going to rebut everything Noonan said by by putting Kelsey on the stand, and as you know, that's pretty risky. Although I don't know how much risk there would be, because I think what she would have to say is, she could actually clarify a lot of the things, that are out there. And she could also, I think, clarify, this whole other thing that seemed to be going on around her without her knowledge of, let's like sneak into the probe. Let's get all our friends together. To me, that whole party was like an affidavit party. Let's all gather up and let's put an affidavit together. I will tell you the shocking thing about that last witness's testimony, that she actually said that they were all there together. They weren't drinking and they weren't having a pool party. So they were all there together for what I call the affidavit party. And that's pretty alarming. And I don't know if the judge is picking up on all this stuff that was working against her. And why did it continue working against her even at the bail hearing? They made kinds of allegations in the recusal motion that that judge lived in North Andover, and there was talk of a lawsuit, and did she have some kind of other interest with their relationships that she had? Those were all kinds of things that they knew were going to be asked if the recusal motion went to a hearing. So, and of course, they weren't going to let that happen. But yeah, I mean, would I love to hear from her? Yes. Will they do it? That's certainly up to her. But in the end, I do think they did a very good job, as we have said, of saying, as Bob pointed out earlier, where's the animus towards Noonan? Where? I don't see any animus towards her. In fact, she was the guy that she trusted. Here, hold my baby, feed my baby, and hey, take this out of here. I mean, the way I don't know if he's seeing that, but my interpretation of that is she's saying, I have an intent here, and it's not to, it's not to assault him. I have an intent here, and the intent is I'm going to harm myself. So you need to get out of here. I do think they presented a good case. That what I think they need to do is, if they, in their argument to the judge, they really need to narrow in on that and hammer it. And I mean, over and over again, that this is, that this was a plan. There were a group of people. The police handled it poorly. They allowed civilians in there. They knew it was an escalated relationship. And yet, they have Justin there. And when did she become upset and shaking? She became upset and shaking by the Commonwealth's own case, right at the time she knew Justin was in there. This all tends to believe, more with her intent. Her intent was to harm herself and not to assault. And like you and I, and like I have said, totally different than whether or not they were right to clear him. I think they were, based on constitutional law. But as far as intent goes, I think they presented a pretty good case. I had a tendency to get lost in a lot of other questions. So that's what I would be wanting to hear, closing arguments, even though it's not evidence, piecing together everything that tended toward a belief that she had a different plan, and the plan wasn't to hurt this person that she liked, that she knew, that, had given her some nice advice in the past, about how to handle it, all of that kind of thing.
Babe, we're both muted somehow.
No, I can hear you, Allie.
Oh, I was muted. I was agreeing, Judge. I think that the things that you pointed out with respect to kind of corroborating her version of events is powerful. I mean, the fact that she was continually trying to get them out of the room.
Yeah, even Houston with a walk.
Yeah.
And somebody had said, oh, well, and I think I saw it over on X, and somebody was like, well, why didn't, if she wanted to unalive herself, why didn't she wait the 10 minutes till they left? Well, because they're taking the guns.
Right. I said the same thing. I don't think you were there. And then someone in chat was like, well, because they're going to take the guns. I was like, duh. Right.
Yeah. Right. That was her chance, so she needed She needed to get them out of that room because the gun was there. And the fact that she said the guns are in the basement, that goes equally to, I need a gun to, for self-harm, as opposed to, I need a gun to shoot someone, while there are 5 other police officers like steps away,
Right.
which, you know what I mean? So,
Yeah, no, I agree 100% that explanation resolved that lie. Because that lie, it was like, "Oh, wait, why'd she lie?" And then I agree, that explanation of, well, because she wanted to unalive herself and she had to do it before they secured the guns, explains that, and I doubt the judge will hold that as consciousness of guilt or pre-planning or intent.
yeah, no one's made a request for consciousness of guilt. They would have had to have done that already. And so, they would have had to actually have actually come and done that already, and they didn't do it. So, so that's good. Is that your young one?
Yeah, that's our 13-year-old, almost almost 14 now.
She's a beautiful girl.
Oh, thank you. Thank you. I appreciate that. All right, so we should expect to see there'll be some downtime when they're going to do the
Yep.
the
I
view.
couldn't tell if they were talking about doing it on Thursday potentially though.
Tomorrow, I think.
Yeah.
Yeah, because and that's why he got off the bench quickly. Because if it was going to be Thursday, then they would have arranged it tomorrow. But anytime as a judge you leave the courthouse, you have to have a court officer with you. That's the rule in Massachusetts. So every time I went to the mental health facility and did commitment hearings for kids that were going to be committed to a mental health facility, I had to have a court officer with me every single time. And same, there were times I had to go to the hospital to do blood transfusion hearings where you had a child born in the neonatal unit and the parents were Jehovah's Witnesses and wouldn't agree to a blood transfusion. And so the hospital would call and I'd go to the hospital to do a hearing on whether or not the child should have a blood transfusion, also with a court officer. So the reason he got off the bench and said, I need to get off the bench and talk to the court officers is because they have to contact the chief court officer for that court and say, can you afford to have a court officer out and going with us? So
yeah. And do you think, so it sounds like they would do it if the Commonwealth has one last witness and then maybe do the view before the defense's case in chief starts?
Or I think they're going to do the view whenever it works best for the court personnel, because, it's a security issue. I think they'll do it, whenever it's best, because this is in the Superior Court. Is it in Salem or Lawrence that they're
doing? Lawrence.
Yeah. So, because I think it was scheduled in Lawrence, but there are some things I thought that happened in Salem. Because I think that's true. So if it's in Lawrence, they still have to drive to North Andover. It's not that far, but it's not around the corner either. And so that means you're going to have personnel outside of the courthouse for a period of time. And then, the other thing is, they're going to call the local police to handle traffic in the area, which is, then we're talking about the North Andover police, unless they're going to use the Massachusetts State Police, but she doesn't live on a state highway. So,
and then, so Sleepless Sleuth had said, did both Houston and Noonan say that Kelsey handed them the car seat and both say they set it down? I cannot recall.
I think Houston just said she handed me something because he said, did she give you something and ask you to go downstairs? And he said, she didn't ask me to go downstairs. She just handed me something. And I don't recall him saying the car seat.
Well, he said that she said, Justin doesn't have a car seat. So she picked up the car seat and handed to him. And he said he didn't want to have something in his hands. So he put it down on the floor.
Houston? That was Houston that said that?
I'm pretty positive of that. But, who knows? It's like there's so much testimony. But he was late in the game. And so I think he said, I just didn't want to, have anything in my hands. But he's the one. Am I wrong where she said, the baby's crying, take the baby for a walk outside. He likes to look cars. So she was trying to get rid of him, and
Yeah.
she was trying to get rid of Noonan by saying, here's these books, bring it downstairs. I mean, so then you have two people that are talking to her before the shooting that she's trying to use everything she can to get them out. Look, Justin doesn't have a car seat. Get this car seat to him.
And Houston was very honest in his answer. He said, she said, so she was trying to get you to leave. And he said, in my opinion, that's what she was trying to do.
Yeah, even though he said he didn't go down, because that was the implication. Clearly
Right.
she's handing him stuff, thinking he's going to lug it downstairs because it's going.
But it begs the question with Sleepless Sleuth's comment is how in the hell, which we've all been asking, did Justin get his hands on the car seat if no one took it down?
Well, it might have been after, or it might have been that they got a car seat from the mother, from Kelsey's mother. It's hard to know how that all happened.
Well, I mean, we saw him walking out with it, and we didn't see Grandma walking in with it.
Interesting. Yeah. So good question.
When the sister and he walked out, the sister had the baby in her arms, and Justin had the car seat and a couple of other items in his hand.
Yeah, I will never, ever be able to reconcile, having civilians at something like that. I will never be able to reconcile that. And, I'll always think whatever happens to her, this case has been unfair. And even if she's convicted, I mean, the maximum sentence is 5 years in state prison or up to 2.5 years in jail. But under the sentencing guidelines, if there's no history, it's really a probation order. I think because the Superior Court, they created their own sentencing guidelines as they did. It's just like in Massachusetts, like your first drunk driving case, you're not, it's like you're going to do the program and you're going to be on probation for a year. I mean, that's the standard practice, and that's what everybody gets. Well, the Superior Court has its own sentencing structure. And I do believe that the sentencing structure, and I think they argued this in the motion for temporary orders in the Probate and Family Court, which is coming up April 2nd. So coming up very close. I think, that in their motion, they're saying, hey, we want visits and we want shared custody. And even if, our client is convicted under the sentencing guidelines, it calls for probation as a sentence. So she may never, even if she's convicted, may never serve a day in jail. So
yeah,
interesting to see.
Yeah. Well, Judge, as always, I'll be sending you an invite. So if you get some wiggle room tomorrow, just pop on in. And like I said, you come and go as you please. You can pop in and out. It's completely, we love having you.
Yes,
Your
we're honored to
insight
have you.
is so invaluable, so fascinating. I feel very privileged to have you hanging over here and really being able to pick your brain, especially because this is your jurisdiction. So it's wonderful to have you over here. So we're very thankful.
Thank you so much. Yeah, it's been a pleasure. I've really enjoyed talking with you guys and sort of breaking this down. And like I said yesterday, the chat's really interesting. People ask great questions, and they're all have very kind words, and so I really appreciate it. And and so if I have the opportunity tomorrow, I'm not even sure what's on my schedule tomorrow. I mean, because there'll be a time when they're doing the view, so I should be able to get in, and hopefully without technical problems, but I'll have to call my kid and say, remote in and like fix it.
I'll send you the invite as soon as we put the live, so you'll have it. And then just, like I said, if you can pop in and spend all day, that would be amazing. If you could pop in for 5 minutes, that would be amazing. Whatever you can do.
We'll take whatever we can get.
Whatever we can get.
Are fun to talk to, even though it's serious, and just a lot of really good comments and analysis. And sometimes it's just nice to go back and forth with people and
absolutely
just, chop it up into pieces. So hopefully I'll see you tomorrow, and thanks again for the invite. Really
thanks, Judge.
All right, thank you.
Thank
All
you.
right, bye. So we're gonna go through the chat, but before we do, we just want to say for anyone out there, don't leave yet. You're gonna get sent over, portaled over to our Afroman stream. We have Afroman's defense attorney and at least one juror. I think there's just one juror at this point. I've only sent the link to one juror, and that is coming up in 40.
No.
35 minutes.
5 p.m. 5 p.m. it starts.
Well, 5 p.m. Eastern time.
Are you serious?
Yes.
Oh, goodness. Oh my goodness. Hold on.
So yeah, it's 36 minutes from now.
Oh my goodness.
So
Are you sure? I thought
I'm positive.
You are?
I just looked at it again.
Oh my goodness. I thought we pushed it to 5 our time because we were
5 their time.
worried.
We pushed it to 5 their time, I'm certain.
Oh.
So I don't know where you left off on the chat. I know where I left off. So
I think we've thrown everything up so you can just like
not the stuff at the end.
Oh yeah.
So we had we got to read it. GB Packer fan says this judge is so good. If only more were like him and Carol in mass. Yes, agreed. And Bob Ross says, firearm nut here. Noonan said he heard a click when Kelsey tried firing. That means slide was cycled without magazine, not impossible, but very unlikely. And I know we saw their firearms expert said if there's not a round in the chamber and you pull, you're going to hear that click, and then you need to, redo it to put one in there. But yeah, thanks, Bob Ross. And Nancy says Kelsey's mom was at the house. Did she speak to her? I mean, that's a good question. I mean, we don't really know. And thanks, Aunt Sent. We put that up about tomorrow.
Yeah.
Bob Ross also said behind again, another witness testifying that he heard shouts before gunfire. Noonan said he fired first and was shouting during the second shot. Yeah, it's the timing is definitely a thing.
Yeah, the inconsistencies are a thing too.
Yep, and we touched on that.
All heard different things. What was yelled?
Shelley, thanks for your generosity. And yes, the lovely Carol did come back. I'm glad that everyone on Reddit is talking about this feed because of her perspective. Love it. Love it. Hopefully it gets more people in here. Iceman Cometh said, something I just thought of during this. If Kelsey said guns were in the basement, why did they let Justin go down there? A point that Judge Carol was making multiple times.
And Bob.
Well, yeah, I'm just,
for days.
Yes, Bob is all Bob. Yes, Bob too.
It doesn't have to be all Bob, but you could throw some Bob in there.
Yes, some Bob in there.
Yeah.
Shelley says, has the officer had a lobotomy? Yeah.
A bit of an aside, when you were pretending like the first time you ever heard the skunk in the jury box as being yesterday, blew my mind.
I know. I think I have heard it before.
I've said it a million times on lives.
I just, my perimenopause brain. Wow. I'm just, we always say you can't unring. I always say like you can't unring a bell. You can't unring a bell, but yeah, the skunk.
Like everybody says, but the skunk in the jury box
is much better. Yeah, that's much better.
Well, I agree.
Justin, you're a loser guy.
Loser.
If you're a lady in mass, get out now. Yeah, scary. And then I think this might be the last one. There was a couple new members. I don't know if you got or not though. That Tony had said, Massachusetts State Police is the Bermuda Triangle of missing and incomplete police reports. Oh, yeah, for sure.
Yeah, and like the epicenter of shitty police investigations.
Right. Dana, member for 12 months. Thanks for your continued support. Thanks for the amazing coverage. Appreciate it. We got Legal E Blonde, new member.
Blonde. Oh, family hug. Welcome.
Yes, welcome. Patty, thanks for your continued support for a month.
Thanks, Patty. I definitely gave Muzzy Bear a family hug this morning.
Okay. And then John said, would you like to object, Mr. Lally? Yeah, right. And I think that's
objection.
I think that's it. I definitely put up Trooper Paul vibes.
All right. Now that I'm panicked now. Now we've got a half an hour.
All right. We got to get
ready. Make sure you're coming to check out David Osborne Jr. and a juror who is going to remain anonymous. So Allie, I hope you're figuring out all the shit.
Yes, she was working on, or he and she were working on on disguising voice. So okay. All right. So and we're gonna keep the camera off. So that's good for
that's easy.
That's easy.
The camera thing's easy. All right, but it's going to be a great live, super important case. It was just such it was a fun case for as important as it was.
Yes.
Like ultimately. So
thank you all. And what do you say, babe?
Hey, we love you guys. Thank you, mods. Thank you guys for being here. Thank you for your generosity, because without you guys, I would literally just be an old man
Sitting around talking to his wife.